Thank you, Pastor. The House will come to order. Please join Micaiah Anderson in the Pledge of Allegiance this morning. She is homeschooled, and she's from Arapahoe, Colorado, and guest of Representative Rod Pelton. Welcome.
Please join me in saying the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Mr. Shebel, please call the roll.
Representatives Amabile, Bacon, Baisley, Benavidez, Burnett. Representative Burnett. Burnett's excused. Byrd, Bockenfeld. Representative Bockenfeld is excused. Basenecker, Bradfield. Representative Bradfield is excused. Caraveo, Carver, Catlin, Cutter, Doherty, Duran, Esgar, Exum, Froelich, Geithner. Rep. Geithner's excused. Gonzalez Gutierrez. Gonzalez Gutierrez is here. Gray.
Here.
Hanks. Herod. Holtorf. Hooten. Judah. Kennedy. Representative Kennedy. Kip. No Kip. Rep. Kip is excused. Larson. Representative Larson is excused. Lindsay. Lantine. Rep. Lantine is excused. Luck. Lynch. McCluskey, McCormick, McKean, McLaughlin, Michelson, Janae, Mullica. Representative Mullica is excused. Neville, Ortiz. Rep. Ortiz is excused. Pelton, Pico, Ransom, Rich, Ricks,
Here.
Roberts, Sandridge,
Here.
Sirota. Representative Sirota is excused. Snyder, Soper. Representative Soper is excused. Sullivan, Tipper, Titone, Valdez A, Valdez D, Van Beber, Van Winkle, Weissman, Williams, Representative Williams is excused. Woodrow,
Here.
Woog, Young, Representative Young. Rep. Young's excused. And Mr. Speaker.
With 55 present, 10 excused, we barely have a quorum. Representative Bacon.
Monday, April. I move that the Journal of Monday, April 25th, be approved, as amended by the Chief Clerk, be approved.
As corrected.
As corrected.
All right. Members, you have heard the motion that the journal be approved as corrected by the Chief Clerk. All those in favor say aye.
Aye.
That's pretty good. All those opposed, no. That was a beautiful no, but the ayes clearly have it. The motion's approved. Announcements and introductions. Representative Weissman.
Thank you, Mr. Speaker. Good morning, judiciary members and others interested. We have 4 bills on our calendar today. Senate Bill 212, House Bill 1386, Senate Bill 99, and House Bill 1383. We are meeting at 1:30 in room 107. That is our room downstairs. 1:30, 107. See you there.
Representative Pelton.
Thank you, Mr. Speaker. You've already been introduced to my pastor, Micah Anderson, and his daughter, Micaiah, but his wife, Nicole, and their son, Nikolai, are also here sitting at the side. So,
Welcome.
Welcome to the House. Hope you have a wonderful day. Representative Michelson Janae.
Thank you, Mr. Speaker. Public and Behavioral Health and Human Services, listen up. We have 1, 2, 3, 4, 5, 6, 7 innings tonight. So you might want to plan your dinner for third inning stretch. That'll be at 1:30 in room 112.
Representative Exum.
Thank you, Mr. Speaker. House Transportation and Local Government, we have a busy afternoon. The order has changed, so listen up. House Bill 1394, Majority Leader Escar and Representative Roberts will go first. House Bill 1378, Representative Judah and Representative Sullivan will go second. I will go third with Representative Woodrow, House Bill 1377. Representative Tatone and Representative Bradfield will go fourth with House Bill 1387. Representative Valdez A will go fifth with House Bill 1388. And Representative Wiseman and Representative Basenecker will go last with House Bill 1363. And we will stay in that order. LSBA.
Thank you, Representative Exum. Representative McLaughlin.
Good morning, Mr. Speaker.
Good morning, Representative
So,
McLaughlin.
Education Committee. The calendar is there, but we're never sure quite how accurate it is. But here's the numbers of what we're going to be hearing tomorrow. Stay tuned. We might add one or two. 1395, 1396, 171, 165, and 192. That'll be tomorrow at 1:30 instead of Thursday. Thank you.
Majority Leader Escar and Representative Duran.
Thank you, Mr. Speaker. Members, pay attention. This is something you're going to want to know about tomorrow. If you bring in $5 tomorrow to go to CCASA, donation to CCASA, you get to wear denim. I know sometimes y'all want a casual day where you get to wear jeans. You need to pay the $5 to do it. There'll be a box on my desk and a box at the back of the room with the sergeants. Tomorrow morning, $5. We'll have a resolution to talk about the meaning of it and why we do it every year. But the $5 donation will go to CCASA. You're also welcome to donate more than $5. But if you don't donate at least $5, don't come in jeans.
Representative Duran.
Thank you, Mr. Chair. $5. Did you hear that? $5 to wear jeans tomorrow. Tomorrow. But we'll take more. Whatever you got, dig deep. We'll see you tomorrow.
Thank you.
Thanks to both of you. Assistant Majority Leader Gonzalez Gutierrez.
Thank you, Mr. Speaker. Members, we have some very important people here today with us joining on the floor. We have kiddos from between 3rd and 5th graders from the Highlands Micro School, which is in House District 4. So please welcome them to the Capitol.
Representative Holtorf.
Thank you, Mr. Speaker. I also have some guests here visiting over on the right-hand side of the chamber. My right, your left. I'd like to introduce Bob Baca, if you'd stand up, sir, from the People's Church of Santa Fe, from Santa Fe, New Mexico, and also Dan File from the First Baptist Church of Lake City, and also for 18 years he's been providing the ministry to the state capitol with the Capitol Commission. Let's give them a round of applause. Now, if you'll allow me, Mr. Speaker, I want to share one word
Sure, go
that
ahead.
was shared by these fine gentlemen this morning in the Bible study that we have down in the basement every Tuesday in room 109. And what these fine gentlemen said was the following: that many of the problems that we find outside of the Capitol cannot be solved within the walls of this Capitol. There are things that we must do, but from man to man, woman to woman, to fix the problems of humanity must be done with the love of Christ and also the hand of God. So thank you, gentlemen, for coming, and thank you for the good word that you share with all of us, regardless of our religious affiliation or association. Praise be to God.
Further announcements and introductions. Majority Leader Eskar.
Thank you, Mr. Speaker. In case some of you weren't paying attention, tomorrow, Denim Day, $5.
Any other announcements or introductions? Seeing none, let's do reports of committees of reference.
Committee on Appropriations, after consideration on the merits, the committee recommends the following: House Bill 1063 as amended, Senate Bill 21 as amended, be referred to the Committee on Legislative Counsel with favorable recommendation. House Bill 1077 as amended, 1254 as amended, 1355 as amended, 1359 as amended, 1361, 1390 as amended, Senate Bill 1, 2 as amended, 8 as amended, 11, 127, 130 as amended, 146, 148, 153, 158. Be referred to the Committee of the Whole with favorable recommendation. Committee on Finance, after consideration on the merits, the committee recommends the following: House Bill 1345, 1392 be referred favorably to the Committee on Appropriations. House Bill 1357 be postponed indefinitely.
Thank you, Mr. Schiebel. Let's do introduction of bills.
House Bill 1401 by Representative Mullica, also Senator Moreno, concerning the preparedness of health facilities to meet patient needs.
House Bill 1401 will be assigned to the Committee on Health and Insurance.
House Bill 1402 by Representative Garnett, concerning measures to promote responsible gaming and in connection therewith creating the Responsible Gaming Grant Program and establishing fund mechanisms to support the grant program.
House Bill 1402 will be assigned to the Committee on Finance.
Senate Bill 182 by Senators Hansen and Quorum, also Representatives Doherty and Young, concerning measures to address economic mobility for Coloradans and in connection therewith creating the Economic Mobility Grant Program within the Department of Public Health and Environment and authorizing the Department of Higher Education to contract for the use of an online platform to assist students with accessing public benefits and making an appropriation.
Senate Bill 182 will be assigned to the Committee on Finance. Majority Leader Eskar. Representative Montine.
Thank you, Mr. Speaker. As you all know, the Health and Insurance Committee is meeting tomorrow at 1:30, and we are adding House Bill 1401 to our calendar. Thank you.
Any further announcements or introductions? Seeing none, Majority Leader Eskar.
Thank you, Mr. Speaker. I move to proceed out of order for immediate consideration of third reading of bills.
Seeing no objection, we'll proceed out of order for immediate consideration of third reading of bills. Mr. Shebel, please read the title of the House Bill 1285.
House Bill 1285 by Representatives Neville and Esgar, also Senator Moreno and Cook, concerning a prohibition against a hospital taking certain debt collection actions against a patient if the hospital is not in compliance with hospital price transparency laws.
Majority Leader Esgar.
Thank you, Mr. Speaker. I move House Bill 1285 on third reading, final passage.
Majority Leader Esgar.
But first, I must ask permission for a third reading amendment.
I think you have to move it. Do you have to move that? Majority Leader Esgar.
What?
I think, isn't it a motion? It's a motion. Yeah, all right.
Thank you, Mr. Speaker. I move Amendment L016 and ask that it be displayed. And members, it was on goldenrod on your desks.
I don't think we can't move the amendment until we grant permission. I think it's, I was just saying
the motion, so I made the motion.
Sorry, a motion for permission. Sorry.
I move for permission.
Yes.
For a third reading amendment.
Very
Holy
good.
cow.
That is properly moved. Minority Leader McKean.
Thank you, Mr. Speaker. Folks, what you saw here was hubris. It was just the assumption that the majority leader is just like, I'm going to get permission, and so I just want to, I would say no. I would say this is a moment where you just say, no, we're not going to put up with that.
I'll remember that.
All right. Properly moved. Any further discussion? Majority Leader Esgar.
Thank you, Mr. Speaker. Members, in our second reading amendment, we put into a bill a definition of collection agency that largely mirrors other parts of statute to just ensure clarity in this bill for the courts and other interested parties. We did not, however, stipulate what a collection agency does not include, which was our intention all along, as we did in our other definitions in the bill, which is, again, consistent with other parts of statute we pulled from here, and is thus truly technical in nature. We ask for an aye vote.
Representative Neville.
Thank you, Mr. Speaker. And members, I'll just say this is an extremely rare event, not only because it's extremely rare that I have a bill that actually makes it to third reading, but I've also never actually had a third reading technical amendment. So I beg for you for permission to run this amendment.
Is there any further discussion on permission? Seeing none, the question before us is to grant permission for a third reading amendment on House Bill 1285. Mr. Shebel, please open the machine and members, please proceed to vote. Representative Soper, how do you vote?
Yes.
Representative Soper votes yes. Representative Sandridge, how do you vote?
Yes.
Representative Sandridge votes yes. Representative Ricks, how do you vote?
Yes.
Representative Ricks votes yes. Representative Woodrow, how do you vote?
Yes.
Representative Woodrow votes yes. Representative Gray, how do you vote?
Yes.
Representative Gray votes yes. Representative Woodrow, let's just double check. How do you vote?
Yes.
Okay, very good. Please close the machine. With 62 aye votes, 2 no votes, and 1 excuse, permission to offer a third reading amendment on House Bill 1285 is granted. Majority Leader Esgar. Yeah.
Thank you, Mr. Speaker. I move Amendment L016 to House Bill 1285 and ask for a yes vote.
It has been properly moved. Is there any further discussion on L016? Seeing none, the question before us is the adoption of L016 to House Bill 1285. Mr. Shebel, please open the machine and members, please proceed to vote. Representative Soper, how do you vote?
Yes.
Representative Soper votes yes. Representative Sandridge, how do you vote?
Yes.
Representative Sandridge votes yes. Representative Woodrow, how do you vote?
Yes.
Representative Woodrow votes yes. Representative Ricks, how do you vote?
Yes.
Representative Ricks votes yes. Representative Gray, how do you vote?
Yes.
Representative Gray votes yes. McKean and Kellen. Please close the machine. With 64 aye votes, 0 no votes, and 1 excused, L016 is adopted to House Bill 1285. Majority Leader Esgar.
Thank you, Mr. Speaker. I move House Bill 1285 as amended on third reading, final passage.
The question before us is the adoption of House Bill 1285 as amended on third reading and final passage. Seeing no further discussion, Mr. Shebel, please open the machine and members please proceed to vote. Representative Soper, how do you vote?
Yes.
Representative Soper votes yes. Representative Sandridge, how do you vote?
Yes.
Representative Sandridge votes yes. Representative Woodrow, how do you vote?
Yes.
Representative Woodrow votes yes. Representative Ricks, how do you vote?
Yes.
Representative Ricks votes yes. Representative Gray, how do you vote?
Yes.
Representative Gray votes yes. Please close the machine. With 63 aye votes, 1 no vote, and 1 excused, House Bill 1285 is adopted. Co-sponsors. Please close the machine. Majority Leader Escar.
Thank you, Mr. Speaker. I move to lay over Senate Bill 9 until tomorrow, April 27th.
Seeing no objection, Senate Bill 9 will be laid over 1 day. Mr. Shebel, please read the title of Senate Bill 167.
Senate Bill 167 by Senator Janal, also Representative Duran, concerning removing the exemption for greyhound breeders from the Pet Animal Care and Facilities Act.
Majority Leader Escar.
Thank you, Mr. Speaker. I move Senate Bill 167 on third reading, final passage.
Question before us is the adoption of Senate Bill 167 on third reading and final passage. Mr. Shebel, please, see no further discussion. Mr. Shebel, please open the machine and members please proceed to vote. Representative Soper, how do you vote?
No.
Representative Soper votes no. Representative Sandridge, how do you vote?
No.
Representative Sandridge votes no. Representative Woodrow, how do you vote?
Yes.
Representative Sandridge votes yes. Representative Ricks, how do you vote?
Yes.
Representative Ricks votes yes. Representative Gray, how do you vote?
Yes, and you announced Woodrow's vote as Sandridge, so we probably should correct that. True.
Heard it.
Representative Gray votes yes. Please close the machine. With 55 aye votes, 9 no votes, and 1 excuse, Senate Bill 165 is adopted. Co-sponsors. Please close the machine. Mr. Shebel, please read the title of Senate Bill 58.
Senate Bill 58 by Senator Simpson, also Representative McCormick, concerning the creation of a peer health assistance program for dental hygienists.
Majority Leader Escar.
Thank you, Mr. Speaker. I move Senate Bill 58 on third reading, final passage.
The question before us is the adoption of Senate Bill 58 on third reading and final passage. Seeing no further discussion, Mr. Shebel, please open the machine and members please proceed to vote. Representative Soper, how do you vote?
No.
Representative Soper votes no. Representative Sandridge, how do you vote?
No.
Representative Sandridge votes no. Representative Woodrow, how do you vote?
Yes.
Representative Woodrow votes yes. Representative Ricks, how do you vote? Representative Ricks, how do you vote? Representative Gray, how do you vote?
Yes.
Representative Gray votes yes. Representative Ricks, how do you vote? Representative Ricks is excused. Please close the machine. With 39 aye votes, 24 no votes, and 2 excused, Senate Bill 58 is adopted. Co-sponsors. Please close the machine. Mr. Shebel, please read the title to Senate Bill 164.
Senate Bill 164 by Senators Enzinger and Woodward, also Representatives Woodrow and Lynch, concerning the substitution of the word treasurers in place of the word assessors in the statutory provision requiring disclosure of property tax information for purchasers of newly constructed residences within the boundaries of a metropolitan district.
Majority Leader Escar.
Thank you, Mr. Speaker. I move Senate Bill 164 on third reading, final passage.
The question before us is the adoption of Senate Bill 164 on third reading and final passage. Seeing no further discussion, Mr. Shebel, please open the machine and members please proceed to vote. Representative Sandridge, how do you vote?
Yes.
Representative Sandridge votes yes. Representative Woodrow, how do you vote?
Yes.
Representative Woodrow votes yes. Representative Ricks, how do you vote?
Yes.
Representative Ricks votes yes. Representative Gray, how do you vote?
Yes.
Representative Gray votes yes. Please close the machine. With 64 aye votes, 0 no votes, and 1 excuse, Senate Bill 164 is adopted. Co-sponsors. Please close the machine. Mr. Shebel, please read the title of Senate Bill 79.
Senate Bill 79 by Senators Colker and Janal, also Representatives Young and McLaughlin, concerning required dementia training for direct care staff of specified facilities that provide service to clients living with dementia.
Majority Leader Escar.
Thank you, Mr. Speaker. I move Senate Bill 79 on third reading, final passage.
The question before us is the adoption of Senate Bill 79 on third reading and final passage. See no further discussion. Mr. Shebel, please open the machine. The members, please proceed to vote. Representative Sandridge, how do you vote?
No.
Representative Sandridge votes no. Representative Woodrow, how do you vote?
Yes.
Representative Woodrow votes yes. Representative Ricks, how do you vote?
Yes.
Representative Ricks votes yes. Representative Gray, how do you vote?
Yes.
Representative Gray votes yes. Please close the machine. With 42 aye votes, 22 no votes, and 1 excuse, Senate Bill 79 is adopted. Co-sponsors. Please close the machine. Mr. Shebel, please read the title of Senate Bill 110.
Senate Bill 110 by Senators Sonnenberg and Colker, also Representative Pelton, concerning requirement that a wind-powered energy generation facility be equipped with light mitigating technology.
Majority Leader Escar.
Thank you, Mr. Speaker. I move Senate Bill 110 on third reading, final passage.
The question before us is the adoption of Senate Bill 110 on third reading and final passage. See no further discussion. Mr. Shebel, please open the machine, and members, please proceed to vote. Representative Sandridge, how do you vote?
No.
Representative Sandridge votes no. Representative Woodrow, how do you vote?
Yes.
Representative Woodrow votes yes. Representative Gray, how do you vote?
Yes.
Representative Gray votes yes. Please close the machine. With 61 aye votes, 3 no votes, and 1 excuse, Senate Bill 110 is adopted. Co-sponsors. Please close the machine. Mr. Shebel, please read the title of Senate Bill 156.
Senate Bill 156 by Senators Colker and Fenberg, also Representatives Amabile and Young, concerning placing limitations on prepaid inpatient health plans and in connection therewith, removing prior authorization for outpatient psychotherapy and limiting when a prepaid inpatient health plan can retroactively recover provider payments.
Majority Leader Escar.
Thank you, Mr. Speaker. I move Senate Bill 156 on third reading, final passage.
The question before us is the adoption of Senate Bill 156.
This is Matt. Was the previous bill's results announced? Robin, I'm sorry. I hate to be the guy who keeps doing this, but I don't think you announced the results of the vote. I think we closed the machine and went to the majority leader.
I think everything's fine, Representative Gray. The question before us is the adoption of Senate Bill 156 on third reading and final passage. See no further discussion. Mr. Shebel, please open the machine, and members, please proceed to vote. Representative Sandridge, how do you vote?
No.
Representative Sandridge votes no. Representative Woodrow, how do you vote?
Yes.
Representative Woodrow votes yes. Representative Gray, how do you vote?
Yes.
Representative Gray votes yes. Please close the machine. With 60 aye votes, 4 no votes, and 1 excuse, Senate Bill 156 is adopted. Co-sponsors. Please close the machine. Majority Leader Escar.
Thank you, Mr. Speaker. I move to proceed out of order for immediate consideration of special orders.
Seeing no objection, we'll proceed out of orders for immediate consideration of special orders. Majority Leader Escar.
Thank you, Mr. Speaker. I move the following bills be made special orders today at 9:35 a.m. House Bill 1012, House Bill 1242, House Bill 1365, House Bill 1348, House Bill 1260, House Bill 1077, House Bill 1390, House Bill 1254, House Bill 1359, House Bill 1361, Senate Bill 184, Senate Bill 194, Senate Bill 162, Senate Bill 169, Senate Bill 174, Senate Bill 2, Senate Bill 8, Senate Bill 11, Senate Bill 127, Senate Bill 130, Senate Bill 146, Senate Bill 1, Senate Bill 148, Senate Bill 158.
Seeing no objection, the bills laid out by the Majority Leader today, Tuesday, April 26th at 9:35 a.m. will be made special orders. Representative Snyder. Members, you have heard the motion. Seeing no objection, Representative Snyder will take the chair.
The committee will come to order.
With your unanimous consent, the bills will be read by title unless there is a request for reading a bill at length. Floor amendments will be shown on the screen and on your iPads. Bills will be laid over upon motion of the majority leader, and the coat rule is relaxed. Madam Majority Leader.
Thank you, Mr. Speaker. I move to lay over House Bill 1012, one bill.
You've heard the motion. All those in favor of laying over the bill for one, please. It'll be laid over by one bill. Thank you.
Okay, we're good.
Mr. Schiebel.
I'll move the bill in the committee report so we can talk about the...
Please read the title, the House Bill 1242.
House Bill 1242 by Representatives Kipp and Exum, also Senators Janal and Heisey, concerning the regulation of structures that are manufactured at a location that is not at the site where the structure is occupied.
Representative Exum.
Thank you, Mr. Chair. Can I say that it's just an honor to serve with you?
And an honor to serve with you, sir.
Thank you. Mr. Chair, I move House Bill 1242, the Appropriations Committee report, and the Transportation and Local Government Committee report.
And Finance?
You go to Finance?
And Finance.
And Finance.
Great. To the Appropriations Committee report. Representative Kipp.
Thank you, Mr. Chair. In appropriations, they appropriated money so that we can begin implementation of the bill.
Great. Is there any further discussion? All those in favor of the appropriation report say aye.
Aye.
All those no. Appropriation report is approved. To the Finance Committee report. Representative Kipp.
Thank you, Mr. Chair. In Finance, we just made a couple of amendments to fix some stuff that we'd missed in the initial amendments in the first committee in Transportation Local Government.
Great.
Don't you remember?
Is there any further discussion? All those in favor of the Finance report, please say aye. All those no. The Finance report is approved. To the Transportation Committee report, Representative Kipp.
Thank you, Mr. Chair. So I will just say I'm in the Transportation and Local Government Committee. For a tiny bill, it was a really big bill, so we kept working on it, and we did make some additional amendments to that are basically technical in nature, just to make sure that we were getting everything right.
Great. Is there any further discussion? All those in favor of the Transportation Committee report, say aye.
Aye.
All those opposed? Transportation Committee report is approved. To the bill, Representative Exum.
Thank you, Mr. Chair. Members, the affordable housing crisis in Colorado is forcing many people to find alternatives apart from home ownership and apartment renting, and many people are discovering the benefits of tiny homes. Some people are building these tiny homes themselves. Other people are buying them from manufacturers. This bill, House Bill 1242, affects only those companies which build tiny homes for sale in Colorado by adding tiny homes to the list of structures which can be regulated by the State Board of Housing within DOLA. If someone is building their own tiny home on their property or hiring someone else to build a tiny home for them on their own property, then they are not subject to this bill. The bill allows the State Housing Board, in consultation with representatives from tiny home industry, to adopt rules, establish standards for tiny homes which cover the manufacture, assembly, installation of tiny homes, to set uniform foundation construction standards for factory-built structures and tiny homes in areas of the state where no standard exists. And I will pass it over to my co-prime.
Representative Kipp.
Thank you, Mr. Chair. So, folks, this bill was brought to me by my county commissioners, and it turns out I learned something I didn't know, that if you have a tiny home on a temporary foundation, it is governed in the same way in Colorado as recreational vehicles are right now, which means that you're not technically allowed to live in them for more than 31 days straight. So
we know that people are doing this. People are doing this with RVs too, but that's another matter. Those were not intended to be lived in full-time, but tiny homes are intended to be lived in on a full-time basis. So what we are trying to do in this statute is basically follow along with the mobile home statutes we have so that people can use tiny homes that are on temporary foundations as a form of housing. And we know we have an affordable housing crisis in Colorado, so this is just, when we talk all of the above solutions, this is one of those all of the above solutions. For people who a tiny home is the right fit, we want them to be able to live in one. So I ask for a yes vote on this bill.
Sponsors, would you like to move the bill? Representative Kipp.
I move HB 22-1242.
Great. That's a good motion. Is there any further discussion? Representative Hanks.
Thank you, Mr. Chair. I was looking at this, and I think the public needs to hear it at length. So accordingly, I would ask that the bill be read at length.
Request has been made for the bill to be read at length. Hey, Robin, what do I have to do besides that? That's what I thought. Just. Yeah.
Second regular session, 73rd General Assembly, State of Colorado, introduced. LLS No. 22 to 415.01 Jerry Payne X 2157 House Bill 22 to 1242. House Committees, Senate Committees, Transportation and Local Government. A bill for an act. 101 concerning the regulation of structures that are 102 manufactured at a location that is not at the site 103 where the structure is occupied. Bill summary.
40.
Note, this summary applies to this bill as introduced and does not reflect any amendments that may be subsequently adopted. If this bill passes third reading in the House of Introduction, a bill summary that applies to the re-engrossed version of this bill will be available at http://leg.colorado.gov. Current law regulates the manufacturers, sellers, and installers of manufactured homes. This regulation includes requirements for the installation of manufactured homes, contract and disclosure requirements, and the registration, escrow, reimbursement, bonding, and inspections of the manufacturers, installers, and sellers. In addition, the State Housing, House Sponsorship KIP and Exum, Senate Sponsorship Ginal and Heisey. Shading denotes House Amendment. Double underlining denotes Senate Amendment. Capital letters or bold and italic numbers indicate new material to be added to existing statute. Dashes through the words indicate deletions from existing statute. Board sets standards for the proper manufacture and installation of manufactured homes. The board consults with an advisory committee when promulgating rules. The bill adds tiny homes, which are typically manufactured, to this regulation on substantially similar terms. This includes adding 2 representatives of the tiny home industry to the advisory committee. The board is given the duty to regulate foundations for manufactured homes and factory-built structures where no construction standards otherwise exist. In addition to adding tiny homes to these provisions, the bill addresses tiny home regulation in the following manner. The board shall promulgate rules establishing specific standards for tiny homes. When the national or international standard is created, the board may use that standard. The board may modify these standards as necessary. The board shall establish standards for connecting a tiny home to utilities, including water, sewer, natural gas, and electricity. A local government may require the inspection of a tiny home manufactured before July 1, 2023, if the tiny home is not manufactured in accordance with the board's standards. A state electrical inspector or a local government may approve the connection of a tiny home for electric utility service if the tiny home is in compliance with applicable codes and standards for connection for electric utility service, and a state plumbing inspector or a local government may approve the connection of a tiny home for water, gas, or sewer utility service if the tiny home is in compliance with applicable codes and standards for connection for water, gas, or sewer utility service. If a tiny home is approved for connection to utilities through the process described above, the tiny home may be connected to the appropriate utilities. Current law governing the connection to each utility is amended to avoid conflicts with the process established in the bill. Selling or installing a tiny home without complying with the bill is declared a deceptive trade practice, which subjects a violator to damages in a lawsuit, a Class 1 misdemeanor, and civil penalties of up to $20,000 per violation, up to $10,000 for violating a court order or injunction, and up to $50,000 per violation if the victim is an elderly person. Current law regulates mobile home parks, including notice requirements, lease termination limits and requirements, security deposit. -2 HB 22-1242. Regulations, entry fee prohibitions, antitrust prohibitions, selling fee prohibitions, kickback prohibitions, retaliation prohibitions, regulation of how and if park rules are established, a right of first refusal when the owner wants to sell the mobile home park, a peaceful enjoyment right, and remedy provisions. The bill includes tiny homes under these provisions. Current law exempts manufactured homes from sales and use tax. The bill adds tiny homes to this exemption. 1. Be it enacted by the General Assembly of the State of Colorado, 2 Section 1. In Colorado Revised Statutes, 2432-3301, Amend 3, 1, Introductory Portion, 1B, 1C, 1D, 1E, 2B, 2C, 2D, 4 and 3, and add 1F and 2E, as follows, 52432-3301. Legislative Declaration. 1. The General Assembly 6 hereby finds, determines, and declares that mobile homes, manufactured 7 housing, and factory-built housing structures are important and 8 effective ways to meet Colorado's affordable housing needs. The General 9 Assembly further finds and declares that, because of the housing crisis in 10 Colorado, there is a need to promote the affordability and accessibility of 11 new manufactured homes and factory-built housing structures. The 12 General Assembly encourages local governments to enact ordinances and 13 rules that effectively treat factory-built housing structures certified 14 through the state program and manufactured housing certified through the 15 federal program, the same as site-built homes. The General Assembly 16 further finds, determines, and declares that 17b, the comprehensive regulation of the installation of mobile 18 homes, manufactured homes, or tiny homes to ensure safety, 19 affordability, efficiency, and performance is a matter of statewide and 20 local concern. 21c, the protection of Colorado consumers who purchase. -3 HB 22-1242. 1. Manufactured homes or tiny homes from fraud and other unfair business 2 practices is a matter of statewide concern and consumers can best be 3 protected by 4. I. Requiring registration of persons engaged in the business of 5. Selling manufactured homes or tiny homes. 6. 2. Imposing escrow and bonding requirements upon persons 7. Engaged in the business of selling manufactured homes or tiny homes. 8 and 9. 3. Requiring persons engaged in the business of selling 10 manufactured homes or tiny homes to include specified disclosures and 11 provisions in any contract for the sale of a manufactured home or tiny 12 home. 13d. The imposition of registration requirements upon the sellers 14 of manufactured homes or tiny homes by both the state and political 15 subdivisions of the state would impose an undue burden upon the sellers 16 of manufactured homes or tiny homes and discourage the sale of 17 manufactured homes or tiny homes. 18e. The registration, escrow, and bonding, and contract. 19 requirements imposed on the sellers of manufactured homes or tiny 20 homes by this Part 33 are exclusive, and no political subdivision of the 21 state may shall not impose any additional registration, escrow, and 22 bonding, or contract requirements on the sellers. 23f. The regulation of tiny homes is necessary to protect 24 consumer safety and keep tiny homes AS and affordable housing 25 alternative. 26.2. The General Assembly further declares that in enacting this Part 2733, it is the intent of the General Assembly that the division establish. -4 HB 22-1242. 1. Through the board, rules as it deems necessary to ensure 2b. Consumer safety in the purchase of manufactured homes or 3 tiny homes. 4c. The registration of manufactured home installers and the 5. Creation of uniform standards for the installation of manufactured homes. 6. Installation on a statewide basis. And 7d. The safety, affordability, and performance of hotels, motels, 8. And multifamily structures in areas of the state where no construction 9. Standards for hotels, motels, and multifamily structures exist, and 10e. The safety of foundation systems for tiny homes. 11. Manufactured homes and factory-built structures in areas of 12. The state where no construction standards for tiny homes. 13. Manufactured homes and factory-built structures exist. 14.3. The General Assembly further declares that the factory-built 15 structure programs and tiny home programs administered and Rule 16 adopted pursuant to under this Part 33 apply only to work performed in 17 of factory or factory-built structures and tiny homes that are 18 built OFF site and completed at the installation site, using 19 components shipped with the factory-built structure as reflected in the 20 approved plans for the factory-built structure or tiny home. 21 Section 2. In Colorado Revised Statutes, 2432-3302, Amend 22, 3, 4, 6, 11, 16, 17, 20, A, 20, D, 26, 29, 30, 32.5, and 23, 33, and add 24.5, 26.5, 34, and 35, as follows, 24-32-3302. Definitions. As used in this Part 33, unless the 25 context otherwise requires. 26.3. Certificate of installation means a certificate issued by the 27 Division for an installation of a manufactured home that meets the -5 HB 22-1242. 1. Requirements of complies with this Part 33 and rules that the Board 2 adopts under this Part 33. 3. 4. Certified installer means an installer of manufactured homes for who or tiny homes that 5a. Is registered with the division, and who 6b. Has installed at least 5 manufactured homes or tiny homes 7 in compliance with the manufacturer's instructions or standards created 8 by the division pursuant to this Part 33, and 9c. Has been approved by the division for certified status. 10.6. Defect means any deviation in the performance, 11. Construction, components, or material of a manufactured home, tiny 12 home, or factory-built structure that renders the manufactured 13 home, tiny home, or factory-built structure or any part thereof of 14 the manufactured home, tiny home, or factory-built structure 15 not fit for the ordinary use for which it was intended. 16.11. Factory-built structure means 17a. A factory-built non-residential and structure. 18b. A factory-built residential buildings. Structure and 19c. A factory-built tiny home. 20.16a. Installation means the placement of a manufactured 21 home or tiny home on a permanent or temporary foundation system. 22b. Installation includes without limitation supporting, blocking, 23 leveling, securing, or anchoring the home and connecting multiple or 24 expandable sections of the home. 25.17. Installer means any person who performs the installation 26 of 27a. A manufactured home, which includes multifamily structures. -6 HB 22-1242. 1 for those with the knowledge, experience, and skills to do so, or 2b. A tiny home. 3.20. Manufactured home means any pre-constructed building 4-unit or combination of pre-constructed building units or closed panel 5 systems that 6a. Includes electrical, mechanical, or plumbing services 7 that are fabricated, formed, or assembled at a location other than the site 8 of the completed home 9d. Does not have motor power is not self-propelled, and 10. 24.5. Mobile home park has the meaning set forth in 11 section 38-12-201.5 6. 12.26. Owner means the owner of a manufactured home or tiny 13 home. 14.26.5. Permanent foundation means a structure that is 15 designed or intended to 16a. Support a building from underneath. 17b. Keep a building firmly affixed to the ground. 18c. Prevent the building from moving. And 19d. Not be removed from the ground or building. 20.29. Purchaser means the first person purchasing a 21 manufactured home or tiny home if either is purchased in good faith. 22 for purposes other than resale. 23.30. Quality assurance representative means any state, firm, 24 corporation, or other entity that proposes to conduct production reviews. 25. Evaluate a manufacturer's quality control procedures and perform design 26 evaluations. For factory-built structures. 27.32.5. Seller means any person engaged in the business of -7 HB 22-1242. 1. Selling manufactured homes to be installed in Colorado or tiny homes 2 be occupied or installed in Colorado. 3.33. Site means the entire tract, subdivision, or parcel of land on which manufactured homes or tiny homes are installed. 5.34. Temporary foundation means a structure that is 6 designed or intended to 7a. Support a building from underneath. 8b. Keep a building firmly affixed to the ground. 9c. Prevent the building from moving. And 10d. Be removable from the ground or building. 11.35. A. Tiny home means a structure that 12. Is permanently constructed on a vehicle chassis. 13.2. Is designed for long-term residency. 14.3. Includes electrical, mechanical, or plumbing services. 15 that are fabricated, formed, or assembled at a location other 16 than the site of the completed home. 17.4. Is not self-propelled. And 18. V. Has a square footage of not more than 419 square feet. 20. B. Tiny home does not include. 21. A manufactured home. 22.2. A recreational park trailer as defined in Section 23-2432-902. 8.24. 3. A recreational vehicle as defined in Section 2432-902-25. 9.26. 4. A semi-trailer as defined in Section 42-1-102, 89, or 27. V. An intermodal shipping container. -8 HB 22-1242. 1. Section 3. In Colorado Revised Statutes, 2432-3303, amend 2, 1E, and 1F, as follows, 32432-3303. Division of Housing Powers and Duties Rules. 4.1. The division has the following powers and duties pursuant to this Part 533, 6E, to enforce requirements concerning the installation of 7 manufactured homes installations, including the registration and 8 certification status of installers. 9F. To enforce requirements concerning the sale of tiny homes 10 and of manufactured homes, including the registration status of sellers. 11 and 12 Section 4. In Colorado Revised Statutes, 2432-3304, amend 13.1d, and add 1f and 1g, as follows, 1424-32-3304. State Housing Board Powers and Duties Rules. 15.1. The Board has the following powers and duties pursuant to this Part 1633, 17d, to promulgate rules establishing standards for the installation 18 and setup of manufactured housing units, and 19f. To promulgate rules establishing standards for tiny 20 homes that cover the manufacture of, assembly of, and 21 installation of tiny homes, and 22g. To promulgate uniform foundation construction 23 standards for factory-built structures or tiny homes in those 24 areas of the state where NO standards exist. 25 Section 5. In Colorado Revised Statutes, 2432-3305, amend 26, 1, introductory portion, 1b, 1c, 2, and 3, and add 1e, and 27, 1f, as follows. -9 HB 22-1242. 124-32-3305. Rules Advisory Committee, Enforcement. 1. The 2 board shall promulgate rules as it deems necessary to ensure 3b. The safety of consumers purchasing manufactured homes or for tiny homes, 5. The c. The safety of manufactured home installations, and 6. E. The implementation of sections 2432-3328 and 72432-3329, and 8. F. The safety of foundation systems for manufactured 9 homes, tiny homes, and factory-built structures in areas of the 10 state where NO construction standards for manufactured 11 homes, tiny homes, and factory-built structures exist. 12. 2. Rules promulgated by the board must include provisions 13 imposing requirements reasonably consistent with recognized and 14 accepted standards adopted by the ASTM International, the 15 International Code Council, the National Fire Protection Association, and 16 the Colorado State Plumbing and Electrical Codes, or a combination 17 thereof of these standards and codes, except to the extent that the 18 board finds that the standards and codes are inconsistent with this Part 33. 19. All rules promulgated by the board must be adopted shall adopt Rules 20 pursuant to Article 4 of this Title 24. 21. 3a. The board must consult with and obtain the advice of an 22 Advisory Committee on residential and non-residential factory-built 23 structures and tiny homes in the drafting and promulgation of rules. The 24 committee consists of 14 members appointed by the 25 division from the following professional and technical disciplines. 26. 1 from architecture. 27. 2. 1 from structural engineering. 10 HB 22-1242. 1. 3 from building code enforcement. 2. 4 1 from mechanical engineering or contracting. 3 V 1 from electrical engineering or contracting. 4 6 1 from the plumbing industry. 5 7 1 from the construction design or producer industry. 6 8 2 from manufactured housing. 7 9 2 from the tiny home industry. And 8 X 1 from organized labor. 9 B. Committee members shall be reimbursed for actual and 10 necessary expenses incurred while engaged in official duties. 11 Section 6. In Colorado Revised Statutes, 2432-3306, amend 12:1, as follows, 1324-32-3306. Recognition of similar standards, compliance 14 with standards. 1. If the division determines that standards for 15 factory-built structures, tiny homes, or manufactured housing homes 16 prescribed by statute or rule of another state or by the United States 17 Department of Housing and Urban Development are reasonably consistent. 18 with, or equal to, standards required by this Part 33, it may provide by rule. 19 that factory-built structures, tiny homes, or manufactured housing 20 homes approved by the other state or by the department meet the 21 standards required by this Part 33. 22 Section 7. In Colorado Revised Statutes, 2432-3307, amend 23:1, as follows, 2424-32-3307. Non-compliance with standards. 1a. The 25 division may obtain injunctive relief from the appropriate A court of 26 competent jurisdiction to enjoin the manufacture, sale, delivery, or 27 installation of 11 HB 22-1242. 1. A factory-built housing structure by filing an affidavit 2 specifying the manner in which the housing factory-built structure 3 does not conform to the requirements of this Part 33 or to rules for promulgated pursuant to Section 2432-3305. Or 5. 2. A tiny home by filing an affidavit specifying the 6 manner in which the tiny home does not conform to this Part 33.7 or TO rules promulgated under Section 2432-3305. 1e. Or 824-32-3328. 9b. The division may suspend the issuance of insignias of 10 approval while injunctive relief is being sought. 11 Section 8. In Colorado Revised Statutes, 2432-3309, amend 12:1a and 2 as follows, 1324-32-3309. Fees Building Regulation Fund Rules. 14:1a. The board, by rule, shall establish a schedule of fees 15 designed to pay all direct and indirect costs incurred by the division in 16 carrying out and enforcing the provisions of this Part 33, except that the 17 amount of the registration fee for installers of manufactured homes is 18 limited to the amount specified in Section 2432-3315, 5, and the 19 amount of the registration fee for sellers of manufactured homes is 20 limited to the amount specified in Section 2432-3323, 3. 21. 2. Before establishing, the board establishes the schedule of 22 fees. The division must, for the board's consideration, shall gather 23 information regarding the fees charged by 24a. Colorado local governments for the inspection and 25 certification of improvements to residential real property that are not 26 manufactured homes or tiny homes, and 27b. The fees charged by governmental entities outside of Colorado. 12 HB 22-1242. 1 for the inspection and certification of manufactured homes for the board's to consideration or tiny homes. 3. The fees must be paid to the division and transmitted to the 4 state treasurer, who shall credit the fees to the Building Regulation 5 fund, which fund is hereby created in the state treasury and referred to in 6th this section as the fund. The state treasurer shall credit all 7 interest derived from the deposit and investment of money in the fund 8 must be credited to the fund. Except as otherwise provided in subsection 9(2) of this section, at the end of any fiscal year, all unexpended and 10 unencumbered money in the fund remains in the fund, and 11 must not be credited or transferred to the general fund or any other fund, 12 or used for any other purpose other than to offset the costs of 13 implementing and administering and enforcing the provisions of this 14 Part 33. 15. 2. In addition to being used to offset the costs of implementing. 16. In administering this Part 33 as specified in subsection 1 of this 17 section, money in the fund may be expended. 18. A. To provide education and training to manufacturers, sellers, 19 installers, building department employees, elected officials, and, as 20 appropriate, other persons affected by the mobile home, manufactured 21 home, tiny home, and factory-built structures structure industry. 22. Regarding the building codes and state program requirements applicable. 23. To mobile homes, manufactured homes, tiny homes, and factory-built 24 structures within the state. 25. B. To provide consumer training throughout the state that will 26. Help a consumer make informed decisions when purchasing. Or 27. Considering the purchase of a mobile home, manufactured home, tiny. 13 HB 22-1242. 1 home or factory-built structure, and 2. C. To provide education and grants that will help manufacturers, 3. Sellers, installers, owners, and, as appropriate, other parties affected by for the mobile home, manufactured home, tiny home, and factory-built 5 structures structure industry address safety issues that affect mobile 6 homes, manufactured homes, tiny homes, and factory-built structures. 7. Section 9. In Colorado Revised Statutes 2432-3311, Amend 8, 1, 8.7, 4, and 6, as follows. 92432-3311. Certification of factory-built structures. 10, 1, 8.7, I. The division shall conduct a full design and plan 11 review and inspection of the construction of factory-built structures to the 12 extent the design and construction relates to work performed off-site, or 13 work that is completed on-site using components shipped with the 14 factory-built structure at the installation site as reflected in the 15 approved plans for the factory-built structure. A local government may. 16 shall not duplicate efforts to review or approve the construction of a 17 factory-built structure that is under review or approved by the division, nor May 18th shall it charge building permit fees to cover the cost of Plan 19 reviews or inspections performed by the division. A local government's 20 jurisdiction is limited to work done on-site at the installation site in 21 compliance with Section 2432-3311, 6, subsection 6 of this Section 22 and includes associated plan review, permits, inspections, and fees. 23. 2. The division may authorize a local government to inspect and 24 approve work that is completed on-site using components shipped with the 25 factory-built structure at the installation site as reflected in the 26 approved plans for the factory-built structure. A local government may 27 charge inspection fees if authorized to assist the division to inspect and 14 HB 22-1242. 1. Approve work on a factory-built structure that is completed on-site. 2. Using components shipped with the factory-built structure at the 3 installation site as reflected in the approved plans for the factory-built 4 structure. 5. 4. A factory-built structure bearing an insignia of approval issued 6. By the division and affixed by the division or an authorized quality 7 assurance representative pursuant to this Part 33 is deemed to be designed 8 and constructed in compliance with the requirements of all codes and 9 standards enacted or adopted by the state and accounting for any local 10 government installation requirements adopted in compliance with Sections 112432-3310 and 2432-3318 that are applicable to the construction of 12 factory-built structures, to the extent that the design and construction 13 relates to work performed in a factory or work on a factory-built 14 structure that is completed at the installation site using 15 components shipped with the factory-built structure as reflected in the 16 approved plans for the factory-built structure. The determination by the 17 division of the scope of such approval is final. An insignia of approval 18 affixed to the factory-built structure does not expire unless the design and 19 construction of the factory-built structure has been modified from 20 approved plans. 21. 6. All work at the installation site that is unrelated to the 22 installation of a factory-built structure or components shipped with 23 unrelated to completing construction of a factory-built 24 structure at the installation site as reflected in the approved 25 plans for the factory-built structure, including additions, modifications, 26 and repairs to a factory-built structure, are IS subject to applicable Local 27 government rules. 15 HB 22-1242. 1. Section 10. In Colorado Revised Statutes, repeal 2432-3313-2 as follows. 32432-3313. Injunctive relief. The division may request the 4 appropriate court to enjoin the sale or delivery of any factory-built 5 structure upon an affidavit, specifying the manner in which the 6 factory-built structure does not conform to the requirements of this Part 733 or the rules promulgated pursuant to this Part 33. The division may 8th suspend the authority of a manufacturer to affix insignias while injunctive 9 relief is being sought. 10. Section 11. In Colorado Revised Statutes 2432-3315, Amend 11, 1, C, 3, and 4, introductory portion as follows. 122432-3315. Installers of manufactured homes and tiny homes 13 registration, fees, educational requirements, rules. 1. C. I. A 14 homeowner who is not required TO register AS and installer with 15. The division if the homeowner installs the owner's homeowner's own. 16. Manufactured home that is a 1 or 2 family dwelling intended for 17. The homeowner's own personal use or a tiny home intended for their 18. The homeowner's own personal use is not required to register as a 19 installer with the division, but the homeowner must comply with all 20 provisions of this Part 33 other than registration provisions. A homeowner 21 is limited to the 1 installation of 1 manufactured home in any 22 12-month period and a total of no more than 5 during the 23 homeowner's lifetime. 24. 2. A homeowner installing the homeowner's own 25 manufactured home or tiny home is required to shall do their own 26 the installation work. If the homeowner has another person perform 27 installation work on their manufactured home, that person is required to. 16 HB 22-1242. 1 must be a registered or certified installer. 2, 3, an application A person applying for registration or 3 certification as a manufactured home and installer, whether an initial or for renewal application, must be submitted. Submit the application on a 5 form provided by the division and verified by a declaration dated and 6 signed by the applicant under penalty of perjury. By the applicant. The 7 application must contain, in addition to any other information the division may 8 reasonably require, the name, address, email address, and 9 telephone number of the applicant. The division shall make the 10 application and declaration available for public inspection. 11 before, on and after July 1st, 2008, in order to be registered initially as 12 a manufactured home and installer, an applicant must, 13 Section 12. In Colorado Revised Statutes, 2432-3315.5, 14 amend, 1, introductory portion, 1A, and 1B, as follows, 152432-3315.5. Contract for the installation of manufactured. 16 homes and tiny homes, requirements. 1, a registered or certified. 17 installer must provide a contract for the installation of each manufactured 18 home or tiny home and make the following disclosures in any contract. 19 for the installation of a manufactured home or tiny home. 20 A, that the installer has a letter of credit, certificate of deposit, or 21 surety bond filed with the division for the performance of the installation. 22 of the manufactured home. 23 B, that an aggrieved person may file a complaint with the 24 division concerning the performance of the installation of the 25 manufactured home, including making a claim against the letter of credit, 26 certificate of deposit, or surety bond filed with the division, and 27 Section 13. In Colorado Revised Statutes, 2432-3316, amend. 17 HB 22-1242. 1 as follows, 22432-3316. Compliance with manufacturer's installation 3 instructions. 1. Except as provided by subsection 2 or 3 of this 4 section, any installation of a manufactured home in this state shall must 5 be performed in strict accordance with the applicable manufacturer's 6 installation instructions. A copy of the manufacturer's instructions or the 7 standards promulgated by the division must be available at the time of 8 installation and inspection. 9 Section 14. In Colorado Revised Statutes, 2432-3317, amend 10, 1, 2, 2.3, 2.9, 3A, introductory portion, 3A, 2, introductory 11 portion, 3A, 2, C, 3B, 4, 5A, introductory portion, 5B, 6, 12, 7, 8, 9, 10, introductory portion, and 10E, as follows, 13, 24, 32, 33, 17. Installation of manufactured homes and tiny 14 homes, authorization, certificates, inspections, inspector 15 qualification and education requirements rules. 1. Before beginning. 16. The installation of a manufactured home, the owner or registered. 17. Installer of a manufactured home or tiny home must submit a request to 18, the division, and receive an installation authorization from the division on 19, a division-approved form, unless the installation is occurring in a 20 jurisdiction where a local government is participating as an independent 21 contractor, in which case the owner or registered installer is to follow the 22 local government's process for receiving authorization to install a 23 manufactured home or tiny home. 24. 2. The division may certify any installer who provides evidence 25 of 5 or more installations of manufactured homes or tiny homes 26 performed by the installer for which installation authorizations have 27 previously been issued pursuant to I in accordance with this section. 18 HB 22-1242. 1. When, in the judgment of the division, the installer has demonstrated the 2 ability to successfully complete installations of manufactured homes in 3 accordance with the requirements of this Part 33. 4. 2.3. An installer certified by the division is not required to obtain 5 an installation authorization from the division, but a certified installer 6 is required to obtain authorization to install a manufactured home or tiny 7 home from any local government participating as an independent 8 contractor. For any installation occurring within the jurisdiction 9 of a local government not participating as an independent 10 contractor, the certified installer, upon completion of the 11 installation in accordance with this Part 33 and board rules, 12 shall affix on the manufactured home or tiny home an installation 13 insignia issued by the division. Is to be affixed on the manufactured home 14 by the certified installer upon completion of the installation of the 15 manufactured home in accordance with the requirements of this Part 33. 16 and board rules in any jurisdiction not participating as an independent 17 contractor. 18. 2.9. The division or an independent contractor at the request of 19, the division may, at the division's sole discretion, inspect the 20 installation of any manufactured home performed by a certified installer 21 pursuant to this subsection, 2.9, and may require the certified installer to 22 correct, within a period established by rule promulgated by the board, any 23 defects or deficiencies in the installation. The division may revoke the 24 certification of any installer certified pursuant to this subsection, 2.9, 25 when, in the judgment of the division, the installer has performed 26 installations of a manufactured home and installation in violation of the 27 requirements of this Part 33 or board rules adopted under this Part. 19 HB 22-1242. 133. Any installer whose certification has been so revoked may apply for 2 recertification in accordance with rules promulgated by the division. 3.3a. The division may fine a registered installer or force suspend or revoke the registration of a registered installer if the installer 5 fails to 6.2. Otherwise pay to the owner or occupant of a manufactured 7 home or tiny home 8c. A refund of any money paid up front that did not result in a 9 complete installation of the manufactured home by the installer or the 10 cost of completing that was used. TO pay a different registered 11 installer. TO complete the installation by a different registered 12 installer. 13b. I. A financial institution or authorized insurer is required to 14 make payment to the division making when the division makes a claim 15 against the letter of credit, certificate of deposit, or surety bond. 16a. If a court of competent jurisdiction has rendered a final 17 judgment in favor of the division based on a finding that the registered 18 installer failed to perform on the installation of the manufactured home 19 as required by this Part 33 or board rules, or 20b. Upon a ceasing of business operations or a bankruptcy filing 21 by the registered installer if the registered installer ceases business 22 operations or files for bankruptcy. 23.2. The division may suspend or revoke the registration of 24 any installer who fails to provide a letter of credit, certificate of deposit, 25 or surety bond as required by Section 2432-3315, 2, and 6. Or who 26 otherwise fails to pay any judgment by a court of competent jurisdiction 27 in favor of the division, is subject to the suspension or revocation of the -20 HB 22-1242. 1. Registration by the division. 2. 4. An owner or a registered installer must display an installation 3 authorization at the site of at which a manufactured home or tiny home 4 is to be installed until an installation insignia is issued by the division or 5 independent contractor, unless the installation is occurring in a 6 jurisdiction where a local government is participating as an independent 7 contractor. In which case, if the local government is an independent 8 contractor, the owner or registered installer is to shall follow the 9 local government's process for identifying a manufactured home or tiny 10 home to be installed until the division's installation insignia is issued by 11 the local government. 12.5a. The division shall adopt rules that specify a standard Form 13 to be used statewide by the division or an independent contractor as a 14 certificate of installation certifying that a manufactured home or tiny 15 home was installed in compliance with the provisions of this Part 33. 16. However, the certificate of installation applies only to an installation of 17 a manufactured home, built in a factory of a tiny home, and of 18 components shipped with to install or finish the manufactured home 19 or tiny home as reflected in the approved plans for the manufactured 20 home or tiny home. The certificate of installation must include, but not 21 be limited to the following. 22b. If a vacant manufactured home or tiny home fails in 23 installation inspection because of conditions that endanger the health or 24 safety of the occupant, the manufactured home or tiny home cannot be 25 occupied until the defects or deficiencies that form the basis of 26 the failed inspection are corrected. If a manufactured home or tiny 27 home fails an installation inspection because of conditions that do not -21 HB 22-1242 1. Endanger the health or safety of the occupant, the manufactured home or 2 tiny home may be occupied pending the correction of those defects or 3 deficiencies that served as the basis of the failed inspection. 4.6. In addition to inspections performed pursuant to subsection 5, 2.9 of this section, the division or the independent contractor that 6 performs inspections and enforcement of proper installation of 7 manufactured homes installations may inspect the installation of 8 a manufactured home upon request filed by the owner, installer, 9 manufacturer, or seller of the manufactured home. The party 10 requesting the inspection must be paid for by the party that requested 11 pay for the inspection. 12.7. If the installation of a manufactured home by an installer 13 has fails the inspection conducted by the division or the 14 independent contractor and it is determined by the division or the 15 independent contractor determines that the installer has failed to 16. Comply with the manufacturer's instructions or violated any of the 17 installation standards promulgated by the division. The installer must 18 shall reimburse the party requesting the inspection for the cost of the 19 failed inspection and must pay for any subsequent repairs necessary to 20. Bring the installation into compliance with the manufacturer's instructions 21 or standards promulgated by the division. The installer must shall also 22 pay for any subsequent inspections required by the division or the 23 independent contractor. Failure of the installer to pay for any inspections 24 or subsequent repairs deemed necessary by the division or the 25 independent contractor shall results in the forfeiture of the 26 installer's performance bond on behalf of the owner of the manufactured 27 home. -22 HB 22-1242. 1.8a. The division may authorize an independent contractor to 2 perform inspections and enforcement of proper installation of 3 manufactured homes installations. 4.b.I. The division may shall provide training for independent 5 contractors to perform installation inspections. The training must 6 enable independent contractors who successfully complete the 7 training to be certified by the division. Independent contractors must 8 be certified by the division to perform installation inspections. 9.2. The division may accept gifts, grants, or donations for 10 the training of independent contractors. The division shall 11 transmit any gifts, grants, or donations it receives to the State 12 Treasurer for deposit in the Building Regulation Fund created in 13 Section 2432-3309. 14c. The division must shall establish by rule the qualifications of 15 an inspector and the areas of expertise necessary for inspecting 16 manufactured homes on and after July 1st, 2008, or tiny homes. A new 17 inspector must pass a division-approved installation test. The 18 qualifications for an inspector include, but are not limited to, those of a 19 professional civil engineer, or local housing inspector, or independent 20 contractor. Commencing in 2009, inspectors shall also complete 21 and maintain records of the completion of division-approved Education 22 as established by the board through rulemaking by Rule 23.9. If an installation or subsequent repair of an installation by an 24 installer fails to comply with the manufacturer's instructions, or 25 meet the standards promulgated by the division within a period 26 determined by the division shall investigate the 27 actions of the installer. The division may revoke, suspend, or refuse to. 23 HB 22-1242. 1. Renew the registration or certification of the installer for failing to comply to with the manufacturer's instructions or the division's standards. 3. Regarding an installation of a manufactured home. Any independent contractor that knows of an installer whose installations have failed 5 inspection and have not been cured by subsequent repair shall 6. Request that the division investigate the installer. 7. 10. The board shall adopt rules concerning 8e. Any other rule matter necessary for the implementation of 9 manufactured home the installation requirements in this part 33. 10. Section 15. In Colorado Revised Statutes, amend 2432-33-1811 as follows. 1224-32-33-18. Local installation standards preempted. 13.1. Except as authorized in Section 2432-33-29. 2. A local 14 government shall not adopt less stringent standards for the N15 installation of a manufactured home than those promulgated by the 16 Division. A local government shall not, without express consent by 17. The division adopt different standards than the standards for the N18 installation of a manufactured home promulgated by the division. 19.2a. Nothing in this section prohibits a local 20 government from enacting standards for tiny homes or mobile or 21 modular homes concerning unique public safety requirements related to 22 geographic or climatic conditions, such as weight restrictions for roof 23 snow loads, or wind shear factors, or wildfire risk, as otherwise 24 permitted by law. 25b. Unless the United States Department of Housing and 26 Urban Development has granted an exemption to a local 27 government, a local government shall not impose. 24 HB 22-1242. 1. Weight restrictions for roof snow loads or wind shear factors. 2. On a manufactured home built to the federal manufactured home. 3. Construction and safety standards that are different from what has been forzoned for the state of Colorado by the United States Department of Housing and Urban Development pursuant to the Federal Act, or impose 6. 2. Any other requirements that would impact the design, and 7. Construction of the manufactured home. Unless an exemption has been 8 granted for that jurisdiction by the United States Department of Housing. 9. And Urban Development. 10.3. Nothing in this section prohibits a local government from 11. Requiring on-site mitigation to address unique public safety requirements. 12. Related to geographic and climatic conditions, such as weight restrictions. 13. For roof snow loads and wind shear factors, or wildfire risk on a 14 manufactured home built to the federal manufactured home construction. 15. And safety standards, so long as there is no interference with the federal. 16. Standards for the design and construction of the manufactured home. 17. Section 16. In Colorado Revised Statutes, amend 2432-33-21-18 as follows. 1924-32-33-21. Investigations of consumer complaints. The 20 Division may investigate complaints filed by owners, occupants, or other 21 consumers relating to the construction of factory-built structures in 22 manufactured homes, and the sale or installation or sale of 23 manufactured homes and tiny homes as necessary to enforce and 24 administer this part 33. 25 Section 17. In Colorado Revised Statutes, repeal 2432-33-22-26 as follows. 27-24-32-33-22. Training of inspectors, acceptance of gifts. 25 HB 22-1242. 1. Grants and donations. 1. On and after July 1, 2000, the division must train independent contractors to perform installation inspections for 3 manufactured homes. The training must enable independent contractors who successfully complete the training to become certified by the 5 Division. 6. 2. On and after July 1, 2000, the division may accept gifts, 7 grants, or donations for the training of independent contractors. The gifts, 8 grants, or donations received must be transmitted to the state treasurer. 9. Who must credit the money to the Building Regulation Fund created in 10 Section 2432-3309. 11 Section 18. In Colorado Revised Statutes, amend 2432-33-2312 as follows. 13 2432-33-23. Sellers of manufactured homes and tiny homes. 14 Registration. 1. Any seller is required to register with the Division 15 before engaging in the business of selling manufactured homes to be or 16 tiny homes if either IS installed in Colorado. 17. 2. An application A person applying for a registration or 18. Renewal required by this section must be submitted. Submit the 19 application on a form provided by the division and must be verified. 20. Verify the application by a declaration signed and dated, under penalty 21 of perjury, by a principal of the manufactured home seller. The 22 application must contain, in addition to such any other information. 23. Regarding the conduct of the manufactured home seller's business as that. 24. The division may reasonably require the name, address, email address. 25. And position of each principal of the manufactured home seller and each 26 person who exercises management responsibilities as part of the 27 manufactured home seller's business activities. The application must also 26 HB 22-1242. 1 contain the address, email address, and telephone number of each retail 2 location operated by the applicant, as well as the location and account 3 number of the separate fiduciary account required by Section 2432-33-24-4, 1, and any board rules. The division must preserve the application and 5 declaration and make them available for public inspection. 6.3a. The division shall register an applicant that 7 complies with subsection 2 of this section and that is qualified 8i in accordance with this section and the rules promulgated 9 under this section. 10b. A registration issued pursuant to subsection 2 under 11 subsection 3a of this section is valid for 1 year 12 months 12 after the date of issuance. The amount of the division shall not set the 13 registration fee cannot be at an amount of more than $214. 15c. If, after issuance of a registration registering a seller, any 16 of the required information submitted with the application for the 17 registration pursuant to subsection 2 of this section becomes inaccurate. 18 A principal of the manufactured home seller shall notify the 19 division in writing of the inaccuracy within 30 days and provide the 20 division with accurate updated information. 21.4. For purposes of this section, a person is not a seller if the 22 person, 23a, is a natural person acting personally in selling a manufactured 24 home owned or leased by the person or a tiny home owned or leased 25 by the person. 26b. Sells a manufactured home or a tiny home in the course of 27 engaging in activities that are subject to the provisions of Article 10 of 27 HB 22-1242. 1. Title 12 or activities that would be subject to the provisions but for 2 specific exemptions set forth in Article 10 of Title 12 or an exemption set 3/4 in Article 10 of Title 12. 4c. Sells a manufactured home or a tiny home for salvage or 5 non-residential use. 6d. Directly or indirectly sells, in any calendar year, 3 or fewer 7 previously occupied manufactured homes that or tiny homes that are 8 owned by a manufactured mobile home park owner and are located 9 within 1 or more manufactured mobile home parks in Colorado. Or 10e. For a salary, commission, or compensation of any kind, is 11 employed directly or indirectly by any registered manufactured home 12 seller to sell or negotiate for the sale of manufactured homes or tiny 13 homes. 14 Section 19. In Colorado Revised Statutes 2432-33-24, amend 15.2 as follows: 1624-32-33-24. Escrow and bonding requirements rules. 17.2a. A seller must provide a letter of credit or certificate of deposit. 18. Issued by a licensed financial institution or surety bond issued by an 19. Authorized insurer in an amount and in accordance with the process 20 established by the board through rulemaking by rule. 21b. A financial institution or authorized insurer is required to 22 make payment to the division making when the division makes a claim 23 against the letter of credit, certificate of deposit, or surety bond. 24i. If a court of competent jurisdiction has rendered a final 25 judgment in favor of the division based on a finding that the registered 26 seller failed to 27a. Deliver the manufactured home or tiny home or refund. 28 HB 22-1242. 1. Payments made toward the purchase of the manufactured home pursuant to 2 or of the tiny home AS required by this Part 33 or board rules. Or 3b. Provide a reasonable per diem living expense in violation of for the contractual provisions required by Section 2432-33-25. Or 5.2. Upon a ceasing of business operations or a bankruptcy filing 6 by the registered seller if the registered seller ceases business 7 operations or files for bankruptcy. 8c. The division may suspend or revoke the registration of 9 any seller who that fails to provide a letter of credit, certificate of 10 deposit, or surety bond as required by this subsection 2, or who that 11 otherwise fails to pay any judgment by a court of competent jurisdiction 12 in favor of the division. Is subject to the suspension or revocation of the 13 registration by the division. 14 Section 20. In Colorado Revised Statutes 2432-33-25, amend 15.1 introductory portion 1a, 1c, 1d, and 2 as follows. 1624-32-33-25. Contract for sale of manufactured home or tiny. 17 home requirements. 1. A seller must provide a contract with the sale 18 of each manufactured home or tiny home and make the following 19 disclosures in any contract for the sale of a manufactured home or tiny 20 home. 21a. That the purchaser may have no legal right to rescind the 22 contract absent delinquent delivery of the manufactured home or the 23 existence of a specific right of rescission set forth in the contract. 24c. That an aggrieved person may file a complaint with the 25 division against the seller for a refund of any payment held in escrow 26 by a seller of manufactured homes against the seller with the division. 27 and 29 HB 22-1242. 1d. That an aggrieved person may bring a civil action pursuant to the provisions of the Colorado Consumer Protection Act, Section 36-1-709, to remedy violations of manufactured home seller requirements 4 in this Part 33. However, damages are limited in accordance with the 5 provisions of Section 6-1-113, 2.5. 6.2. A contract for the sale of a manufactured home or tiny home 7 by a seller must also contain the following provisions. 8a either. 9i. A date certain for the delivery of the manufactured home or 10 tiny home. Or 11.2. A listing of specified delivery preconditions that must occur 12 before a date certain for delivery can be determined. 13b. A statement that if delivery of the manufactured home or tiny 14 home is delayed by more than 60 days after the delivery date. specified 15 in the contract of sale, or by more than 60 days after the delivery 16 preconditions set forth in the contract of sale have been met if no date 17 certain for delivery has been set, the seller will either refund the 18 manufactured home sale down payment or provide a reasonable per diem 19 living expense to the buyer for the days between the delivery date 20 specified in the contract or the 61st day after the delivery 21 preconditions set forth in the contract have been met, whichever is 22 applicable, and the actual date of delivery, unless the delay in delivery is 23 unavoidable or caused by the buyer, and 24, c, an agreed upon location for delivery of the manufactured 25 home or tiny home. To the purchaser. 26 Section 21. In Colorado Revised Statutes, 2432-3326, amend 27-1, introductory portion, 1b, 1c, and 2, as follows. Dash 30 HB 22-1242. 12432-3326. Unlawful sales practices, manufactured homes 2, and tiny homes fines. 1. A seller engages in an unlawful 3 manufactured home sale or tiny home sales practice when the person, 4b, fails to comply with the escrow and bonding requirements of 5 sections 2432-3323, 2.5, and 2432-3324, section 2432-3324, or board 6 rules, 7 KC, fails to provide and include in any contract for the sale of a 8 manufactured home or tiny home any of the disclosures or contract 9 provisions required by section 2432-3325, or 10.2, any a person found to be selling or have sold that sells a 11 manufactured home or tiny home in a manner contrary to the 12 requirements of this Part 33 or rules adopted under this Part 33 is 13 subject to revocation or suspension of a seller's registration, fines, or any 14 other measures as prescribed by rule promulgated by rules that the 15 Division promulgates or by other applicable Colorado law. The Division. 17 violations of this Part 33 or rules adopted under this Part 33 that 18 are committed during a single sale constitute 1 violation. Each sale 19 performed in violation of this Part 33 or rules adopted under this 20 Part 33 constitutes a separate violation. Fines must be paid to the 21 Division and transmitted to the State Treasurer, who must credit the fees 22 fines to the Building Regulation Fund created in Section 2432-3309. 23 Section 22. In Colorado Revised Statutes, 2432-3327, amend 24-1, as follows, 25-2432-3327. Inspections. 1. For the purposes of enforcement of 26 this Part 33, persons duly designated by the Division, upon presenting 27 appropriate credentials to the owner, operator, or agent in charge are 31 HB 22-1242.
Oh, never mind.
Manufactured home or tiny home in a manner contrary to the 12 requirements of this Part 33 or rules adopted under this Part 33 is 13 subject to revocation or suspension of a seller's registration, fines, or any 14 other measures as prescribed by rule promulgated by rules that the 15 Division promulgates or by other applicable Colorado law. The Division may 16th issue a fine of up to $10,000 for each violation. Multiple 17 violations of this Part 33 or rules adopted under this Part 33 that 18 are committed during a single sale constitute 1 violation. Each sale 19 performed in violation of this Part 33 or rules adopted under this 20 Part 33 constitutes a separate violation. Fines must be paid to the 21 Division and transmitted to the State Treasurer, who must credit the fees 22 fines to the Building Regulation Fund created in Section 2432-3309. 23 Section 22. In Colorado Revised Statutes, 2432-3327, amend 24-1, as follows. 25-2432-3327. Inspections. 1. For the purposes of enforcement of 26 this Part 33, persons duly designated by the Division, upon presenting 27 appropriate credentials to the owner, operator, or agent in charge are 31 HB 22-1242. 1 authorized, 2a, to enter at reasonable times and without advance notice any 3 factory, warehouse, or establishment in which manufactured homes, tiny 4 homes, or factory-built structures are manufactured, stored, or held for 5 sale, 6b, to inspect at reasonable times, within reasonable limits, and 7 in a reasonable manner, any factory, warehouse, or establishment in 8 which manufactured homes, tiny homes, or factory-built structures are 9 manufactured, stored, or held for sale and to inspect any books, papers, 10 records, and documents that relate to the safety of manufactured homes, 11 tiny homes, or factory-built structures. Each inspection must be 12 commenced and completed with reasonable promptness. 13. C. To enter and inspect, at reasonable times and without advance 14 notice, any site on which a manufactured housing home or a tiny home 15 is being or has been installed or reinstalled at or near the time of 16 installation or reinstallation, and 17. D. To inspect any books, papers, records, and documents that 18 relate to the proper installation of a manufactured housing home or a 19 tiny home. 20 Section 23. In Colorado Revised Statutes, add 2432-3328 and 21-2432-3329 as follows. 22-2432-3328. Tiny Homes Standards Rules. 1. The Board 23 shall promulgate rules establishing standards for the 24 manufacture of tiny homes. The Board may use any national or 25 international standard that is appropriate for all or a portion 26 of a tiny home if the Board finds that the standard provides for 27 reasonable safety standards for tiny home occupants. The 32 HB 22-1242. One Board may modify, by rule, any national or international 2 standard adopted under this subsection, 1, as necessary for use 3 in Colorado. 4. 2. The Board shall establish standards for connecting 5A tiny home to utilities, including water, sewer, natural gas, and 6 electricity. 7. 24, 32, 33, 29. Local government's inspections of tiny homes. 8. Connection to utilities rules. 1. A local government may require 9. The inspection of a tiny home manufactured before July 1, 2023. 10. If the tiny home is not manufactured in accordance with the 11 standards established under Section 24, 32, 33, 28. 12. 2. A. A state electrical inspector or a local government may 13th approve the connection of a tiny home for electric utility 14 service if the tiny home is in compliance with applicable codes 15 and standards for connection for electric utility service. 16. B. A state plumbing inspector or a local government may 17th approve the connection of a tiny home for water, gas, or sewer. 18. Utility service if the tiny home is in compliance with applicable 19 codes and standards for connection for water, gas, or sewer. 20. Utility service. 21. Section 24. In Colorado Revised Statutes, 2432-904.5, 22 amend, 1, introductory portion and 1A, as follows, 23 2432-904.5. Compliance with national standards, 24, recreational park trailers, recreational vehicles. 1. No a person, 25 partnership, firm, corporation, or any other entity may shall not 26 manufacture, sell, or offer for sale within this state. 27. A. Any new recreational vehicle that is not manufactured in 33 HB 22-1242. 1. Compliance with the American National Standards Institute's, ANSI's, 2. Standard A 119.2 National Fire Protection Association Standard 31192 for recreational vehicles or any successor standard or 4 amendment, thereto, or 5 Section 25. In Colorado Revised Statutes 6-1-105, amend 6, 1, SS, as follows, 76-1-105. Unfair or deceptive trade practices. 1. A person 8 engages in a deceptive trade practice when, in the course of the person's 9 business, vocation, or occupation, the person, 10 SS, violates any provision of Part 33 of Article 32 of Title 2411 CRS that applies to the installation of manufactured homes or tiny 12 homes, 13 Section 26. In Colorado Revised Statutes, amend 6-1-709 as 14 follows, 15 6-1-709. Sales of manufactured and tiny homes, deceptive 16 trade practices. A person engages in a deceptive trade practice when, in 17, the course of such the person's business, vocation, or occupation, such. 18. The person engages in conduct that constitutes an unlawful manufactured. 19. Home sale practice as sales practice or an unlawful tiny home 20. Sales practice, as either sales practice is described in Section 21, 24, 32, 33, 26. CRS. 22. Section 27. In Colorado Revised Statutes, 12-115-103, add 23, 13, as follows, 2412-115-103. Definitions. As used in this Article 115, unless the 25 context otherwise requires, 26, 13, tiny home has the meaning set forth in Section 27, 24, 32, 33, 02, 35. 34 HB 22-1242. 1 Section 28. In Colorado Revised Statutes, 12-115-120, amend 2, 1C, 2A, 2C, and 10D, as follows, 312-115-120. Inspection Application Standard Rules. 4. 1AC, a utility shall not provide service to any person required to have 5 electrical inspection under this Article 115 without proof of final approval 6 as provided in subsection 1B of this section, except that the utility 7 shall provide service, 8I, shall be provided in those situations determined by the local 9 electrical inspection authority, or by the board, whichever has jurisdiction, 10 to be emergency situations for a maximum period of 7 days or until 11 the inspection has been made, or 12, 2, if the board or local electrical inspection authority 13 has approved a tiny home connection for electric utility service 14 in accordance with Section 24, 32, 33, 29, 2. 15, 2, A, the owner of an electrical installation in any new 16 construction, other than manufactured units certified by the Division of 17 housing pursuant to Section 24, 32, 33, 11 or a tiny home manufactured 18 to the standards of Section 24, 32, 33, 28, 1, or remodeling or repair 19 of an existing construction, except in any incorporated town or city, 20 county, city and county, or qualified state institution of higher education 21 having its own electrical code and inspection program equal to the 22 minimum standards as are provided in this Article 115, shall have the 23 electrical portion of the installation, remodeling, or repair inspected by a 24 state electrical inspector. A qualified state institution of higher education 25 with a building department that meets or exceeds the minimum standards 26 adopted by the board under this Article 115 shall process applications for 27 permits and inspections only from the institution and from contractors. 35 HB 22-1242. 1 working for the benefit of the institution and shall conduct inspections 2 only of work performed for the benefit of the institution. 3C. A manufactured home, mobile home, tiny home, or movable 4-structure owner shall have the electrical installation for the manufactured 5-home, mobile home, tiny home, or movable structure inspected prior to 6 obtaining electric service. And inspection of a tiny home performed in 7 accordance with section 2432-3329 complies with this subsection 8(2)(c). 9(10)(d). I. The board shall ensure compliance with this section. 10. If the board determines, as a result of a complaint, that an entity other 11 than the state is conducting electrical inspections that do not comply with 12 this section, the board may issue to that entity an order to show cause, in 13 accordance with sections 12-20-405 and 12-115-122, 6, as to why the 14 board should not issue a final order directing that entity to cease and 15. Desist conducting electrical inspections until that entity comes into 16. Compliance to the satisfaction of the board. 17. 2. The board shall not issue a cease and desist order to 18 an inspecting entity because the inspecting entity approved the 19 occupancy of 1 or more tiny homes if the tiny homes have been 20 approved in accordance with section 2432-3329. 21. 3. If the use of state electrical inspectors is required after the 22 issuance of a final cease and desist order pursuant to this subsection 23(10)(d), that entity shall reimburse the board for any expenses incurred in 24 performing that entity's inspections, in addition to transmitting the 25 required permit fees. 26. Section 29. In Colorado Revised Statutes, 12-155-103, add 27, 13.5, as follows. 36 HB 22-1242. 112-155-103. Definitions. As used in this Article 155, unless the 2 context otherwise requires. 3. 13.5. Tiny home has the meaning set forth in Section 424-32-3302, 35. 5. Section 30. In Colorado Revised Statutes, 12-155-105, amend 6, 2, introductory portion as follows. 712-155-105. Powers of Board Fees Rules. 2. Notwithstanding 8 any other provisions to the contrary, the board may, with regard to 9 manufactured housing that is subject to Part 7 of Article 32 of Title 24, 10 Section 31. In Colorado Revised Statutes, 12-155-118, amend 11, 3, as follows. 12-155-118. Exemptions. 3. Nothing in this Article 155 shall be 13 construed to apply to the manufacture of housing that is subject to the 14 provisions of Part 7 of Article 32 of Title 24 or the installation of individual 15 residential or temporary construction units of manufactured housing water 16 and sewer hookups inspected pursuant to Section 12-155-105 Section 1712-155-105, 2. 18 Section 32. In Colorado Revised Statutes, 12-155-120, amend 19, 1, and 10C as follows. 2012-155-120. Inspection Application Standards. 1A. Any 21 plumbing or gas piping installation in any new construction or remodeling 22 or repair, other than manufactured units or tiny homes inspected in 23 accordance with the provisions of Part 7 of Article 32 of Title 24, except 24 for the new construction or remodeling or repair in any incorporated town 25 or city, county, or city and county, or in a building owned or leased or on 26 land owned by a qualified state institution of higher education where the 27 local entity or qualified state institution of higher education conducts. 37 HB 22-1242. 1. Inspections and issues permits must be inspected by a state plumbing 2 inspector. 3B. A state plumbing inspector shall inspect any new construction for remodeling or repair subject to the provisions of this subsection 1-5 within 3 working days after the receipt of the application for 6 inspection. 7C. Prior to the commencement of any plumbing or gas piping aid installation, the person making the installation shall apply for a permit 9 and pay the required fee. 10D. Every mobile home, tiny home, or movable structure owner 11 shall have the plumbing and gas piping hookup for the mobile home, tiny 12 home, or movable structure inspected prior to obtaining new or different 13 plumbing or gas service. And inspection of a tiny home performed in 14 accordance with Section 2432-3329 complies with this subsection 15, 1D. 16E. A qualified state institution of higher education with a building. 17. Department that meets or exceeds the minimum standards adopted by the 18 board under this Article 155 shall process applications for permits and 19 inspections only from the institution and from contractors working for the 20 benefit of the institution, and shall conduct inspections only of work 21 performed for the benefit of the institution. Each inspection must include 22 a contemporaneous review to ensure that the requirements of Section 2312-155-108 have been met. A qualified state institution of higher 24 education shall enforce standards that are at least as stringent as any 25 minimum standards adopted by the board. 26(10)(c)(i). The board shall ensure compliance with this section. 27. If the board determines, as a result of a formal complaint, that an 38 HB 22-1242 One inspecting entity is conducting plumbing inspections that do not comply to with this section. The board may issue to the inspecting entity an order to 3 show cause, in accordance with section 12-155-105, 1 YM, as to why the 4 board should not issue a final order directing the inspecting entity to cease 5 and desist conducting plumbing inspections until the inspecting entity 6 comes into compliance to the satisfaction of the board. 7. 2. The board shall not issue a cease and desist order to aid an inspecting entity because the inspecting entity approved the 9 occupancy of 1 or more tiny homes if the tiny homes have been 10 approved in accordance with section 2432-3329. 11. 3. If the use of state plumbing inspectors is required after the 12 issuance of a final cease and desist order pursuant to this subsection 13, 10 SC, the inspecting entity shall reimburse the board for any expenses 14 incurred in performing the inspecting entity's inspections, in addition to 15. Transmitting the required permit fees. 16. Section 33. In Colorado Revised Statutes 38-12-201.5, 17 amend 5 as follows: 1838-12-201.5. Definitions. As used in this Part 2 and in Part 11 of 19 this Article 12, unless the context otherwise requires. 20 mobile home means 21 a single-family dwelling that is built on a permanent chassis. 22 is designed for long-term residential occupancy, contains complete 23 electrical, plumbing, and sanitary facilities, is designed to be installed in 24 a permanent or semi-permanent manner with or without a permanent 25 foundation, and is capable of being drawn over public highways as a unit. 26 or in sections by special permit, or 27 b a manufactured home, as defined in Section 38-29-102 6 if 39 HB 22-1242. 1. The manufactured home is situated in a mobile home park, or 2 c a tiny home, as defined in Section 2432-3302, 35, that 3 is used as a long-term residence in the mobile home park. 4. Section 34. In Colorado Revised Statutes, amend 39-26-721.5 as follows: 639-26-721. Manufactured homes and tiny homes. 7. 1. 48% of the purchase price of a manufactured home, as 8 defined in Section 42-1-102, 106b, is exempt from taxation under Part 9(1) of this Article 26, except that the entire purchase price in any subsequent 10 sale of such a manufactured home, after it has been once subject to the 11 payment of sales tax by virtue of Section 39-26-113, is exempt from 12 taxation under Part 1 of this Article 26. 13. 2. The storage, use, or consumption of a manufactured home, as 14 defined in Section 42-1-102, 106b, after the manufactured home has 15 been once subject to the payment of use tax by virtue of Section 1639-26-208, is exempt from taxation under Part 2 of this Article 26. 17. 3. Beginning July 1st, 2019, the sale, storage, usage, or 18 consumption of a manufactured home, as defined in Section 39-1-102-19, 7.8, or a tiny home, as defined in Section 2432-3302, 35, is exempt 20 from taxation under Parts 1 and 2 of this Article 26. 21. Section 35. In Colorado Revised Statutes 29-2-105, amend 22, 1d, I, introductory portion and 1d, I, p, as follows: 2329-2-105. Contents of sales tax ordinances and proposals. 24. 1. The sales tax ordinance or proposal of any incorporated town, city, 25 or county adopted pursuant to this Article 2 shall be imposed on the sale 26 of tangible personal property at retail or the furnishing of services, as 27 provided in subsection 1d of this section. Any countywide or -40 HB 22-1242. 1 incorporated town or city sales tax ordinance or proposal shall include the 2 following provisions. 3d I. A provision that the sale of tangible personal property and for services taxable pursuant to this Article 2 shall be the same as the sale 5 of tangible personal property and services taxable pursuant to Section 639-26-104, except as otherwise provided in this subsection 1d. The 7 sale of tangible personal property and services taxable pursuant to this 8 Article 2 shall be subject to the same sales tax exemptions as those 9 specified in Part 7 of Article 26 of Title 39, except that the sale of the 10 following may be exempted from a town, city, or county sales tax only by 11. The express inclusion of the exemption either at the time of adoption of 12 the initial sales tax ordinance or resolution or by amendment thereto. 13. P. The exemption for manufactured homes and tiny homes set 14 forth in Section 39-26-721. 3. 15. Section 36. Act subject to petition effective date. 16. Applicability. 1. This act takes effect at 12:01 a.m. on the day following 17 the expiration of the 90-day period after final adjournment of the 18 General Assembly, except that, if a referendum petition is filed pursuant 19 to Section 1, 3 of Article V of the State Constitution against this act or in 20 item, section, or part of this act within such period, then the act, item, 21 section, or part will not take effect unless approved by the people at the 22 general election to be held in November 2022 and, in such case, will take 23 effect on the date of the official declaration of the vote thereon by the 24 governor. 25. 2. This act applies to acts committed on or after the applicable 26 effective date of this act. 41 HB 22-1242.
Is that finished? All righty then. Is there any further discussion? Representative Hanks.
Thank you, Mr. Chair. I wanted to go over a little bit of the revised pink sheet, the revised fiscal note, and I won't go through all of it, but I did want to focus on page 2 and the assumptions. And I think it's useful for the public record, for the public at large that is listening to this, to understand what we're assuming here. The fiscal note assumes that 1,300 tiny homes will be constructed and installed in FY 23-24, and that the industry will grow 7% per year. State revenue. This bill increases state cash fund revenue by $924,000 in FY 23 and 24, and ongoing to multiple cash funds. This revenue is subject to TABOR. The bill will also decrease state sales and use tax and may increase civil penalties collected, but those amounts have not been estimated. Finally, the bill allows DOLA to accept gifts, grants, and donations. However, none have been identified as of writing. Fee impact on tiny home manufacturers, buyers, sellers, inspectors, and installers. Colorado law requires legislative Colorado law requires legislative service agency review of measures which create or increase any fee collected by a state agency. Fees will be collected by the Department of Regulatory Agencies and the Department of Local Affairs to cover the expenditures in the bill beginning in FY 23-24. DORA fees. The current fee for electrical permits for structures of less than 1,000 square feet is $96. This is expected to increase to $100.55 to cover the expenditures in the bill. With the addition of 1,300 tiny homes to an average of 42,000 permits annually, the revenue increase is expected to be $321,815. The current fee for plumbing inspections is $26. This is expected to increase to $27.23. With the addition of 1,300 tiny homes to an average of 18,000 permits annually, the revenue increase is expected to be $57,539. These fee amounts are estimates only. Actual fees will be set administratively by DORA. Fees collected will be deposited into the Professions and Occupations Cash Fund. DOLA fees. The division will conduct a survey to estimate the volume of tiny home construction, shipments, and installations prior to the implementation of the program to determine what fees will be assessed. To cover the cost of the program and establish a fund balance, the division is expected to collect $545,110 that will be deposited into the Building Regulation Fund. I want to briefly go through Table 2, and then I think I'll step aside. Fiscal year, type of fee, total fee impact. DORA, the electrical permit, $321,815. DORA, plumbing inspection, $57,539. DOLA, certifications for tiny home sellers, installers, and independent inspectors, $545,110. The total will come to in FY 23 and 24, $924,464. I just want the people of Colorado to have some understanding of the fees being collected should this bill pass. Thank you.
Is there any further discussion? Seeing none, the question before us is the passage of House Bill 1242. All those in favor say aye. Aye. All those opposed, no. The ayes have it. 1242 is passed. Mr. Schiebel, would you read the title to House Bill 22-1012? Oh, sorry. Mr. Schiebel, will you read the title to House Bill 22-1012.
House Bill 1012 by Representatives Cutter and Valdez D, also Senators Janal and Lee, concerning healthy forest and in connection therewith creating the Wildfire Mitigation and Recovery Grant Program.
Representative Valdez.
Thank you, Mr. Chair. I move House Bill 1012 and Appropriations and Energy and Environment Committee report.
That's a good motion. To the Appropriations Committee report.
Thank you, Mr. Chair. In the Appropriations Committee report, we added money to House Bill 1012.
Mr. Speaker.
Thank you, Mr. Chair. And members, I just wanted to, I know there was a lot of discussion on kind of process around House Bill 1012, and I just wanted to highlight that, we should all, I know it's late in session, we all want to be thoughtful and as thoughtful as we can be about process. And I know there was sort of discussion of, how many amendments were run in the Appropriations Committee. I've talked to people on both sides of the aisle about that, and I think we've come to a good resolution. But I just wanted to highlight that for the body. I know it's tough. On one hand, let's be patient with each other. On the other hand, let's try to be as open and transparent as we can on all the work that we're doing.
Representative Valdez.
Thank you, Mr. Chair. In those amendments, we're not only acting and working with the Colorado State Forest Service to make sure that we continue to look at carbon and co-benefit framework for the project level in forest management programs and practice. And with that, I'll let my co-prime.
Where are we? What do I need to talk? Okay.
Representative Cutter.
Thank you, Mr. Chair. So obviously in appropriations, we got money and for the bill. And we basically, at the request of the Forest Service, we restructured this bill to create a framework for carbon. I think my co-prime was describing it accurately. To create a framework so that the Forest Service could evaluate their work within the context of carbon capture and good forest management practices.
Okay. Is there any further discussion? Seeing none.
No amendment.
Yeah. Yes. Wait. Oh, that was yours. Okay. Thank you.
Representative Cutter?
No.
Okay. All those in favor of the appropriation report, please say aye.
Aye.
All those opposed? The appropriation report passes. To the Energy and Environment report, Representative Cutter.
Thank you, Mr. Chair. The Energy and Environment Committee, we originally, we took the original bill, again, at the request of the Forest Service. We were working closely with them. They requested that we amend our grant program to go under the furworm program, which the explanation for that escapes me, Forest Management Grant Program. And so that's what we did in Energy Environment.
Is there any further discussion? All those in favor of the Energy Environment report, please say aye. Aye. All those opposed, no. The ayes have it. The Energy and Environment report passes. To the bill. Representative Cutter.
Thank you, Mr. Chair. It is an honor to serve with you.
An honor to serve with you too, Representative.
So the beauty of the legislative process is that we do have a lot of opportunity to make our legislation the best it can be for the maximum benefit of our constituents and our state. And so that's sort of the process you've seen here. This amendment really this went through some iterations, as you heard, to finally get to a bill that the Forest Service is pleased to house. It'll benefit them, and it will do everything we can to protect forests, stay on the cutting edge of best practices, to make sure that we as a state are ready to meet the challenges posed by climate. So that's really what we wanted to get at with this bill. And the development of this forest carbon accounting framework is critical to advancing practices to reduce the amount of carbon dioxide that enters the atmosphere from our forest. So I ask for your aye vote.
Representative Valdez.
Thank you, Mr. Chair. Members, in the last 5 years, we've had some of the most devastating fires here in the state of Colorado. And as we talked and worked with regional forester and the state forester and the timber industry, remember, the time is now to act. And we must continue to work and put more tools and management into our forest fires now more than ever. Our watersheds are devastated due to the bark beetle. The fuels that we have, we must continue to look at eradicating, but also management practices, and this bill creates jobs in our communities. This bill with management will continue to work forward and make sure that we have the education and putting carbon sequestration back into our soils and looking at more ways than one to make sure that we put mitigation, but also the collaboration and working with local governments, our U.S. Forest Service, and the state of Colorado moving forward. With that, I ask for your support on House Bill 1012.
Is there any further discussion? Representative Hanks.
Thank you, Mr. Chair. This is an interesting bill and an interesting topic, and while short, I'd ask that it be read at length. Thank you.
Request has been made to have the bill
Second regular
read.
session, 73rd General Assembly, State of Colorado, introduced. LLS No. 22 to 176.01 Richard Sweetman, X 4333, House Bill 22 to 1012. House Committees, Senate Committees, Energy and Environment. A bill for an act. 101, concerning healthy forest and, in connection therewith. 102, creating the Wildfire Mitigation and Recovery Grant 103 program. Bill summary. Note, this summary applies to this bill as introduced and does not reflect any amendments that may be subsequently adopted. If this bill passes third reading in the House of Introduction, a bill summary that applies to the re-engrossed version of this bill will be available at http://leg.colorado.gov. Wildfire Matters Review Committee. Section 1 of the bill creates the Wildfire Mitigation and Recovery Grant Program in the Colorado State Forest Service, to provide grants to help counties with forested areas prevent and recover from wildfire incidents and ensure that such efforts are undertaken in a manner. House sponsorship Cutter and Valdez D. Lynch, Snyder. Senate sponsorship Ginal and Lee, Story. Shading denotes House amendment. Double underlining denotes Senate amendment. Capital letters or bold and italic numbers indicate new material to be added to existing statute. Dashes through the words indicate deletions from existing statute. That reduces the amount of carbon that enters the atmosphere. In expending grant money, a county, to the extent practicable, shall ensure that biomass that is removed from forests is recycled or disposed of in a manner that reduces the amount of carbon that enters the atmosphere. The Forest Service shall administer the grant program and, subject to available appropriations, award grants out of money annually appropriated to the Forest Service for the grant program. The Forest Service shall review grant applications in consultation with the Division of Fire Prevention and Control in the Department of Public Safety and with the Colorado Forest Health Council in the Department of Natural Resources. The grant program is repealed, effective September 1, 2028. Before the repeal, the grant program is scheduled for a sunset review by the Department of Regulatory Agencies. Section 2 schedules this review. 1. Be it enacted by the General Assembly of the State of Colorado. 2. Section 1. In Colorado Revised Statutes, add 2331-318 as 3 follows. For 2331-318. Wildfire Mitigation and Recovery Grant Program 5. Grant Program created applications, awards, reports, funding 6. Repeal. 1A. There is hereby created in the Colorado State 7 Forest Service the Wildfire Mitigation and Recovery Grant 8 Program, referred to in this section as the Grant Program. TO9 provide grants in order to 10I. Help counties with forested areas prevent and recover 11 from wildfire incidents by removing deadwood and other 12 potential wildfire fuel as well as debris that has resulted from 13A wildfire incident. And 14.2. Ensure that such efforts are undertaken in a manner 15. That reduces the amount of carbon that enters the atmosphere. 16B. Grant recipients may use the money received through 17 the grant program for the following purposes. 18I. To purchase or lease equipment, including mobile wood. -2 HB 22-1012. 1. Chippers. To assist with the removal of dead wood and other 2 potential wildfire fuel as well as debris that has resulted from 3A wildfire incident. 4. 2. To hire and compensate laborers to assist with the 5 removal of dead wood and other potential wildfire fuel as well 6 as debris that has resulted from a wildfire incident. And 7. 3. To initiate and maintain reforestation efforts. 8. Including the planting of tree seedlings after a wildfire 9 incident. 10C. In expending grant money as described in subsection 11(1)(b) of this section, a county, to the extent practicable, shall 12 ensure that biomass that is removed from forests is recycled or 13 disposed of in a manner that reduces the amount of carbon that 14 enters the atmosphere, including the sale or donation of 15I. Salvageable timber, 16.2. Unsalvageable timber that is reduced to chip or 17 pellet form, and 18.3. Unsalvageable biomass that has been rendered AS19. Suitable for composting. 20D. The Colorado State Forest Service shall administer. 21. The grant program and, subject to available appropriations, 22 shall award grants as provided in this section. Grants shall be 23 paid out of money annually appropriated for the grant program, 24 as described in subsection 4 of this section. 25, 2A, to receive a grant, a Board of County 26 Commissioners must submit an application on behalf of ITS County 27 to the Colorado State Forest Service. At a minimum, the -3 HB 22-1012. One application must include the following information. 2I, the name of the county and the portion of the county. 3, in which the county plans to implement wildfire mitigation or for recovery efforts. And 5.2, the amount of grant money that the county seeks. 6, including an itemization of how the county plans to spend such 7 money. 8B, the Colorado State Forest Service shall review grant 9 applications in consultation with the Division of Fire Prevention 10 and Control in the Department of Public Safety and the 11 Colorado Forest Health Council created in Section 23-31-316 and 12 awarding grants. The Colorado State Forest Service shall 13 consider the input of the Director of the Division of Fire 14 Prevention and Control and the input of the Colorado Forest 15 Health Council. 16C, the Colorado State Forest Service shall distribute the 17 grant money within 30 days after the Colorado State Forest 18 Service awards a grant. 19.3a, on or before November 1st, 2022, and on or before -4 HB 22-1012.
That's not it.
14. Implement the grant program. The Colorado State Forest Service, May 15th, use up to 3% of the money annually appropriated. 16. For the grant program to pay the direct and indirect costs that 17. The Colorado State Forest Service incurs in administering the 18 grant program. 19. Any money that is appropriated to the Colorado State 20 Forest Service pursuant to subsection 4A of this section and 21 not expended by the Colorado State Forest Service in the state 22 fiscal year for which it is appropriated remains with the 23 Colorado State Forest Service to implement the grant program 24 in the following state fiscal year and does not revert to the 25 general fund. 26.5. This section is repealed, effective September 1st, 2028. 27. Before the repeal, the grant program is scheduled for review in -5 HB 22-1012. 1. Accordance with Section 2434-104. 2. Section 2. In Colorado Revised Statutes, 2434-104, add 3, 29A, 17, as follows, for 2434-104. General Assembly Review of Regulatory Agencies 5 and Functions for Repeal, Continuation, or Reestablishment Legislative 6 Declaration, Repeal. 29A, the following agencies, functions, or both, 7 are scheduled for repeal on September 1st, 2028, 8, 17, the Wildfire Mitigation and Recovery Grant 9 program created in Section 2331-318. 10 Section 3. Act subject to petition effective date. This Act 11 takes effect at 12:01 a.m. on the day following the expiration of the 1290-day period after final adjournment of the General Assembly, except 13 that, if a referendum petition is filed pursuant to Section 1(3) of Article V14 of the state constitution against this Act or an item, section, or part of this 15 Act within such period, then the Act, item, section, or part will not take 16 effect unless approved by the people at the general election to be held in -6 HB 22-1012.
The question before us is the passage of House Bill 1012. All those in favor, please say aye.
29.
All those opposed, nay.
As follows.
The ayes have it. Passes. Madam Majority Leader. Next bill. Oh, I'm sorry, Mr. Schiebel. Will you please read the title to House Bill 22-1365?
House Bill 1365 by Representative Esgar, also Senator Henriksen, concerning the creation of the Southern Colorado Institute of Transportation Technology at Colorado State University, Pueblo.
Madam Majority Leader.
Thank you, Mr. Chair. I move House Bill 1365 and the Education Committee report.
To the committee report.
Thank you, Mr. Chair. On the Education Committee report, we clarified who would be on the appointed board. I ask for an aye vote.
Question before us, approval of the committee report. All those in favor, please say aye. All opposed, no. Ayes have it. It passes. To the bill.
Thank you, Mr. Chair. Members, I move House Bill 1365 and ask for your support. This bill will solidify a partnership that's already providing great benefits in Pueblo and Southern Colorado by creating the Southern Colorado Institute of Transportation Technology at CSU Pueblo. I ask for your support for this program. Thank you.
Is there any further discussion? Seeing none, the question before us is the passage of House Bill 1365. All in favor, please say aye. All those opposed, no. The ayes have it. The bill passes. Mr. Schiebel, please read the title to House Bill 22-1348.
House Bill 1348 by Representatives Froelich and Caraveo, also Senator Winter, concerning enhanced oversight of the chemicals used in oil and gas production.
Representative Caraveo.
Thank you, Mr. Chair. I move House Bill 1348 on the Appropriations and Energy Committee reports.
To the Appropriations Report. Representative Caraveo.
Thank you, Mr. Chair. In appropriations, we made an appropriation of $60,000 for the first year of operations.
Great. The question before us is approval of the appropriation report. Everybody, all in favor, say aye.
Aye.
Those opposed, no. The ayes have it. The report passes. To the Energy and Environment Report, Representative Froelich.
Thank you very much, Mr. Chair. Energy and Environment had a wonderful discussion about this opportunity for oil and gas to be more transparent in their chemical use, and we have a couple amendments to the Energy and Environment Committee. To the bill. So we asked for an aye vote.
Any further discussion? All those in favor of the Energy and Environment Report, please say aye.
Aye.
All those opposed, no. The ayes have it. The report is passed. To the bill.
Thank you very much, Mr. Chair. To the bill, we have been working with industry to make sure that our definitions work within the system. And so I move Amendment L005, which clarifies that by manufacturer, we actually mean discloser. That is the person who is filing the information with the Colorado Oil and Gas Commission. I ask for an aye vote.
L005 has been properly moved and is displayed. Any further discussion? All those in favor of L005, please say aye.
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 All those opposed, no. The ayes have it. L005 is adopted. Representative Froelich.
Thank you. I move L006 to the bill, which again clarifies who is actually doing the disclosing of chemical information, and I ask for an aye vote.
It's a good motion. It is displayed. Is there any further discussion? Seeing none, all those in favor of L006, please say aye.
Aye.
All those opposed, no. The ayes have it. L006 is adopted.
Thank you, Mr. Chair.
Representative Froelich.
Thank you. And one last one. I move L007, again, working with industry to make sure that our definitions align with actual practices. And I ask for an aye vote.
That's a good motion, and L007 is displayed. Is there any further discussion? Seeing none, the question before us is a passage of L007. All those in favor, please say aye. Those opposed, no. The ayes have it. L007 is adopted. Representative Caraveo.
Thank you, Mr. Chair. And I would like to thank everybody that has cooperated on this bill, including the industry, in order to provide further transparency around oil and gas operations in communities. There is much, I think, consternation about what may or may not be in these fluids that are put in downhole, and whether they may be affecting health in our communities. And so this will simply give us more information about what is being used as the sites. I ask for an aye vote.
Representative Froelich.
Thank you, Mr. Chair, and thank you to my wonderful co-prime, Dr. Caraveo, Dr. Representative Caraveo. And speaking of doctors, the Physicians for Social Responsibility report is one of the impetuses for this bill. Over 12,000 wells in Colorado that claimed trade secret in order to avoid properly disclosing the chemicals used in their operations. That is 413 million pounds of undisclosed chemicals. The report asked that we halt the use of PFAS in oil and gas operations, and good news, oil and gas operations do have confirmed that they do not use PFAS in Colorado, and they have agreed to a certification process in this bill. And the other recommendation was more public disclosure, and so that's what this bill is about, and I ask for an aye vote.
Is there any further discussion? Representative Luke.
Thank you, Mr. Chair. And of course, I urge a no vote on this bill. It's for the oil and gas industry. This is death by 1,000 paper cuts. This is just one of those paper cuts. We have a very clean industry. We have an industry that's regulated, probably more than anywhere, and in the cleanest industry in the whole country. Obviously, we all rely on oil and gas right now. My constituents do. Our state does. Our country does. The world does. And this is just really needless legislation. In fact, I just start to question why we're going this route. We had a former governor, Hickenlooper, who actually drank frack fluid. So I'm questioning why we are just creating more issues and more of a process for the industry to go through. They've been very willing to make changes and, again, provide the cleanest fracking process that we have in this country. So this is needless. It's really not good for anyone at this point in time, and I urge a no vote.
Is there any further discussion? Representative Pico.
Thank you, Mr. Chair. As previously noted, Governor Hickenlooper took a couple of swigs of fracking fluid. So have I. It's got the same ingredients that you get in ice cream. So it's not dangerous. I would recommend you mix it with tequila because it goes down a little bit better. But it's not this deadly tough. It doesn't really do that. Doesn't contaminate water supplies. The engineering that goes into ensuring that this downhole chemicals concentrations are kept out of water supplies is extensive. You have the drill hole, you have it concreted, steel piped, concreted again, steel piped. They have multiple layers. They have been pressure tested, and according to the EPA, they have never had that contamination occur. What goes down into the fracking layers is a mile separate from with solid rock in between of any of the water aquifers. This is a safe product. It is a safely done. And so far as disclosures, all of the chemicals are disclosed at the well sites by the operators. What they don't want to do is put their own particular mixtures up online and put it out there. The trade secrets is an issue, and that is something that they want to hold on to. But as I said before, the EPA has done that, has never found, never validated, I should clarify, never validated any contamination of water supplies. Colorado Water Quality Control Division did an exhaustive sampling of water wells in Weld County, our biggest county of production. Over half the wells had no PFAS at all. Highest measurement, any well, 13 parts per trillion, but that's not from chemicals used by the industry. They don't do that. Not from this. Contamination of water supplies by PFAS is not from oil and gas. It is from surface contamination from aircraft operations, the firefighting foam used at airports. Not an issue of oil and gas contamination. As pointed out, PFAS is not used in oil and gas operations. And I ask for a no vote.
Minority Leader McKean.
Well, thank you, Mr. Chair. It's an honor to serve here with you.
And an honor to serve with you, sir.
Well, thank you. Folks, you heard a comment before, this is like the death of 1,000 cuts. But right now, Colorado consumers are asking for cheaper hydrocarbons, cheaper gas, cheaper diesel fuel, so that we can live our lives without going broke. And what we see here is a bill, as many of the bills we're seeing, which is a solution in search of a problem. We already have frac focus. How many people in here, show of hands, nobody's going to raise their hands because nobody's listening, but that's all right. We already have frac focus, which is a website where all of the chemicals used in an operation are already online, already available, already a system by which you can find who is drilling what well, what is the operation going on there, what is being used. When we say we want more information, I think the question is for what purpose? And to be honest, I don't see a purpose here. Like I said, this is a solution looking for a problem. We do not have wells testing high for PFAS. And in fact, when you talk about whether or not the firefighting foam is used just at airports, it is not. It is actually a foam that's been used for years for fires that do not respond to water as the extinguishing treatment. And so when you find any of this product out there in wells, very, very frequently, that is from other operations far removed from anything we're talking about here today. But what I really see in this bill is yet another impact to the very industry that is saving families money in Colorado today. And in fact, I call as a piece of this that if what we're going to do is go and put yet another restraint on this, why is it that the governor is not responding to our call to issue permits in 90 days? Why is it? When the companies, every single company says we will comply with everything you've put in place. But when we keep ladling it on and ladling it on, this is the murder of an industry. This is not just a little reporting requirement. This is the desire to get rid of something some people don't like. Well, go ask the people driving up and down I-25. Go ask the people driving up and down Highway 85 or I-70. Do you want oil and gas to be put out of business in this state? I'm going to guess they're going to say no. They're going to say no because they need that to get to work, to get home to see their families, to get across the state, and to bring all of the produce, the meat, the vegetables, everything you go get in your grocery store. That gets there because of petrochemicals. And this is a design to try to make sure that that industry has a harder time working within the very good constraints we already have. We have the toughest regulations in the world, folks. Why do we keep ladling it on? Vote no.
Representative Will.
Thank you, Mr. Chair. It's an honor to serve with you.
And you too, sir.
I come up in strong opposition to this bill. I don't think it's needed. I think our oil and gas industry currently does a great job, and they've been doing that for quite some time. I heard this bill in committee. We heard lots of professional testimony about it, about the transparency of this business, about groundwater protection in this business, about no PFAS chemicals being used in frac fluids. You know, these companies stand by ready to cooperate and do their business and get going. You know, I know Mr. Halley that was a witness there in the committee as well, that there's 99% of what's used in fracking is water and sand. 99%. And they've already been reporting all of this since 2011. And, you know, all this reporting into the frac fluids is overseen by the Groundwater Council. And the site that you can go to on the frac chemicals, it's overseen by the Groundwater Council. And it is intellectual property to these companies, and should remain so. You know, we talk about the governor saying he doesn't meddle in any business. This seems like meddling to me, but you know, and from the COGCC rules themselves, and I'll just talk about the chemical disclosure. Upon request by the director, the commission, a relevant local government, governmental agency, an emergency responder, or a health professional, the operator, vendor, or service provider will provide a list of the chemical constituents, including the specific identity and concentration of each constituent contained in a chemical product. These are COGCC rules. Such request may be made as a result of a spill or a release, a complaint from a potentially adversely affected person, or when necessary to protect and minimize adverse impacts to public health, safety, welfare, the environment, and to wildlife resources. So the disclosure of the chemical constituents contained in a chemical product will only be made to a health professional when requested for the purpose of diagnosis or treatment of an individual who may have been exposed to a chemical used at an oil and gas location. That means a chemical used at an oil and gas location doesn't mean frac fluid. It means any of them. You know, you can get gasoline spills, diesel fuel spills, all that. If there's a specific chemical and it's needed for a health professional, that is all provided, and that includes frac fluid. This bill, I think, is needlessly and without evidence expands reporting of more than the frac fluid as well, but all drilling and maintenance fluids are included. I think the fiscal note's too low. It's probably way more than what that is. And Frac Focus only does frac fluids, but this is a bill I think goes way too far. You know, Leader McKean talked about people driving up and down I-25 and I-70 and all that. I'm telling you, natural gas give you a hot shower this morning. It heats your homes. You know, we talk about heat pumps and all this other things, and yes, is that progressing with technology? Yes, it is. And that's great. Let the market bear that. Let's do that. We're forcing too many things here. Natural gas is clean, and emissions are way down because of the natural gas and what they've done. The oil and gas industry, the gas molecules produced in Colorado, among the cleanest in the world. Under Colorado's rigorous regulatory framework, and I mean rigorous because it has been, and that's morphed into that most rigorous probably in the nation, and environmental rules that are widely seen as a gold standard. Colorado companies are utilizing state-of-the-art technology, we've seen it, and innovation to decrease emissions, reduce leaks. Obviously, the methane is a concern to all of us. We've doing detection on that and doing a much better job in reducing leaks. Limit venting and flaring. Flaring used to be in the country I come from, well, you can see flares all night all over the countryside. You don't see a flare anymore. That don't happen. And we just disturb far less land. Their footprint, they're doing a much better job as far as erosion control, all of that. These companies are doing a great job. And so much less land disturbance. The end result's an abundant, efficient, and affordable energy source for Coloradans that are produced locally. We're not importing it, it's produced locally in one of the safest and most environmentally sound manners anywhere. That matters, particularly if the alternative is relying on energy produced by countries with poor labor standards and environmental practices. And without calling those out, I think everyone in the room understands what that is. So let's produce our energy sources here locally, within the United States, within Colorado, and doing it in an environmentally responsible manner. We can do that, we've proven it, and if not, we're going to be importing it. And I think you understand who that's supporting and what it's supporting. So I strongly oppose this bill, and I'll be back up probably to talk some more about it. So thank you.
Representative Pico.
Thank you, Mr. Chair. What was just talked about was some of our reliance upon oil and gas. A lot of the green energy ideas, the heat pumps and so forth, they all run on electricity. And electricity in Colorado is powered largely by oil and gas operations and will be for foreseeable future. You cannot build enough green energy, wind, solar, and batteries. The batteries alone will be strip mining the planet to get enough other materials, the rare earth metals, to build all of the batteries that would be required to carry up that electrical load. It simply is not there. The manufacturing isn't there. The engineering isn't there. We need oil and gas to keep us going. But I'd like to drill a little further into the Rule 208, talking about the trade secret chemical product, hydraulic fracturing chemical disclosures. These are already part of Rule 208 of the Oil and Gas Commission, hydraulic fracturing chemical disclosures, vendor and service provider disclosures. A service provider who performs any part of a hydraulic fracturing treatment and a vendor who provides hydraulic fracturing additives directly to the operator for hydraulic fracturing treatment will, with the exception of information approved as a trade secret chemical product pursuant to Rule 208B, furnish the operator with any information needed for the operator to complete the chemical disclosure registry form and post the form on the chemical disclosure registry. The purpose of the bill is provide disclosure. It's already in the rules. We don't need another legislation to enforce this. The information will be provided as soon as possible in 30 days following the conclusion of a hydraulic fracturing treatment, and in no case later than 90 days after the commencement of such hydraulic fracturing treatment. Operator disclosures within 60 days following the conclusion of a hydraulic fracturing treatment, and in no case later than 120 days after the commencement of such hydraulic fracturing treatment, the operator of the well will complete the chemical disclosure registry form and post the form on the chemical disclosure registry, including the operator name, the date of the hydraulic fracturing treatment, the county in which the well is located, the API number for the well name and the number, the longitude and latitude of the wellhead, the true vertical depth of the well, the total volume of water used in the hydraulic fracturing treatment of the well, or the type and total volume of the base fluid used in the hydraulic fracturing treatment of something other than water, each hydraulic fracturing additive used in the hydraulic fracturing fluid, and the trade name, vendor, and a brief descriptor of the intended use or function of each hydraulic fracturing additive in the hydraulic fracturing fluid, each chemical intentionally added to the base fluid, the maximum concentration in percent by mass of each chemical intentionally added to the base fluid, and the chemical abstract service number for each chemical intentionally added to the base fluid if applicable. The ability to search for information. The chemical disclosure registry will allow the director and the public to search and sort the registry for Colorado information by geographic area, ingredient, chemical abstract service number, time period, and operator. So the intent of the bill is to provide more disclosure. We already have full disclosure of anything. The only thing this bill would add would be to broadcast it to the world and broadcast trade secret information. Although they try to avoid that, the fact is that's the only thing that you're really going to add to this. And what is this going to do? It's going to add costs. It is going to add to the cost that Coloradans pay for oil and gas. I ask for no vote.
Is there any further discussion? Representative Van Bever.
Thank you, Mr. Chair. I would urge a no vote on House District 1348. There's several things that I have as a concern, and while I completely agree with the bill sponsors that we want safe water, I come from a long line of folks who ensured that the water that we put on the crops was safe for not only the consumption of the plants receiving that water, but the animals that we would give that water to as well, that we raised on the farm. And as much as I agree with you on premise that it is our responsibility here to protect the general welfare of the public, when I look at this bill, I think of many things. When I go to vote on a bill and I think about what we are doing for the voters in our districts or for the voters of the entire state of Colorado, I have several things I need to take into consideration. Is this bill enforceable? Is the language in this bill something that can be enforced on the premise of how it is written? How does this impact affordability? Is it, as as Minority Leader McKean said, death by 1,000 cuts to an industry that would possibly be punitive in the purpose of the bill coming forward in the first place? And the fact that this bill makes the manufacturer of a product report the chemical contents when they will not have knowledge of where, when, and how the well is drilled, fracked, or maintained, is frankly just a prescription for disaster. I liken it to this situation. An electric car manufacturer being responsible for the products and the chemicals, the performance, and how the tires of that car and the manufacturers of the tires of that car are responsible for their industry. One has absolutely no ability and or frankly responsibility to have the other be something that they can control. There is no difference between the example I just gave and this bill. Local water is something that we need to survive. And I know where I come from, our water is constantly, continuously assessed and tested to ensure that it is safe for us to consume. We already have structures in place to ensure that these kinds of chemicals that might hurt us as human beings or might harm our animals or the crops in the ground are already tested. Wells are already tested annually. So I would urge a no vote because these things that I just brought up as concerns for this bill, none of them pass those tests. And worst of all, it's this death by 1,000 cuts that at some point we have to say lends itself to making Colorado yet another place, and this is another layer where it's unaffordable to live. How much do we want to pay for fuel? 98% of the products that we use in this chamber, in your home, come from fossil fuels. 98%. Heart valves for children. NICU equipment. If we were to remove everything that fossil fuel provides for us from our world, we might as well go back to the caveman days where life expectancy was 30 years old. And we no longer have the ability to have a life that is secure, to have a life that is more productive, that is more stable. It's this kind of bill where we need to say no. Stop bringing bills to this chamber with an agenda to kill an industry that allows us to do
Representative
kinds of things. Thank you so much, Chair. I appreciate your leadership. That allows us to do the things that we need to do to have a world in 2022 where it is safe to live. Thank you for bringing a concern to us about water, but I don't believe this is it. I urge a no vote.
Representative Soper.
Merci. Thank you, Mr. Chair. I appreciate being able to come down and talk about this bill. We heard this bill in Energy and Environment Committee, and one thing that greatly concerned me is the provision on trade secrets. And I know we've briefly touched on this a little bit here today, but what's most important is that you know what chemicals are being used in the fracking fluids. Same is true with Coca-Cola. What's most important is you know what ingredients are being used, for example, in Coca-Cola, that you understand that it has caffeine, that it has high fructose corn syrup, that it has caramel coloring number red. What you don't necessarily need to know is what percentage of caramel coloring or how much high fructose corn syrup or how much water, because that's part of the trade secret. That's the recipe. That allows you to replicate Coca-Cola. Same is true here. What's most important for public health and public safety is that Coloradans have access to know what chemicals are going into the fracturing fluids that's going into the ground here in Colorado, and that then they're able to make a decision on that. They don't need to know the exact recipe, the exact formula that makes that up. That's considered proprietary and allowed to be protected under trade secrets. This bill goes one step further also by requiring the different companies to have to disclose to the Colorado Oil and Gas Commission what the value of that trade secret is. Now, members, it's very difficult, A, to understand what the value of a trade secret is to a particular company, because that one trade secret may not be worth that much to that company. But collectively, the collection of trade secrets that they are protecting from their competitors may be worth a lot, because that's what gives them an advantage in the competitive marketplace. It also may be worth more to their competitor than it is to them. Their competitor may love to know what their formula is, especially if they understand that their formula works better than the one they have. This bill really concerns me because it upends a principle of law that has been considered sacrosanct in this state and across the United States for the history up until this point. And to take that and to just throw it out the window is of great concern. Companies have operated with trade secrets ever since the beginning of our nation, and before we were a nation, trade secrets were also part of the British Empire before that. And then we come here today and we want to know what the exact formula is. Disclosure of the recipe. Tell us what those concentration amounts are. What's most important is that you know what chemicals are being included. And I can't stress that enough. And that's what the public should be entitled to know. If you can't make a determination, let's say going back to our Coke example, if you believe that high fructose corn syrup is bad for you, don't drink Coke. But you don't necessarily need to know that there's 23 grams of high fructose corn syrup per 20-ounce can of Coke. I don't know if that's true or not. I just made that up. But yeah, because it's secret. You don't know exactly what it is. But I can tell you if high fructose corn syrup is bad for you and there's any level of high fructose corn syrup in Coca-Cola, then you shouldn't be drinking it. And that would be the same here. If there's a chemical on that fracturing list that we as a legislature and a state have deemed should not be going into the ground, and we mark that as something that shouldn't be going in, then if any of that is disclosed in this chemical list, then it shouldn't be going into the ground, period. It doesn't matter if it's 1% or 50% of that final recipe. And that it's not that we necessarily need to dive into the recipe. Even if, as the bill says, that it would only be the Colorado Oil and Gas Commission that would look at the back end, I do fear in an era of highly competitiveness, both from the environmental community and from the corporation side, that it's very difficult when you're giving up something that should be a secret. You're now in a very vulnerable situation where that can be released easily to the public. There's always people who are willing to leak these things out of government agencies. But the fact that we now are moving in this direction is dangerous on the precedent side of the equation. I can tell you that there's also a fear for national security, and that there's many nations around the world who have been very aggressive at trying to learn trade secrets of American corporations. China being one of those, would love to understand what are in the fracturing fluids that we're talking about here that allow American companies to actually perform better than, for example, Chinese companies. And by forcing disclosure of the exact recipe, we're also giving up that recipe in the end to America's enemies. Disclosure is always good, as far as generally what the chemical elements are in something. But we need to be very careful because right now the oil and gas economy that used to exist in Colorado is nowhere near where it used to be. And that's because of policies that have changed from this building and from the ballot box. What we also have seen is in recent years, gas has become increasingly expensive. When I filled up my vehicle before returning here on late Sunday night, it was $4.15 in Delta. And what I see from bills like this is it's more regulation piled on top of an industry that's barely able to make it here in Colorado, that's teetering on completely exiting the state. I mean, already companies like Halliburton have completely exited Colorado. I mean, where they used to be in my district are just boarded up buildings. And as we've seen this exodus from Colorado, it stands to reason that perhaps this could be why we are seeing unprecedented gasoline prices, $4.15 in Delta, $5.05 for diesel in Delta. Regulations that we see in bills like this do result in higher prices. It is no wonder that we're paying more at the pump. It's no wonder that Coloradans are paying more for natural gas and propane to heat their homes in winter, and why so many Coloradans are having to make that horrible decision of, am I going to have to pay for heat in the winter or medicine or food? Regulations have consequences, and that is why I rise in opposition to this bill. If it was just simply strengthening the disclosure of only the chemicals but not the recipe, I think that might be a conversation that would involve both sides of the aisle. But what I see here is just another nail in the coffin of the oil and gas industry, and I urge a no vote. Thank you.
Is there any further discussion? Representative Hanks.
Thank you, Mr. Chair. And this is a topic that is of high interest to me. As some people in the House may know, I did some fracking in North Dakota. I find this bill to be built off of faulty assessments, misinformation, and I find it to be unnecessary and injurious to an industry that is actually pretty efficient, very environmentally conscientious, and I can say that as a guy who hammered iron on the frac sites where we put down Titan liners under our pump trucks and under our hydraulic chemical blenders so that if we had any spill in the course of mixing chemicals, they were contained on a Titan liner that were then cleaned up as we drove off by environmental experts whose job it was to capture, contain those, and they were very small spills. This bill has some really interesting language, right? Let's even start with the legislative declaration. The General Assembly hereby finds and declares that there are tens of thousands of active oil and gas wells in Colorado. Many different types of products that contain chemical additives are used by operators during the drilling and stimulation of these wells to break up the subsurface and extract oil and gas from the ground. This is where it gets kind of interesting. It says, while water and sand can make up the vast majority of these products, and let's just stop there. Water and sand do make up the vast majority of these products. In fact, when I was fracking, I remember the percentage of oil, or of water and sand to be 97%. In testimony while listening to this in committee, we were advised it was 99%. And what I don't think people fully understand here and I don't think the bill is written in such a way that makes it clearer, and in fact, I'm real sure they didn't have any concept of how fracking occurs. Everything that goes down the hole comes back out of the hole. We're talking water, and we're talking a solution that holds sand and ceramic nodules, little bearings, in suspense so that it doesn't pile up as you kick over the fracking effort. Because here's something else I don't think anybody understands. At least I could not decipher that anybody understood it as we read through this bill. Fracking in Colorado goes to a depth of about 8,000 feet before it kicks over. And then it can go an additional 5,000 to 8,000 feet on a horizontal. I will say in North Dakota, we actually went deeper. We went around 11,000 feet before we kicked over to a horizontal. The water table's at 400 feet. I asked the question. So we've got a water table at 400 feet. We're down below that. We are in triple and quadruple cased wells, concrete, steel, going past through the water table area. And we're going 40 times, I beg your pardon, let me do the math here. We're going 20 times deeper than the water table. So here's another thing that we're still in the same paragraph, and I'll correct it. While water and sand do make up the vast majority of these products, the amount of chemical additives injected into a well can add up to tens of thousands of gallons because of the amount of these products that are used during the course of an oil and gas operation. But again, all of this comes back out of the hole in backflow operations because it has to. First off, it's part of the plan. Second, if you didn't pull the water and the chemicals out of there, there wouldn't be room for oil to come back into the hole, and that's the point of doing this in the first place. So when I asked the question, how much water does a frac job use? The answer I got was, well, we don't know, but you probably do. Well, that's a nice answer. I appreciated that. I was trained that we use 2.5 million gallons of water on a frac job. All of that comes back out, and guess what? All of it gets used again. They have insulated water tanks around frac sites. You'll see it like a perimeter. It looks like a little fort built out of Legos, huge green Legos. I used to go out and test the water content of that water that was brought into the sites in North Dakota. I'm sure that happens here too, but that water is reused. The answer I got when I asked the question of the experts from the Oil and Gas Association was we use about 4 million gallons of water. I thought it was 2.5 up in North Dakota. I guess what's 1.5 million gallons of water among friends, right? But it all gets pulled back out and it all gets reused at the next site. And by the way, that's about what a golf course consumes in the course of a couple weeks of watering. And the difference is we get the water back when you do the fracking. So this is built off of premises of frankly, if you ask an expert, I won't call myself an expert, but I'll call myself a frac hand. This is built off of ignorance. And then they talk about PFAS materials and how problematic they are. And then somewhere in the course of this, they figure out the fracking industry doesn't even use PFAS, so we make an amendment. So what are we doing with this bill other than just adding an anvil to somebody's backpack? You know, somebody asked here, somebody made a comment that Gas is up to $4.15. Those are California prices, except they're not California prices anymore. Have a good Colorado friend of mine, been a friend of mine now since Arabic class back in 1984. He's out in California right now, and gas is $6 a gallon. So that's what we can look forward to here. We have the old California prices. We can look forward to the new California prices coming around the corner. And we'll find it in the cost of milk. We'll find it in the cost of butter. We already have. I've used this talking to constituents around the state. Bought a tub of butter for $3.50. Now it's $7. You know, I still have my commercial truck driving license, and I filled a tank or two. It's not a big deal when it's the company truck, but if you're a mom and pop, husband and wife, trucking team, and your diesel is now $6.50 a gallon, and that price is a couple of weeks old based off of a California query I made. But now you've got a tank that's going to cost you $1,200, $1,400 to fill, and you're a mom and pop operation. It makes it hard to get back from Texas when you're getting 4.5, 5 miles to gallon on your rig. We have a useful industry here. We have a workforce that is second to none in its technological prowess and in its environmental conscientiousness. I can tell you this firsthand. I hammered iron with Blue Collar America and drove trucks, and we cared about what we were doing. We worked long hours, but we always looked at safety. We always looked at the spills. And the spills were usually some kind of grease off of the pump as we were doing maintenance on it. And that's what that Titan liner was for. This is a bill that does nothing but choke an industry that we ought to admire, respect, and frankly, one that we ought to appreciate because we need it for everything that we do in this life. It has made, petroleum products have made our lives better. Try to get grandma to the hospital on a horse in today's world. You can get her to the hospital in a vehicle in a matter of minutes, a trip that used to take hours. My great-granddad died on the farm, and my great-grandmother had to walk out 5 miles to get help from somebody. We don't have to do that anymore because we have oil and gas, and we have a supplies system and a production system that is second to none. We are funding foreign entities that we fundamentally do not like and do not agree with. And yet, we were once upon a time, before day one of Joe Biden, energy independent. How do I know? I did it. And I think life was a whole lot better when we were energy independent. Inflation was not 8.5%, which is what the government is currently admitting to. Did I hear somebody call my name?
Representative Hanks, I was going to see if you could come back to the bill, please.
Well, this bill ruins everything in our economy, and so that's why I was talking about our economy, because this bill will impact it further. There's nothing in this that is demonstrably makes life better. All it is another stick in the eye of an industry that we have a need for. I wanted to start at the top. and I'll do this. We won't have Tilda do it or whatever the nickname for the machine is. A bill for an act concerning enhanced oversight of the chemicals used in oil and gas production. The bill establishes a regulatory scheme that requires disclosure of certain chemical information for products used in downhole oil and gas operations, chemical disclosure information. On or before July 31, 2023, the Oil and Gas Conservation Commission is required to utilize or develop a chemical disclosure website to collect and share certain chemical disclosure information to the public. On or after July 31, 2023, a manufacturer that sells or distributes a chemical product for use in underground oil and gas operations, parenthetical downhole operations, in the state must disclose to the Commission: Bullet 1, the trade name of the chemical product. Bullet 2, the list of names of each chemical used in the chemical product. Bullet 3, the estimated amount of each chemical used in the chemical product. And Bullet 4, a description of the intended purpose of the chemical used in the chemical product. The manufacturer must also provide the Commission with a declaration that the chemical product contains no intentionally added perfluoroalkyl or polyfluoroalkyl chemicals. For manufacturers that were already selling or distributing a chemical product for use in downhole operations in the state before July 31, 2023, the disclosure and declaration must be made at least 30 days before July 21, 2023. For manufacturers that begin to sell or distribute a chemical product for use in downhole operations in the state on or after July 31, 2023, the disclosure and declaration must be made at least 30 days before the manufacturer begins selling or distributing the chemical product. On or after July 31, 2023, an operator of downhole operations using a chemical product must disclose to the Commission the date of commencement of downhole operations. Bullet 2, the county of the well site where downhole operations are being conducted. Bullet 3, the numerical identifier assigned by the American Petroleum Institute to the well where downhole operations are being conducted. And Bullet 4, the trade names and quantities of any chemical products the operator plans to use in downhole operations. The operator must also provide the Commission with a declaration that the chemical product contains no intentionally added perfluoroalkyl or polyfluoroalkyl chemicals. For downhole operations that commenced before July 31, 2023, and that will be ongoing on July 31, 2023, the disclosure and declaration must be made at least 75 days before July 31, 2023. For downhole operations that commence on or after July 31, 2023, the disclosure and declaration must be made at least 75 days before commencement of downhole operations. The Commission will use the chemical disclosure information to create a chemical disclosure list for each well site, which will include, Bullet 1, an alphabetical list of names of chemicals that will be used in downhole operations at the well site, and Bullet 2, the total estimated amount of each chemical that will be used at the well site. The Commission will post each chemical disclosure list on the chemical disclosure website. The Commission shall provide the chemical disclosure list to the applicable operator within 7 days after the operator's disclosures. Prior to the commencement of downhole operations, the operator is required to disclose the chemical disclosure list to communities near where downhole operations will be conducted, local public water administrators, and, if there is a high priority habitat near where downhole operations are being conducted, the divisions of parks and wildlife. For downhole operations that commenced before July 31, 2023, and that will be ongoing after July 31, 2023, the disclosure of the chemical disclosure list by the operator to these entities must be made at least 60 days before July 31, 2023. For downhole operations that commence on or after July 31, 2023, the disclosure of the chemical disclosure list by the operator to these entities must be made at least 60 days before commencement of downhole operations. If a manufacturer believes that any information will be included on a chemical disclosure list is a trade secret, the manufacturer must file a trade secret claim with the Commission. If the Commission determines that the information covered by the trade secret claim constitutes a trade secret, the Commission shall not include the information on any applicable chemical disclosure list. On or before July 31, 2023, the Commission must promulgate rules that set standards for the disclosure of the chemical disclosure information to Bullet 1. An officer or employee of the United States, the state, or a local government in connection with the officer's or employee's official duties. Bullet 2, contractors of the United States, the state, or a local government if the Commission determines that the disclosure is necessary for performance of the contract or the protection of public health and safety. Bullet 3, a healthcare professional in connection with an emergency or with diagnosing a treating a patient. And Bullet 4, in order to protect public safety, a person who is employed in public health or a scientist or a researcher employed by an institution of higher education. No later than February 1, 2025, and no later than February 1 each year thereafter, the Commission shall submit and present an annual report to the General Assembly based on the chemical disclosure information. Section 1, Section 1, Legislative Declaration. The General Assembly hereby finds and declares that A, there are tens of thousands of active oil and gas wells in Colorado. B, many different types of products that contain chemical additives are used by operators during the drilling and stimulation of these wells to break up the subsurface and extract oil and gas from the ground. C, and this is the one I spoke of earlier parenthetically, while water and gas can make up the vast majority of these products, the amount of chemical additives injected into a well can add up to tens of thousands of gallons because the amount of these products that are used during the course of an oil and gas operation. Stepping out of the reading, I will say that is totally fallacious right there. If it was even close to accurate, this bill would be worth reading the rest of it. When these chemical additives are injected into a well, there is a high risk of contamination to nearby groundwater or surface water. Some chemicals used in chemical products, such as perfluoroalkyl and polyfluoroalkyl chemicals and biocides, have high aquatic toxicity and can be incredibly harmful to human health and the environment. And again, stepping out of the reading, they aren't using those, and they've said as much. 2, the General Assembly further finds and declares that A, even though exposure to these chemical additives poses a danger to public health and the environment, scientists, state and local regulators, and the public lack full access to information about the chemical additives used in oil and gas production in the state. B, while Colorado requires the reporting of certain chemical information for products that are used in hydraulic fracturing, parenthetical fracking, operations for input into a third-party database, there are broad exemptions allowed for chemical information that is deemed proprietary or confidential by the operator or supplier of a product.
Representative Hanks, if I could just interrupt you for a moment. There's been a request that maybe you step back a little bit from the microphone. It's apparently causing some disruption to folks listening outside the chamber. Thank you.
Yeah, I probably don't need the mic. D, Operators and suppliers of the products often do not have knowledge of the chemical information that they are required to report to the state. E, as a result of the amount of trade secrecy claims and the operators and suppliers' lack of knowledge. Wow, sorry, that was editorial. Let me start again. E, as a result of the amount of trade secrecy claims and the operators and suppliers' lack of knowledge of specific chemical information about the chemical additives that are used in the fracking operations in the state is vastly underreported. F, greater transparency regarding chemical use in oil and gas production is urgently needed and can be achieved by Roman numeral 1, requiring manufacturers rather than operators and suppliers to disclose information about chemicals that are used in oil and gas production in the state. Roman numeral 2, requiring the Colorado Oil and Gas Conservation Commission to gather the chemical information so that the disclosure of specific chemical information can be provided from the trade name of a product, which will thereby protect any proprietary information. And Roman numeral 3, ensuring that disclosure of the chemical information to the state, to local governments, and to schools and community in close proximity to oil and gas operations occurs before the use of the products in oil and gas operations. And G, a full inventory of the chemicals used in oil and gas production will, Roman numeral 1, assist state agencies, local governments, healthcare professionals, public health officials, and scientists in determining if highly hazardous chemicals are being used in oil and gas productions. Roman numeral 2, alert Coloradans to potential exposures of highly hazardous chemicals prior to their use. And Roman numeral 3, encourage the manufacturers and users of products that contain highly hazardous chemicals to use less toxic alternatives in future oil and gas operations.
Excuse me, Representative Hanks, sorry to interrupt you again, but we have taken some amendments on this bill, and you've run into some of that area, so I didn't know if you wanted to be apprised of that or not.
Yes, I have the amendments in hand here, Mr. Chair, and thank you. I have L005, I have L006, I have L007. I'll ask the chair, did I miss any, sir?
Yes, you have the correct ones. I just wanted to make sure you were aware of that. Please proceed.
Thank you, Mr. Chair. And in a moment of disclosure, what I intended to do is go through what we saw in the committee, add those amendments at the end, make some final remarks, talk about some fiscal notes here, and then I'll probably yield the balance of my time.
Great.
I think I was somewhere around Roman numeral 3 and 3 thereafter. Yes, therefore, the General Assembly determines and declares that the state should enact a regulatory scheme that provides full disclosure of the chemicals that are being deposited into the environment through oil and gas production because A, Coloradans have the right to know what chemicals are being deposited into the environment where they live, work, recreate, and B, state and local governments and regulators need this chemical information to adequately protect the people, water systems, wildlife, and environment of Colorado. Section 2, in Colorado revised statutes, add 34-60-132 as follows. 34-60-132, disclosure of chemicals used in downhole oil and gas operations, chemical disclosure lists, community notification, trade secret information, disclosure of chemical information to governmental agencies, healthcare professionals, and scientists, reports, definitions, rules, repeal. 1. As used in this section, unless the context otherwise requires, A1, additive means a chemical or combination of chemicals added to a base fluid for use in a hydraulic fracturing treatment. Roman numeral 2, additive includes proppants. B, quote, base fluid, unquote, means the continuous phase fluid type such as water used in a hydraulic fracturing treatment. C, quote, chemical, unquote, means any element, chemical compound, or mixture of elements or chemical compounds that has a specific name or identity, including a chemical abstract service number. D, quote, chemical abstract service number, unquote, means the unique numerical identifier assigned by the chemical abstract service to a chemical. E, chemical, I say again, quote, chemical disclosure information, unquote, means the information disclosed to the Commission under subsections 2A Roman numeral 1 and 3A Roman numeral 1 of this section. Quote, I say again, F, quote, chemical disclosure list, unquote, means a list of chemicals that an operator indicates that the operator plans to use in downhole operations at a well site. G, quote, chemical disclosure website, unquote, means a website that is capable of displaying chemical disclosure lists and can be accessed by the public. H, Roman numeral 1, quote, chemical product, unquote, means any product that consists of one or more chemicals and is sold or distributed for use in downhole operations in the state. Roman numeral 2, quote, chemical product, unquote, includes additives, base fluids, and hydraulic fracturing fluids. I, quote, division, unquote, means the Division of Parks and Wildlife in the Department of Natural Resources. J, quote, downhole operations, unquote, means oil and gas operations that are conducted underground. K, quote, healthcare professional, unquote, means a physician, physician assistant, nurse practitioner, registered nurse, or emergency medical service provider licensed or certified by the state. L, quote, high priority habitat, unquote, means habitat areas as identified by the division where measures to avoid, minimize, or mitigate adverse impacts to wildlife have been implemented or are planned to be implemented to protect breeding, nesting, foraging, migrating, or other wildlife activities. M, quote, hydraulic fracturing fluid, unquote, means the fluid, including any base fluid and additives, used to perform a hydraulic fracturing treatment. N, quote, hydraulic fracturing treatment, unquote, means all stages of the treatment of a well by the application of a hydraulic fracturing fluid under pressure, which treatment is expressly designed to initiate or propagate fractures in an underground geologic formation to enhance the production of oil and gas. O, quote, manufacturer, unquote, means the person or entity that makes, assembles, or otherwise generates a chemical product or whose trade name is affixed to a chemical product. P, quote, perfluoroalkyl and polyfluoroalkyl substances, unquote, or PFAS chemicals, has the meaning set forth in section 25-5-1302, parenthetical 7. Q, quote, proppants, unquote, means materials inserted or injected into an underground geologic formation during a hydraulic fracturing treatment that are intended to prevent fractures from closing. R, quote, public water systems, unquote, has the meaning set forth in section 25-1.5-201, parenthetical 1. S, quote, trade secret, unquote, means the whole or any portion or any phase of any scientific or technical information, design, process, procedure, formula, improvement, confidential business or financial information, listing of names, addresses, or telephone numbers, or other information relating to any business or profession that, 1, is secret and of value, 2, for which the owner of the secret has taken measures to prevent the secret from becoming available to persons other than those selected by the owner to have access for limited purposes. T, quote, type 3 aquifer, unquote, means an aquifer that consists of unconsolidated geologic material, including alluvial, colluvial, or other consolidated materials. U, quote, well site, means the area that is directly disturbed during oil and gas operations. 2, manufacturer chemical disclosure information and declaration. A, on or after July 31, 2023, and subject to subsection 2, parenthetical B of this section, a manufacturer that sells or distributes a chemical product for use in downhole operations in the state must, Roman numeral 1, disclose to the Commission, A, the trade name of the chemical product, B, the list of the names and chemical abstract service numbers of each chemical used in the chemical product, C, the estimated amount of each chemical used in the chemical product, and D, a description of the intended purpose of each chemical used in the chemical product, and Roman numeral 2, provide a written declaration to the Commission that the chemical product contains no intentionally added PFAS chemicals. B, Roman numeral 1A, for manufacturers that were already selling or distributing a chemical product for use in a downhole operations in the state before July 31, 2023, the information and declaration required to be provided pursuant to subsection 2A of this section must be provided to the Commission at least 30 days before July 31, 2023. B, this subsection 2B, Roman numeral 1, is repealed effective July 1, 2024. Roman numeral 2, for manufacturers that begin to sell or distribute a chemical product for use in downhole operations in the state on or after July 31, 2023, the information and declaration required to be provided pursuant to subsection 2A of this section must be provided to the Commission at least 30 days before the manufacturer begins selling or distributing the chemical product. C, the Commission shall make reasonable efforts to ensure that the information and declaration required to be provided under subsection 2A of this section is provided to the Commission. 3, operator chemical disclosure information declaration. On or after July 31, 2023, and subject to subsection 3B of this section, an operator of downhole operations using a chemical product must, Roman numeral 1, disclose to the Commission, A, the date of commencement of downhole operations, B, the county of the well site where downhole operations are being or will be conducted, C, the unique numerical identifier assigned by the American Petroleum Institute to the well where downhole operations are being or will be conducted, and D, the trade names and quantities of any chemical products the operator plans to use in downhole operations, and Roman numeral 2, provide a written declaration to the Commission that the chemical products contain no intentionally added PFAS chemicals. B, Roman numeral 1A, for a downhole operation that commenced before July 31, 2023, and that will be ongoing on July 31, 2023, the information and declaration required to be provided pursuant to subsection 3A of this section must be provided to the Commission at least 75 days before July 31, 2023. B, this subsection 3B Roman numeral 1 is repealed effective July 1, 2024. Roman numeral 2, for a downhole operation that commences on or after July 31, 2023, the information and declaration required to be provided pursuant to subsection 3A of this section must be provided to the Commission at least 75 days before commencement of the downhole operation. C, the Commission shall make reasonable efforts to ensure that the information and declaration required to be provided under subsection 3A of this section is provided to the Commission. 4, change in chemical disclosure information. If there is a change in the information provided under subsection 2A1, I say again, 2A Roman numeral 1 or 3A Roman numeral 1 of this section, the manufacturer or operator must submit the change to the Commission within 30 days after the date of manufacturer or operator first knew of the change. 5, chemical disclosure list. A, the Commission shall use the chemical disclosure information to create a chemical disclosure list for each applicable well site. B, the Commission shall include in the chemical disclosure list, Roman numeral 1, an alphabetical list of the names and chemical abstract services numbers of each chemicals that will be used in downhole operations at the well site, and Roman numeral 2, the total estimated amount of each chemical that an operator plans to use in downhole operations at the well site. C, the Commission shall not include in the chemical disclosure list Roman numeral 1, the trade name of a chemical product used in a downhole operations at the well site, or the Roman numeral 2, the total amount of a chemical in a chemical product. D, no later than 7 days after an operator makes the disclosures required under subsection 3 of this section, the Commission shall, Roman numeral 1, post a chemical disclosure list on the chemical disclosure website and include the date of the submission of the chemical disclosure list to the Commission in the post, and Roman numeral 2, provide the chemical disclosure list to the operator of the applicable well. E, the Commission shall, Roman numeral 1, post an updated chemical disclosure list if there are any notifications received from a manufacturer or operator under subsection 4 of this section, and include the date of the notification by the manufacturer or operator in the post, and Roman numeral 2, ensure that A, all chemical disclosure lists and updated chemical disclosure lists remain viewable to the public. B, the chemical disclosure website is searchable by chemical, date of submission, or update of a chemical disclosure list name. Well, that's poorly done. Let me try that again. B, the chemical disclosure website is searchable by chemical, date of submission, or update of a chemical disclosure list, name and address of the operator, and county of the well site. And C, the chemical disclosure website allows members of the public to download chemical disclosure lists in an electronic delimited format. 6, community notification. On or before July 31, 2023, and subject to subsection 6B of this section, an operator shall provide the chemical disclosure list to Roman numeral 1, all parties that A, are located within 2,640 feet of the well site, and B, the operator is required by rule to notify of the determination made by the director of the Commission that an oil and gas development plan is complete. Roman numeral 2, the administrator of any public water system that operates a surface water public water system intake that is located 15 stream miles or less downstream from the well site. B, a groundwater under the direct influence of a surface water public water system supply well within 2,640 feet of the well site. And C, a public water system supply well completed in a Type 3 aquifer within 2,640 feet of the well site, and 3, the division if A, there is a high priority habitat within 1 mile of the well site, or B, there is a state wildlife area as defined in section 33-1-102, parenthetical 42, or a state park or recreation area within 2,640 feet of the well site. B, Roman numeral 1A, for downhole operation that commenced before July 31, 2023, and that will be ongoing on July 31, 2023, the chemical disclosure list must be disclosed by the operator in accordance with subsection 6A of this section at least 60 days before July 31, 2023. B, this subsection 6B, Roman numeral 1, is repealed effective July 1, 2024. Roman numeral 2, for a downhole operation that commences on or after July 31, 2023, the chemical disclosure list must be disclosed in accordance with subsection 6A of this section at least 60 days before the commencement of the downhole operations. 7, trade secret claims. If a manufacturer believes that any information the manufacturer is required to disclose under subsection 2A, Roman numeral 1 of this section is a trade secret and should not be included in a chemical disclosure list, the manufacturer shall file a trade secret claim with the Commission and provide the Commission with a written description of Roman numeral 1, the extent that the information covered by the trade secret claim is known by A, the manufacturer's employees, B, the persons involved in the manufacturer's business, and C, persons outside of the manufacturer's business. Roman numeral 2, measures taken by the manufacturer to protect the secrecy of the information covered by the trade secret claim. Roman numeral 3, the value of the information covered by the trade secret claim to the manufacturer and the manufacturer's competitors. And Roman numeral 4, the amount of effort and money spent by the manufacturer in developing the information covered by the trade secret claim. B, notwithstanding any law to the contrary, the Commission shall not protect the names or chemical abstract service numbers of any chemical as a trade secret. C, if the Commission determines that a trade secret claim filed under subsection 7A of this section is incomplete, the Commission shall notify the manufacturer by certified mail. The manufacturer has 30 days after receiving the Commission's written notice to provide any missing information to the Commission. D, the Commission shall determine within 30 days after a manufacturer's trade secret claim filed under subsection 7A of this section is complete whether the information covered by the trade secret claim constitutes a trade secret. E, if the Commission determines that the information covered by the trade secret claim constitutes a trade secret, Roman numeral 1, the Commission shall not include the information in any applicable chemical disclosure list, and Roman numeral 2, the Commission may disclose the information only in accordance with subsection 8 of this section. F, if the Commission determines that the information covered by the trade secret claim does not constitute a trade secret, the Commission shall, Roman numeral 1, notify the manufacturer by certified mail of the Commission's determination, and Roman numeral 2, include the information in any applicable chemical disclosure list unless the manufacturer obtains from a court of competent jurisdiction A, declaratory judgment stating that the information is subject to protection from public disclosure, or B, a preliminary injunction prohibiting disclosure of the information to the public. G, the manufacturer shall provide notice to the Commission of any court order received pursuant to subsection 8F, Roman numeral 2 of this section. Notwithstanding any law to the contrary, nothing in this subsection 7 allows a manufacturer to refuse to disclose to the Commission the information required to be disclosed under subsection 2A, Roman numeral 1 of this section. 8, disclosure of chemical disclosure information to state agencies, healthcare professionals, and scientists. A, on or before, I say again, A, on or before July 31, 2023, the Commission shall promulgate rules setting forth standards for the disclosure of chemical disclosure information to Roman numeral 1, an officer or employee of the United States, the state, or a local government in connection with the officers or employees' official duties. 2, Roman numeral 2, contractors of the United States, the state, or a local government if the Commission determines that disclosure of the chemical disclosure information is necessary for A, satisfactory performance of a contract with the United States, the state, or a local government. Or B, the protection of public health and safety. Roman numeral 3, a healthcare professional in the event of an emergency or to diagnose or treat a patient, and Roman numeral 4, in order to protect public health and safety, a person who is A, employed in the field of public health in a governmental or healthcare agency, or B, a scientist or researcher employed by an institution of higher education who is studying the environmental health impacts of chemical products. B, a person described in subsection 8A, Roman numeral 4 of this section must submit a written statement of need to the Commission to receive chemical disclosure information. The written standards of need at a minimum must, Roman numeral 1, identify the specific chemical disclosure information that is sought by the person, and Roman numeral 2, describe the reason that disclosure of the specific chemical disclosure information is necessary for public health or research purposes. C, a healthcare professional described in subsection 8A, Roman numeral 3 of this section may share the chemical disclosure information with other persons, including with the patient and other healthcare professionals, as may be professionally necessary to diagnose or treat a patient, except as prohibited under applicable federal or state law. 9, reporting to the General Assembly. A, Roman numeral 1, the Commission shall prepare an annual report that includes A list of chemicals used in downhole operations in the state in the prior calendar year. B, an approximate amount of each chemical used in downhole operations in the state in the prior calendar year. A description of the concentration of the use of each chemical in the areas throughout the state in the prior calendar year. And D, the number of trade secret claims received by the Commission under subsection A of this section in the prior calendar year. 2, no later than Roman numeral 2, no later than February 1, 2025, and on or before each February 1 thereafter, the Commission shall A, submit and present the report prepared pursuant to subsection 9A, Roman numeral 1 of this section to the Energy and Environment Committee of the House of Representatives and the Transportation and Energy Committee of the Senate or any successor, and B, post the report on the Commission's website. B, notwithstanding section 21-1-136, parenthetical 11A, Roman numeral 1, the requirement to report to the legislative committees continues indefinitely. Rules. The Commission may promulgate rules that are necessary for the implementation and administration of this section. Section 3, Safety Clause. The General Assembly hereby finds, determines, and declares that this act is necessary for the immediate preservation of the public peace, health, or safety. So what I want to say about this, I may go through the amendments, but before I do, and maybe I'll overlook the amendments and just close with some comments. We are not talking the Exxon Valdez here, where you have, and statistically, transporting oil is a much higher risk of spilling oil than actually producing oil. We had mostly hydraulic pump leakages onto our Titan liners. We had, in my experience, never had any kind of downhole leakage. We are well under the water table. The wells are cased and cased and cased outside of that, triple, quadruple cased near the water table. The people that work in the oil and gas industry, the blue-collar frackers, truck drivers, they're friends of mine, at least those I worked with. And let me tell you about those guys I worked with. They were conscientious. We worked hard. And the environment mattered. This country matters to us. How it looks matters to us. But also producing energy that can get grandmother to the hospital, that can get food and clothing to the stores and the supply centers are important to us. We knew the value of what we're doing. This bill goes off of rather capricious ideas of what fracking is, gross ignorance of what downhole operations is and what backflow operations are. Frankly, the depth of the well versus the depth of the water table, without knowledge of how much water's used. I mean, there's a lot of reasons to strike this down. Oh, let's not forget PFAS. They don't use it. And that was really seemingly the impetus for this bill in the first place. And then we find out they don't even use it in fracking. We should have known that before something like this was drafted, in my opinion. I urge a no vote on House Bill 22-1348.
Representative Will.
Thank you, Mr. Chair. It's an honor to serve with you.
Honor to serve with you, sir.
I wanted to come back up and talk a little bit more about the industry and some of the things that have happened and improvements over the years, but I want to talk about some emissions innovations and emissions reductions. And several of those innovations that have occurred, especially along the Colorado Front Range, but also on the western slope, included but not limited to tankless production, low bleed pneumatics, electric powered drill rigs, electric pumping engines, fence line and community air monitoring, water recycling. My colleague, Mr. Hanks, talked about the millions of gallons used in a frac job and how that water is reused in the water recycling. And that all those processes happen, I know of all the wells I've been around on the western slope. So it's beneficial water reuse, and we use solar PV and battery storage for monitoring and small pump operations. All the remote sensing that are done in those wells, rather than having to have vehicle trips in and out of those wells, some of that remote sensing is all done with solar PV and battery storage for monitoring. Increased pipeline usage to reduce truck traffic. That's especially true in fracking operations, especially true. And light mitigation, we see that especially if it's near homes or development, is light mitigation. Noise barriers, quiet hydraulic fracturing equipment, and then a lot of community coordination to identify, plug, reclaim old vertical wells. We're talking about that a lot this year, right here in the House floor, about plugging some of these wells that are no longer in use. There's a lot of other emerging technologies and applications that are forthcoming. It's not possible in all circumstances, but operational efficiency has really been improved in all these well sites to significant emission reduction that leads to less ozone formation and less global climate. According to the International Energy Agency, the United States saw the largest decline in energy-related CO2 emissions in 2019 on a per-county basis. In fact, advanced economies, we're seeing good success in their emission reduction efforts. Part of that is due to fuel switching to natural gas, which is a low-carbon fuel. Most climate concerns about natural gas relate to methane emissions. But according to the EPA, methane emissions are being reduced while production of natural gas increases. On a statewide basis for Colorado, we're making significant strides here in Colorado. Methane is emitted with volatile organic compounds, VOCs. You hear about the VOCs, which contribute to ozone formation. So controls to mitigate these VOCs also mitigate methane. And to provide both air quality and global climate change benefits, from 2011 to 2017, Colorado's oil and gas, natural gas industry saw nearly a 50% reduction in emissions. So in that 6-year period, a 50% reduction in emissions, with models out to 2023 projecting further decreases, particularly in non-containment areas like we're in here in Denver. One way to reduce emissions is to reduce the venting and flaring. That's already occurring on the western slope. Venting natural gas occurs for safety reasons due to excess pressures unless control equipment is installed on site. That's being installed on sites now. Flaring is a common way to mitigate that venting and is accomplished by a controlled burn, reducing emissions that would otherwise be vented directly into the atmosphere. No longer happening over there. There's an economic incentive to limit venting and flaring, and in the charts above, it's clear that Colorado oil and gas operations are national leaders when it comes to keeping product and production in a pipeline. So looking at Colorado specific flaring data from 2015 to 2019, local operators have maintained very low flaring rates. In fact, while the national average was at 4.75%, that's the national average, Colorado oil and gas companies flared only 0.2% in 2019, 0.2. So leak detection and repair. Another way to reduce emissions is a strong leak detection and repair practices. Methane makes up 84% of leaks associated with oil and gas development. So detecting those leaks and fixing them quickly is important. That's happening in this state. 2014, Colorado is the first state in the country to establish leak detection and repair requirements. According to the State Health Department, more than 2.2 million inspections at Colorado oil and gas locations occurred between 2014 and 2018. That's in a 4-year period. 2.2 million inspections. In fact, there were about 30,000 inspections in 2018 alone, with leaks reported in only 3.2% of the time on those inspections. So about a 3% detection in leaks out of roughly 730,000 inspections. So in 2019, the numbers compiled and finalized later in 2020, but total inspections up to 2020 was about closer to 3 million inspections. So another metric for understanding oil and gas emissions is by looking at emissions intensity. In short, this is calculated by dividing the CO2 equivalents produced per barrel of oil, and it's important to note that oil and gas formations are different from one another, and there's no apples-to-apples comparisons when using this metric. And there's, those are different layers, different formations, the different geology, different depths, different techniques, When oil and gas first started, directional drilling was unheard of. Now it's common. It's such a good thing because most of these sites now in a field, there's about 32 wells per site. That's because of directional drilling. So the technology is getting better. The footprint of the oil and gas production is so much smaller. Years ago, and it's 32 wells would have been 32 sites, 32 well pads. Now it's one pad with 32 wells on it going out in these formations. So the technology is getting so much better. And energy density can be expressed as amount of energy generated per acre or the number of acres needed to produce 1 megawatt of energy, including related mining, transmission, capacity factors, and waste. Coal, nuclear, and natural gas all feature the smallest physical footprint of about 12 acres per megawatt produced. 12 acres per megawatt produced. And that's for coal, nuclear, and natural gas. For solar and wind, use about 43 to 70 acres per megawatt, respectively. And hydropower from large dam uses about 315 acres per megawatt. Contemporary decision-making about constructing electric generation plants facilities are rarely considered the value that comes from the energy density. These technology and high energy density result in smaller surface impacts. They allow for increased efficiency with economies of scale. Colorado is a national leader in its commitment to safe and responsible development of Colorado's oil and gas natural resources. Over the past decade, Colorado has implemented precedent-setting regulations from baseline groundwater testing. I've experienced that right next to my home as well. And monitoring air regulations, targeted methane leak detection. I just talked about that, the leak detection. The rules are widely viewed as some of the most rigorous in the country and around the world. So let's be producing this natural gas right here locally and within our state because it's the cleanest we're going to get anywhere. So I stand in strong opposition to this bill. Thank you.
Is there any further discussion? Seeing no further discussion on House Bill 1348, the question. Yes, Representative Rich.
Thank you, Mr. Chair. I rise in opposition to House Bill 1348. You know, rather than improving the pre-existing database, this bill creates a new chemical disclosure list that must be completed by the Colorado Oil and Gas Commission, Conservation Commission. Now, current law allows companies to apply for exemptions to conceal specific fracking fluid ingredients if they are classified as trade secrets. But this bill goes after trade secrets by giving the Commission the authority to determine whether the info is covered by a trade secret claim constitutes a trade secret. You know, this bill is another example of this state meddling in business. I ask for a no vote.
Seeing no further discussion, the question before us is the adoption of House Bill 1348. All those in favor say aye. Aye. All opposed say no. No. 1348 is adopted. Mr. Shebo, please read the title to House Bill 1260.
House Bill 1260 by Representative Froelich, also Senator Simpson and Fields, concerning ensuring students have reasonable access to medically necessary services in schools.
Thank you. Representative Froelich.
Thank you, Mr. Chair. I move House Bill 1260 and the Education Committee report.
To the Education Committee report.
Thank you, Mr. Chair. The Education Committee report is essentially the bill. We did a strike below that brought opposition to neutral. And I ask for a yes vote.
Thank you. Seeing no further discussion, the question before us is the adoption of the Education Committee report to House Bill 1260. All those in favor say aye. All opposed say no.
Aye.
The Education report is adopted. To the bill, Representative Froelich.
Thank you, Mr. Chair. This bill is really about children quite a few of them with autism spectrum disorder diagnoses, seeking medical treatment at and during school in order to be able to properly live their school experience. The bill indicates quite specifically that these are medically necessary treatments. They are covered by insurance and Medicaid. It's really comparable, if we think of it, to oxygen. You would never say to a student, you should get your oxygen when you're not at school. These are critical components to a student's success, and this bill is about laying out a pathway for parents to be able to access these services. And this bill is about parents trying to ensure that their children can make the most of their lives and their school experience. I would say that the opposition to the bill and the negotiating process was discouraging. And to hear in committee have a committee member, one of our members addressed by expert witness from the education community to say, you would have to be an idiot if you can't figure out how to dispute an IEP. That's not what we're going for, and we want to move forward and allow parents a proper access to this treatment and a path forward. I ask for a yes vote.
Thank you. Any further discussion on House Bill 1260? Seeing none, the question before us is the adoption of House Bill 1260. All those in favor say aye. Aye. All opposed say no. House Bill 1260 is adopted. Mr. Shebel, please read the title to House Bill 1077.
House Bill 1077 by Representatives Michelson, Janae, and Judah, also Senators Priola and Hansen, concerning the creation of the Colorado Nonprofit Security Grant Program for qualified nonprofit organizations at high risk of a terrorist attack who applied for but did not receive a grant from the Federal Nonprofit Security Grant Program.
Thank you. Representative Michelson, Janae.
Thank you, Mr. Chair. I move House Bill 1077 and the Appropriations and Public and Behavioral Health and Human Services Committee reports.
To the Appropriations Report. Representative Judah.
Thank you, Mr. Chair. Appropriations was kind enough to appropriate $500,000 to implement the program and help out our houses of worship.
That is kind. Any further questions on the Appropriations Committee report to House Bill 1077? Seeing none, the question before us is the adoption of the Appropriations Committee report. All those in favor say aye.
Aye.
All opposed say no. Appropriation. Thank you. The Appropriation report is adopted. To the Public and Behavioral Health and Human Services report, Representative Michelson, Janae.
Thank you. In the Public and Behavioral Health and Human Services Committee, we ironed out all of the details that needed to be fixed so that we could make sure that this program was available to people who were unable to get funded through the federal program for security grants. We ask for an aye vote.
Thank you. Any further discussion on the Public Behavioral Health and Human Services report? Seeing none, the question before us is the adoption of the Public Behavioral Health and Human Services report. All those in favor say aye.
Aye.
All opposed say no. The report is adopted. To the bill, Representative Judah.
Thank you, Mr. Chair. I think for both of us, my co-prime and myself, this bill was very personal to us. I think really in the wake of 9/11 and probably decades before, mosques around really the country and especially here in Colorado have been targeted violently, and we've gone from everything gun-wielding people outside mosques to unfortunately pig heads stuffed on our gates. And it's very Islamophobic, but is not exclusive to mosques. Unfortunately, a lot of other houses of worship are experiencing a lot of the same things. So for me, it's about safety and security and making sure we're protecting hollow ground.
Thank you. Representative Michelson, Janae.
Thank you, and I'm so honored to work with my co-prime on this. This is very personal for both of us. You may recall not that long ago, there was a young man who was killed right outside of the yeshiva in North Denver, and he was in an area that the yeshiva had applied 4 times for the federal funding for security for a gate. All they had been applying for was funding for a gate. Had that gate been there, this young man would have been protected and likely would not have lost his life. We are asking for you to consider an aye vote as we work to protect all of those people who deserve to pray freely and without fear of death.
Thank you. Seeing no further discussion, the question before us is the adoption of House Bill 1077. All those in favor say aye.
Aye.
All opposed say no. House Bill 1077 is adopted. Madam Majority Leader.
Thank you, Mr. Chair. I move to lay over House Bill 1392 bills.
House Bill 1390 will be laid over upon the request of the Majority Leader. Mrs. Schubel, please read the title of House Bill 1254.
House Bill 1254 by Representative Valdez-A, also Senators Winter and Priola, concerning regulation related to the ownership of a vehicle.
Representative Valdez-A.
Thank you, Mr. Chair. I move House Bill 1254 and the Appropriations Report.
To the Appropriations Report.
Well, we got a little bit of money appropriated to us to implement this program.
Thank you. Seeing no further discussion, the question before us is the adoption of the Appropriations Committee report to House Bill 1254. All those in favor say aye.
Aye.
All opposed say no. The Appropriations Report is adopted. To the bill, Representative Valdez-A.
Thank you very much, Mr. Chair. This is a great bill. This is a rerun, as you would call it in this context. This bill came through last year. It had a large Tabor impact, and unfortunately it got the dreaded V word. What this does is it essentially updates some of our statutes. It updates statutes to ensure that expired temporary tags is a fine. You have to register your car. It ensures that when people are registering their car, we find out when they became residents of Colorado, so we collect the correct amounts of tax, and I'd ask for an aye vote.
Thank you. Seeing no further discussion, the question before us is the adoption of House Bill 1254. All those in favor say aye. All opposed say no. Thank you. House Bill 1254 is adopted. Mr. Shebel, please read the title to House Bill 1359. Representative Bacon and Snyder.
House Bill 1359 by Representatives Bacon and Snyder. Also Senator Rodriguez. Concerning the creation of the Colorado Household Financial Recovery Program.
Well done. Sure bill. Oh. Stand by. Sorry.
I get started.
Okay. Representative Snyder.
Thank you, Mr. Chair. And may I just say what a distinct honor and pleasure it is to work with you.
The pleasure is mine. Thank you.
Thank you, sir. So I will move House Bill 221359, the Finance Committee report, as well as the Appropriations Committee report.
To the Appropriations Committee report.
Thank you. So we did take some amendments in appropriations today. One was to increase the administrative cap, and the other was to get a appropriation of money. So I ask for a yes vote on the Appropriations Committee report.
Thank you. Seeing no further discussion, the question before us is the adoption of Appropriations Committee report to House Bill 1359. All those in favor say aye.
Aye.
All opposed say no. Thank you. The Appropriations Committee report is adopted. To the Finance report, Representative Snyder.
Thank you, Mr. Chair. Yeah, so we had a wonderful hearing in Finance Committee, and that we did take an amendment there, and it was approved, and so I would ask for approval of the Finance Committee report.
Thank you. Seeing no further discussion, the question before us is the adoption of the Finance Committee report to House Bill. Okay, we have further discussion on the Finance Committee report by Representative Bacon. Thank you for joining us.
This is.
Thank you.
Representative Bacon.
Thank you. I actually have an amendment to the committee report. I'd like to move L3 and have it displayed. It's not a big deal.
Okay.
You just need to strike. It's duplicative.
Thank you. That is a proper motion. Amendment L003 is now before us. Representative Bacon.
Thank you. Members, I'm sorry? Good? Okay. Sorry, this is just actually to strike duplicative language that was brought to our attention by the drafter.
Thank you. Any further discussion on Amendment L003 to the Finance Committee report? Seeing none, the question before us is the adoption of Amendment L003. All those in favor say aye.
Aye.
All opposed say no. Thank you. Amendment L003 is adopted. To the Finance Committee report. Okay. Seeing no further discussion on the Finance Committee report, the question before us is the adoption of the Finance Committee report. All those in favor say aye.
Aye.
All opposed say no. The Finance Committee report is adopted. To the bill. Representative Bacon.
Thank you, members, and thank you for your patience. House Bill 1359 is actually a really exciting opportunity to be able to support our neighbors as they continue to move through the negative and potentially harmful impacts of the pandemic. This bill addresses the need of our neighbors as consumers, whereas over the last couple of years, we have been able to provide financial supports for small businesses, even to the extent of thinking about housing. But this bill is primarily a program created with state funds in partnership with philanthropies, in partnership with private entities, to be able to offer manageable loans, what we would call bridge loans and small loans, no more than $5,000, to consumers that have been historically underbanked or have had difficulties in accessing capitals through traditional banks. So ultimately, again, 1359 is really setting up people to be able to borrow that grocery money, to be able to borrow rent dollars at a really low rate that is much lower than perhaps using a credit card or payday loans. And even though the rate is lower, it is still higher than what they may be able to access at traditional banks. Ultimately, we worked really hard along with the Bell Policy Center. We had many conversations with banks and the nonprofit lending community, along as, again, philanthropies out in the state. Really think this is an incredible opportunity to help our neighbors. So ultimately, we hope that we can earn your vote in support of House Bill 1359.
Thank you. Representative Snyder.
Thank you, Mr. Chair. And I think it's really important to understand this is a trend we're seeing a lot these days, especially this year. But the money that the state will be putting into this program will be working through the CDFIs, the Colorado Development Financial Institutions, which are an outgrowth of the Community Reinvestment Act that puts requirements on our banking institutions. But much like the Climber Fund, which was another program administered by the Treasurer's Office, this, we think, will be, our state money will be leveraged several times over. There's a lot of interest from these community, these CDFIs. And, you know, in the Climber Fund, we were looking at basically a 5-to-1 match with private investment money. And I think we might accomplish something very similar to that ratio with this project. So it'll be a lot more money into the system. And ultimately, what this one of the great benefits of this is for these, you know, people from lower incomes and others who have not participated in the economic recovery to the same level as others, it will really get them, in some cases, their first exposure to a banking institution. So we're hoping it'll have a lot of secondary effects and would ask for your support.
Thank you. Seeing no further discussion, the question before us, the adoption of House Bill 1359. All those in favor say aye.
Aye.
All opposed say no. House Bill 1359 is adopted.
It worked out.
Madam Majority Leader.
Thank you, Mr. Chair. I move to lay over House Bill 1390, one bill.
Okay. House Bill 1390 will be laid over one bill. Mr. Shi will please read the title to House Bill 1361.
House Bill 1361 by Representative Basenecker, considering measures to enhance oversight of oil and gas operations within the state.
Representative Basenecker.
Thank you, Mr. Chair. I move House Bill 1361, the Energy Environment Committee report, and the Appropriations Committee report. Just energy
There's
and
no
environment.
appropriation report. To the Energy and Environment report.
Thank you, Mr. Chair. In Energy and Environment, we had a great discussion about the bill. We were able to adopt several amendments which moved industry to a monitor position on the bill and also kept our environmental friends happy. And so we were pleased to accomplish that work. I'd ask for your support.
Thank you. Seeing no further discussion, the question before us is the adoption of the Energy and Environment report to House Bill 1361. All those in favor say aye. Thank you. All those opposed say no. The report is adopted. To the bill, Representative Basenager.
Thank you, Mr. Chair. This bill ultimately was set up a performance audit to be conducted by the Office of the State Auditor. What this bill seeks to do is deliver key data to the General Assembly in regard to oil and gas production data, emissions data, enforcement actions, as well as providing a clear understanding of current gaps and areas of opportunity in relation to interagency communication and data sharing. I firmly believe that good policy is derived from good data, and this bill will deliver just that. It's important to note that industry came to the table with good intention, as did our environmental friends in this space, and we were able to negotiate a bill that actually allowed for an audit to move forward in a way that had industry at a monitor position and our environmental friends in support. I think what this honestly will do is facilitate a timely review of successes in this space and as a result of past efforts and audits, while also identifying future opportunities to ensure compliance and accuracy. We all agree that oil and gas operation is a critical industry in our state in regards to how it impacts our communities, and this bill will deliver an audit that seeks to give us good data about what next steps might be, both in terms of oil and gas activity, but also in terms of our state agencies, where there are gaps right now in communications. So I'd ask for your support.
Thank you. Representative Ransom.
Thank you, Mr. Chair. And folks, I just want to point out one thing in this bill. I understand that it started out to be a larger bill, and I talked to the sponsor, and he explained that in trying to get different people on board, it was carved down to just an audit. My question had been why it didn't just go through our audit committee. But one thing I do want to point out, and I'm more than happy to share the canary sheet that we were given for Appropriations Committee this morning. I just want to point out that this year, this bill has actually a very small financial impact of $4,100. But then it says that there's a significant cost increase in the second year. That is for the actual audit piece, I'm presuming. But I just want to let you know that when we've been hearing things about like structural deficit, possible recession, things like that, I just want to make sure that everybody here recognizes that passing this bill would bring what is literally given to us by our staffers across the street, a significant cost increase in the second year. So thanks so much.
Thank you. Representative Pico.
Thank you, Mr. Chair. I'd just like to drill into this another one.
That's a $5 fine. Please continue.
Thank you, Mr. Chair. I appreciate that. To build on what was just said a few minutes ago, there is a structural deficit that this builds into the budget. And it fundamentally is down to where, even I can say, hey, an audit is fine, but we don't need legislation to have an audit. We do have an audit committee. That is something that could be done. At this point, this is a bill that doesn't really have a purpose other than to mandate legislatively what we already have a process for to do, to use the audit committee, put this in there. So let's vote this down. We don't need additional legislation. We don't need bills that do what we can already do, and we certainly don't need a bill that adds deficit dollars in the years ahead. Vote no.
Thank you. Representative Wook.
Humu humu nuku nuku apu a. There are people listening. It was once Hawaii State Fish. I'm sorry. I urge a no vote on this bill. Thank you.
Thank you. That's a $5 fine, too. Representative Will. Representative Will.
Mr. Chair, it's a true honor to serve with you.
The honor is mine, sir.
It's such an honor that I hope I don't get fined because the previous two got fined. So here goes. I heard this bill in the Environment, Energy and Environment Committee, and was a no vote. I mean, I do think this bill it does nothing more than double dipping of existing regulatory policies and reporting policies. You know, if you talk to the people that work in this field and in this industry, they'll tell you that Colorado's oil and gas provides some of the cleanest in the nation and in the country. And definitely when you extrapolate that out worldwide, it's definitely the cleanest. So I just think it's repetitive reporting and just some other regulations that the industry just doesn't need. And I don't see that this bill does it. So I strongly ask for a no vote on the bill.
Thank you. Representative Basenecker.
Thank you, Mr. Chair. With due respect to my colleagues, there is no additional regulation in this bill. There is no additional requirements in this bill. Industry 2023 looks the same as 2022, looks the same as 2024. So I want to make that clear. In addition, existing policy stands in place in this bill. So if oil and gas is indeed, as we've heard, the cleanest operator in the state, and I won't argue that because I don't need to argue that because the data will show that. And so that's exactly what the audit will deliver for us is good data in this space. I think honestly it will deliver good results in terms of ministerial reporting compliance, and we look forward to highlighting those successes. We know that there are issues with reporting in regard to our state agencies. This bill is not duplicative. It actually creates processes and a performance audit to understand how information comes into each of our state agencies, but is never shared across those agencies at present. So that is the piece which is absolutely not duplicative. And lastly, I'll just mention this, the cash impact in the second budget year, OSA has ensured us that they can accomplish this within existing appropriations. There is no balloon at the end. We've accounted for this, and we do believe that we're in good shape fiscally. So I'd ask for your support.
Thank you. Minority Leader McKean.
Well, thank you very much. You know, I've been working on another bill that brings up some reporting requirements, and we were immediately met with, well, if that takes more time to do that, then it's imposing a cost. So it might not be regulation, but it might actually be imposing a cost on an industry that's already very much burdened. And I guess my big question is this going to paint a picture of production? Is it going to paint a picture of the cost of regulation? Is it going to paint a picture of what does the future horizon economically look like as we decimate this industry?
Thank you. Representative Basenecker.
Thank you. Page 4 and 5 of the bill list out the audit, performance audit pieces that you can look at in terms of what the OSA is going to look at in the scope. And there are no additional reporting requirements. Industry will simply turn in the pieces of information that they do now to our state agencies. Our state agencies turn that information over to OSA, and that's where the information flows from. So there's no additional burden on industry in this bill.
Thank you. Seeing no further discussion, the question before us is the adoption of House Bill 1361. All those in favor say aye. Aye. All opposed say no. No. House Bill 1361 is adopted. Madam Majority Leader.
Thank you, Mr. Chair. I move to lay over House Bill 1390, another bill.
We will continue to lay over House Bill 1390 one more time. Mr. Sheba, please read the title to Senate Bill 184.
Senate Bill 184 by Senators Fenberg and Pedersen, also Representatives Esgar and Tipper, concerning authority for a member of the General Assembly to be absent during the legislative session without forfeiting compensation.
Thank you. Majority Leader Esgar.
Thank you, Mr. Chair. I move Senate Bill 184.
To the bill.
Thank you, Mr. Chair. Members, this bill ensures that legislators who opt to take parental leave are still eligible for full compensation. This has been an issue for years. We are finally taking care of it and letting parents across Colorado know that they too can serve in the legislature if they have a child.
Thank you. Representative Tipper.
Thank you, Mr. Chair. And one of the questions I received was if an individual is absent for an unapproved reason, if their pay would still be docked. The answer to that is yes. You have to seek approval from leadership in order for an approved absence. I ask for a yes vote.
Thank you. Seeing no further discussion, the question before us is adoption of House Bill 184. All those in favor say aye. Aye. All opposed say no. House Bill 184 is adopted. I'm sorry. Senate Bill 184 is adopted. Thank you. Majority Leader Esgar.
Thank you, Mr. Chair. I move to lay over House Bill 1392 bills.
Okay, we are continuing to lay over House Bill 1390. Ms. Cheever, please read the title to Senate Bill 194.
Senate Bill 194 by Senators Story and Fields, also Representatives Valdez D. and Hooton, concerning allowing unencumbered money in the Creative Industries Cash Fund that is credited to the fund from the Capital Construction Fund for the purposes of the Art and Public Places Program to be available for expenditure for 3 fiscal years.
Representative Hooton.
Thank you, Mr. Chair. Members, in the NO edit, we
Please
have
move the bill first, Representative Hooton.
Go ahead. Yes, Mr. Chair, I move Senate Bill 194.
Thank you. To the bill.
Thank you. Members, Senate Bill 194 comes from the Capital Development Committee, and what it does is it allows the Office of Creative Industries in OEdit to hold on to unencumbered funds that they receive through capital construction projects for up to 3 years. And this is the case for all capital development funded projects in the state of Colorado. A small percentage of their funds go to support the Arts and Public Places program, and they have 3 years to spend the funds that they receive from the state, and we are extending that same privilege to the Creative Industries Cash Fund. I urge an aye vote.
Thank you. Representative Valdez D.
Thank you, Mr. Chair. It's an honor to serve with you here today.
Honor to serve with you, sir.
Absolutely. Thank you to my colleague, Representative Edie Hooton, for moving Senate Bill 194, as this is a good bill, not only to make sure the process continues for 2 years for creative industry in all our communities, to make sure that the art, the influence continues to evolve and grow in more ways than one. And with that, we ask your support on Senate Bill 194.
Thank you. Is there any further discussion on Senate Bill 194? Seeing none, the question before is the adoption of Senate Bill 194. All those in favor say aye.
Aye.
All opposed say no. Senate Bill 194 is adopted. Mr. Shebel, please read the title to Senate Bill 162.
Senate Bill 162 by Senators Enzinger and Kirkmeyer, also Representatives Woodrow and Lynch, concerning the modernization of the terminology used in the Colorado Revised Statutes relating to the organization of Colorado state governmental agencies without altering the status of the powers assigned to those agencies pursuant to the Administrative Organization Act of 1968.
Thank you. Representative Lynch.
Thank you, Mr. Chair. It's an honor to serve with you. I would like
Honor to serve with you.
I would like to move Senate Bill 162 and the State Civic, Military, and Veterans Affairs Committee report.
To the committee report.
Thank you, Mr. Chair. So in the, this is one of those SRC things where we're going through and fixing up a bunch of stuff. In the committee, there was basically a typo in what, in the type of agency the behavioral health is. It changed that to a type 2 and then changed the associated language once that change was made.
Thank you. Any further discussion on the State Civics, Military, and Veterans Repair Committee report? Seeing none, the question before is the adoption of the committee report to House Bill 162. All those in favor say aye.
Aye.
All opposed say no. The State Civic, Military, and Veterans Affairs Committee report is adopted. To the bill, Representative Lynch.
Thank you, Mr. Chair. So once again, this basically updated the language from really the Administrative Organization Act of 1968, and in the definition and the types of our government entities from Type 1 and Type 2, there was some kludgy language in there that made it, really got rid of the archaic Type 3 transfer and then makes conforming amendments to go along with that. I would like to say, however, there has also been a more recent change, so I would like to offer, or I would like to move Amendment L005.
That amendment has been properly moved. Is now before us to Amendment L005. Representative Lynch.
Thank you, Mr. Chair. So really simple change on page 100 of the bill. It basically, the article was off. It it corrects it and makes it say Article 35 instead of Article 1. It was purely an oversight from OLLS, and they asked for us to make that correction. I would ask for an aye vote.
Thank you. Seeing no further discussion, the question before is the adoption of Amendment L005 to House Bill 162. All those in favor say aye.
Aye.
All opposed say no. The amendment is adopted. To the bill, Representative Lynch.
Thank you, Mr. Chair. Other than this just being a good bill and a yes vote, I think that's all we got.
Thank you. Seeing no further discussion, the question before is the adoption of Senate Bill 162. All those in favor say aye. Aye. All opposed say no. Senate Bill 162 is adopted. Majority Leader Escar.
Second verse, same as the first. Mr. Chair, I move to lay over House Bill 1390, one bill.
Okay, we are still laying over House Bill 1390 at the request of the Majority Leader. Mr. Cheeble, please read the title to Senate Bill 169.
Senate Bill 169 by Senator Donovan, also Representatives Will and Hooton, concerning the non-disclosure of sensitive species information under the Colorado Open Records Act.
Representative Will.
Thanks, Mr. Chair. It's an honor to serve with you.
Honor to serve with you, sir.
I move Senate Bill 22-169.
To the bill. Representative Hooton.
Thank you, Mr. Chair. Members, what this bill does is put some guardrails around core requests for Colorado's endangered wildlife and plant species. Historically, Parks and Wildlife receives about 7 core requests a year. Since COVID, they are averaging 300 requests a year. And while some are researchers and nonprofits who have a legitimate reason to request data on the location of plant species and wildlife, many requesting doing these core requests are looking for precise locations of Colorado's wildlife. Always not with the best intentions. So what the bill does is it just tightens up these core requests. We worked an amendment out on the Senate side with the media because, of course, they would have a real interest in core requests. So we adopted their amendment to everyone's satisfaction. And we clarified some concerns from several other communities, which I'll let my co-prime speak to.
Thank you. Representative Will.
Thank you, Mr. Chair. And I'm really happy to be in this bill with my co-prime, Representative Hooton. And actually just presented this bill yesterday in Ag. And it's probably one of the most important bills I've carried down here because it helps Colorado Parks and Wildlife protect its ability to perpetuate and preserve our state's incredible wildlife resource. You know, it's Representative Hooton mentioned the number of core requests. I can tell you at the tail end of my career with CPW, the core requests virtually keep you from doing your job. You have to fulfill those core requests. Basically, can't do the rest of your job. So, and this is really important. You know, the researchers and the wildlife biologists out there that are the backbone of that agency. Trying to achieve the mission, we need to constantly collect and maintain data, and we don't need to be sharing that all the time with everyone that has a core request. Maybe it was mentioned yesterday by Director Vilsack about, and I've had many of these too. It's really common, but people want exact locations, especially kill locations of a bighorn sheep or Rocky Mountain goats or moose or whatever, and they're wanting. They're and bombarding the agency with requests of where these locations are. And it just doesn't, that's not the use of that. We'll see it, I think, as the wolves with the wolf reintroduction. We'll see a lot of requests in that fashion as well. A lot of times, especially with large predators, bears and lions, there's a lot of interest in there. With those species, when you have a GPS collar on them or whatever, people wanting that information. Is a bear close to my house? Is a mountain lion close to where my grandkids play, et cetera, et cetera. So those type of requests for information just can't be fulfilled and won't be. So this is really important, especially for like Gunnison, sage grouse, Lex, that type of information. We don't want that to get out. Also, Edie mentioned rocket. Yes, goes to rocket, plant species. So this is a really good bill, and
Fair chase is a good one.
yeah, we talked a little bit in committee about fair chase and ethical sportsmanlike activities. So, and this for the North American model of wildlife management and fair chase. This is kind of information needs to remain within the biologists and the researchers that are using this information and collecting this data. So I strongly ask for an aye on this bill. Thank you.
Thank you. Seeing no further discussion on Senate Bill 169, the question before us is the adoption of Senate Bill 169. All those in favor say aye.
Aye.
All opposed say no. Senate Bill 169 is adopted. Madam Majority Leader.
Thank you, Mr. Chair. I move to lay over Senate Bill 1390, House Bill 1390. Two bills.
Okay, 1390 will be laid over two bills as requested by the Majority Leader. Madam Majority Leader.
Thank you, Mr. Chair. I move to lay over Senate Bill 174 till the end of the calendar, special orders calendar.
Senate Bill 174 will be laid over as requested. Madam Majority Leader.
I just messed this up. I apologize. I move Senate Bill 2 until tomorrow, April 27th.
Okay, Senate Bill 2 will be laid over until tomorrow. Madam Majority Leader.
And one more. Excuse me, Minority Leader. Thank you. I lay over House Bill 1390, two more bills.
Okay, 1390 will be laid over two more bills as requested. Mr. Sheba, please read the title to Senate Bill 8.
Hi, how are you?
Senate Bill 8 by Senators Enzinger and Priola, also Representatives McLaughlin and McKean, concerning post-secondary education support for certain students who have been in out-of-home placement and in connection therewith making an appropriation.
Representative McLaughlin.
Thank you, Mr. Chair. I move Senate Bill 22008 and the Appropriations and Education Report, please.
Thank you. To the Appropriations Committee report. Representative McLaughlin.
The Appropriations Committee report, we started off with 5 employees needed. We cut it back to 4 employees needed, and we saved the state a lot of money. So there's that.
We did.
Thank you. Seeing no further discussion, the question before us is the adoption of the Appropriations Committee report to Senate Bill 8. All those in favor say aye.
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 Thank you. All opposed say no. Appropriations Committee report is adopted. To the Education Committee report. Minority Leader McKean.
Thank you very much, Mr. Chair. In House Education, we put on a couple of amendments. What we really did was a minor cleanup, and then we talked about the Navigator Office and talked about just navigators and who it is that we need to do this work. I ask for an aye vote.
Thank you. Seeing no further discussion, the question before us is the adoption of the Education Committee report to Senate Bill 8. All those in favor say aye.
Aye.
All opposed say no. The Education report is adopted. To the bill. Representative McLaughlin.
Yes, this is a bill that was brought to us by COYAC, students who are really involved in government. And this will help, this will give navigators around the state to help our foster youth find a college, take the tests that get into college, and then once they are in, it will actually pay for the college and all the other expenses that come with it, the housing and the food and things like that. And it'll be a great service to our foster youth, many of them who never have any access to any of that help.
Minority Leader McKean.
Thank you, Mr. Chair. Not only do they not have access to this help, but so few go on to higher education or earning certificates after high school that I speak for you, we feel like we need to be reminded that these are our kids, and through no fault of their own, they end up in this tumultuous world of being a foster kid. And a foster kid often means that it's very difficult to find that next piece. This helps them find that next piece and truly sets people up for excellence and progress throughout their whole lives. We urge an aye vote.
Thank you. Seeing no further discussion, the question before us is the adoption of Senate Bill 8. All those in favor say aye.
Aye.
All opposed say no. Senate Bill 8 is adopted. Minority Leader Escar.
Go ahead.
I'm sorry, Majority Leader Escar.
Go ahead. I have the next bill.
Oh, okay, I'm sorry. Ms. Shebel, please read the title to Senate Bill 11.
Senate Bill 11 by Senators Enzinger and Quorum, also Representatives Catlin and Esgar, concerning the establishment of the America 250 Colorado 150 Commission and in connection therewith making an appropriation.
Thank you. Majority Leader Escar.
Thank you, Mr. Chair. I move Senate Bill 11.
To the bill.
Senate Bill 11 is a bill that will establish the America 250 through the. I'm sorry. I'm going to hand it off for a second.
No, you're good.
Okay, in 2016, Congress approved an act that established both America 250 Commission and Foundation, which is a 501c3. They're charged with coordinating America's 250th birthday and raising money to fund commemorative initiatives in every state. That so happens to line up with our 150th birthday here in Colorado. The Colorado 150 Commission initiative was started by a grassroots stakeholder coalition that prioritizes inclusive programming for all people. And this bill simply helps move that through so we can celebrate America's 250th birthday along with Colorado's 150th birthday at the same time. It's a very patriotic bill. We ask for a yes vote.
Thank you. Representative Catlin.
Thank you, Mr. Chair. It's an honor to serve with you.
Honor to serve with you, sir.
Thank you. Members, this is an opportunity here. As you can tell, I'm in charge of the party caucus. And this is an opportunity for us to get in on celebrating the 250th anniversary and the state's 150th anniversary. To create this commission, it's going to look across the state of Colorado of all people, of all walks of life. This is a chance for us to come together as the United States and the state of Colorado to celebrate something that's incredible, the incredible birth of this nation and the birth of this state. Here it is, folks. If you're interested in a party, this is the one to get in on. It's going to last for years.
Majority Leader Escar.
Thank you, Mr. Chair. And I don't know about you all, but I'm down to have a party with Rep. Catlin.
Yeah. Good bill. Vote yes.
Thank you. Seeing no further discussion, the question before us is adoption of Senate Bill 11. All those in favor say aye. Aye. All opposed say no. Senate Bill 11 is adopted. Majority Leader Escar.
Thank you, Mr. Chair. Let's try it this way. I move to proceed out of order for the immediate consideration of Senate Bill 146.
We will proceed out of order to consider Senate Bill 146 as requested by the Majority Leader. Mr. Shebel, please read the title to Senate Bill 146.
Senate Bill 146 by Senators Enzinger and Heisey, also Representatives Snyder and Catlin, concerning the expansion of the Colorado Housing and Finance Authority's Middle Income Access Program and in connection therewith making an appropriation.
Representative Snyder.
Thank you, Mr. Chair. I move Senate Bill 146, the Transportation and Local Government Report, and the Appropriations Report.
There's no committee report to the bill.
Great.
Representative Snyder. Representative Snyder, go ahead.
Thank you. So this is actually one of the most exciting bills of the year. You know, we have a whole raft of bills that are seeking to address the affordable housing crisis, many working specifically in the area of homeless and lower income folks. This one's a little different. This is the middle income, what they call the missing middle. So this bill targets people making 80 to 120% of AMI. It puts money into a very successful existing CHAFA program. By way of example, the last round of funding they took $14 million of state money and turned that into $140 million worth of building. So we're hoping to have similar results with this bill, and we would ask for your support.
Thank you, Representative Catlin.
Thank you, Mr. Chair. Members, this is a chance for us to help some of the people that are qualified to buy a house in a typical world. But in the world that we live in today, they're left out. We've done a lot of work to help people with low-income housing, help them find shelters, help them find apartments. This is an opportunity for us to take young people, particularly, that are qualified to buy a house in most markets and help them with that by producing inventory that will allow those kind of buyers and those kind of renters to have a place that they can live within their means, which is something that's got to happen in order for this country to get back on its feet and we start getting ourselves together. This is a good bill. Vote yes.
Thank you. Seeing no further discussion, the question before us is the adoption of Senate Bill 146. All those in favor say aye.
Aye.
All opposed say no. Senate Bill 146 is adopted. Mr. Shield, will please read the, I'm sorry, Majority Leader Escar.
Thank you, Mr. Chair. I know you're probably really tired of hearing this. I move House Bill 1390, two bills.
Okay. House Bill 1390 will still be laid over. Two more bills. Ms. Chiba, please read the title to Senate Bill 127.
Senate Bill 127 by Senators Kirkmeyer and Zenzinger, also Representatives Larson and McCluskey, concerning funding for special education services and in connection therewith making an appropriation.
Thank you. Who would like to start? Representative McCluskey.
Thank you, Mr. Chair. It is an honor to serve with you.
Honor to serve with you.
I move Senate Bill 127.
To the bill.
Members, this is a wonderful day. In addition to bringing forward a School Finance Act that provides more funding to our public schools than we've been able to do in years, that buys down the budget stabilization factor to the lowest point it's been in 10 years, we are, with Senate Bill 127, making a significant investment in special education services. I am so pleased that for the first time, we are inching closer to fully funding the demands that our schools are facing with students who have special needs. Right now, those students receive services, but school districts are forced to use their general fund operating dollars to help provide those services. These dollars follow the students. These dollars go through our categoricals and make sure that school districts who have students identified in the different tiers of special education services, that they receive dollars specific to those students. It's a pretty powerful way to direct state resources. With $80 million headed to our schools, I couldn't be more proud and thrilled to be joining Rep. Larson and the entire interim School Finance Committee that met this last year and said, you know what, we need to do more for special education, and this is that work. I am very pleased to be here today and encourage an aye vote.
Thank you. Representative Larson.
Thank you, Mr. Chair, and thank you to my co-prime sponsor. This was a great bill to move out of the Interim School Finance Committee, extremely consequential, an area of passion for all of us involved. Just real quick running through the particulars, we are making essentially an inflation adjustment to our Tier A funding, which you may remember from budget debates past, bumping that up from $1,250 to $750. We are also setting our Tier B funding on a path to be fully funded over the next few years. We couldn't get that all done in one fell swoop because this is expensive, but we've made a massive down payment on it. And then the third component, which is oft overlooked but is important, is we are also doing a study to look at some of the other states and what they do for their tiering for special education services. This is a rapidly evolving field in our understanding of the particulars of what it takes to educate children with specific needs. And looking at what some other states have done recently is a worthwhile endeavor, and this bill also sets us up for that. So with that, I would ask for a yes vote.
Thank you. Any further discussion? Minority Leader McCain.
Well, thank you very much, Mr. Chair. Folks, this is so badly needed. I spent part of my day the other day with some paras, and to hear the kinds of issues that they face with kiddos who are nonverbal, with the amount of time that they need to spend with young boys and girls who definitely need that time and that attention, especially coming after the on-again, off-again school of COVID. This is absolutely essential funding, and I thank the two of you, and I thank the body for passing this. This is a good vote yes. This goes to essential services for kids right now today.
Thank you. Seeing no further discussion, the question before us is the adoption of Senate Bill 127. All those in favor say aye. All opposed say no. Senate Bill 127 is adopted. Mr. Sheba, please read the title to Senate Bill 130.
Senate Bill 130 by Senators Rankin and Hansen, also Representative McCluskey.
Representative McCluskey.
Concerning the authority for state public entities to enter into public-private partnerships for public projects and in connection therewith making an appropriation.
Majority Leader Escar.
Thank you, Mr. Chair. I move to lay over Senate Bill 130. Actually, I asked for a brief recess. Let me figure this out.
Committee be in a brief recess. Committee will come back to order. Majority Leader Escar.
Thank you, Mr. Chair. I move to lay over Senate Bill 130. One bill.
Okay, Senate Bill 130 will be laid over one bill as requested. Majority Leader Escar.
And I move to proceed out of order for the immediate consideration of Senate Bill 148.
Mr. Sheba, please read the title to Senate Bill 148.
Senate Bill 148 by Senators Donovan and Simpson, also Representatives McLaughlin and Catlin, concerning the creation of a grant program to provide a grant to a Colorado land-based tribe to support infrastructure improvements to tribal behavioral health facilities that serve indigenous individuals and in connection therewith making an appropriation.
Thank you. Representative McLaughlin.
Yes, thank you, Mr. Chair. I move Senate Bill 22-148 and no committee reports.
To the bill. Representative McLaughlin.
Thank you. This one came from a committee, an interim committee this year that was giving for mental health and behavioral health issues. And this will give money to the tribes, and they will decide where to put behavioral health center. The Southern Ute tribe had one, and so they might be able to use one and to kind of redo that. But the tribes are going to work together with the communities and come up with not only the rest of the money for this. This is about 25% of what they would need, but it'll also, they will decide where to put it and who to staff it with and make sure that it's tribally sensitive.
Thank you. Representative Catlin.
Thank you, Mr. Chair. This bill is not prescriptive. The tribes will have a choice to renovate an existing building on the Southern Ute tribal land, construct a new facility, or work with adjoining communities to devise the best situation for everyone involved. It lets our sovereign neighbors decide. This is an opportunity for the state of Colorado to reach up to the tribal neighbors that we've got in the state of Colorado and recognize some of the problems that they are experiencing. In their communities, they are suffering as badly as we are, and maybe worse. This is an opportunity for them to take a hold of their destiny and decide what they want to do for their tribes people. And it gives us an opportunity to say, yes, we support you. We're standing there beside you. This is a good bill. Vote yes.
Thank you. Seeing no further discussion, the question before us is the adoption of Senate Bill 148. All those in favor say aye.
Aye.
All opposed say no. Senate Bill 148 is adopted. We're back to 130. Okay. Mr. Sheba, please read the title to House Bill 1390.
House Bill 1390 by Representatives McCluskey and McLaughlin, also Senator Zenzinger, concerning the financing of public schools and in connection therewith making an appropriation.
Representative McLaughlin.
Yes, I move House Bill 22-1390 with the appropriations and education reports, please.
To the Appropriations Committee report. Representative McCluskey.
Thank you, Mr. Chair. In appropriations, we made sure to fund our public schools with more than $8 billion in the School Finance Act, and I ask for an aye vote.
That was a generous donation there. Any further questions on the Appropriations Committee report? Seeing none, the question before us is adoption of the Appropriations Committee report. All those in favor say aye.
Aye.
All opposed say no. Appropriations Committee report is adopted. To the Education Committee report, Representative McCluskey.
Thank you, Mr. Chair. Members, in Education Committee, we did add and clarify a couple of the components that we've included in this year's School Finance Act. As you know, school funding is the focus of this piece of legislation that we pass every single year. And because of some of the challenges, some of our grant programs and other auxiliary services have faced during the pandemic, we did extend either timelines for grant programs or the use of funding for those programs. You will see that in the Education Committee report. Additionally, and I want to lift up our colleagues, Representative Weissman and Representative Bacon, there is a provision in the School Finance Act where we fund both multi-district online students and Ascent students. There was another bill moving through the chambers that focused on that fifth-year concurrent enrollment program, the Ascent program. Because of the conflicts that were recognized between that bill and the School Finance Act, we were able to incorporate the changes that were coming forward from House Bill 1002 into the School Finance Act so that we could incorporate those changes along with the funding that those changes would require. And I certainly hope that Representatives Weissman and Bacon, in their good work on House Bill 1002, will take a moment to offer their voices in incorporating that policy effort into the School Finance Act. Additionally, as we incorporated that program into the School Finance Act, we did catch a couple of small changes that we need to make. And with that, I move L008 to the Education Committee report.
That has been properly moved and now before us to Amendment L008. Representative McCluskey.
Thank you, Mr. Chair. Members, L008 adjusts the timeline. We had to move that once the language was incorporated into the School Finance Act. And we also added language around the pupil enrollment because we currently account for these concurrent enrollment students through the Ascent program. We had to also include their accounting in the reports to the State Board. I ask for an aye vote on L008.
Seeing no further discussion, the question before us is the adoption of Amendment L008 to the Education Committee report. All those in favor say aye.
Aye.
All opposed say no. Amendment L008 is adopted. To the Education Committee report, Representative McCluskey.
I ask for an aye vote.
Any further discussion? Yes. Assistant Minority Leader Geithner.
Thank you, Mr. Chair and members. I move L015 and I ask that it be displayed.
That amendment is now before us to Amendment L015.
Thank you,
Assistant
Mr.
Minority
Chair.
Leader Geithner.
Yeah, thank you, Mr. Chair. Members, we had the opportunity to hear 1390 in committee, and during that process, there was an amendment L004 that was put on, and it had specifically to do with coding as it pertains to homeschool students. There's been some further conversations, and my thanks to the sponsors for the conversation that we've had. And it looks like we may have struck to some sort of an agreement here in L015. But the premise is that it alleviates some of the concerns specifically that the homeschool community had. And that's what we've gotten to here. It still gets to the purpose, I think, in the amendment of L004, but maybe it's a little bit more delicate way of approaching what was looking to be included through that previous amendment that was included in committee.
Thank you. Representative Luck.
Thank you, Mr. Chair. And I, too, just wanted to thank the bill sponsors for considering this amendment and for talking with us. We are trying to balance a number of different stakeholders, and so hopefully this is, for now, a good compromise for all.
Thank you. Representative McCluskey.
Thank you, Mr. Chair, and yes, thank you to our colleagues who brought this concern forward. We had originally included in the School Finance Act a change to how we were coding homeschool students who access school programs or services during the day. And unfortunately, our approach had been just reducing an administrative burden. And so we were trying to clarify in statute how we could do this coding in a simpler way. But now that we have heard other voices, we're certainly opening to revisit how this coding is occurring, and do support this amendment at this time and look forward to ongoing conversations.
Thank you. Seeing no further discussion, the question before us is the adoption of Amendment L015 to the Education Committee report. All those in favor say aye.
Aye.
All opposed say no. Amendment L015 is adopted. Back to the Education Committee report. Representative McCluskey.
I urge an aye vote on the Education Committee report.
Thank you. Seeing no further discussion, the question before us is the adoption of the Education Committee report to House Bill 1390. All those in favor say aye.
Aye.
All opposed say no. Thank you. The Education Committee report is adopted. To the bill. Representative McLaughlin.
Thank you, Mr. Chair. I think the most exciting thing about this bill is that the budget stabilization factor is going to be the lowest it's been since it started. And this means that we're doing our job and we're paying back a debt that we have owed educators for a very long time. So very happy with that.
Thank you. Representative McCluskey.
Thank you, Mr. Chair. In the interest of being perfect, I move L010 to House Bill 1390.
Thank you. That amendment has been properly moved. Is now before us to Amendment L010. Representative McCluskey.
Thank you, Mr. Chair. We had a grammatical error, and we are fixing it. I urge an aye vote.
Go teachers.
Thank you. Seeing no further discussion, the question before us is the adoption of Amendment L010 to House Bill 1390. All those in favor say aye.
Aye.
All opposed say no. The amendment is adopted. To the bill, Representative McCluskey.
Thank you, Mr. Chair. Members, this is, next to the long bill, probably the most exciting bill around financing that we do in this chamber, in this underneath the Gold Dome. And I am so pleased to see this funding going to our public schools this year. All of us should take pride in the investment that we are making today. We exceeded the governor's proposal for what we should be giving to our public schools. I am hopeful that in the next several years we are able to buy down the budget stabilization factor in its entirety, and I look forward to having your partnership in that effort. This bill is about our students receiving the resources they need so that their teachers are earning a living wage, that they receive the professional development they need to be the best in the business, that we're providing an A+ curriculum and all of the other needs that schools and communities face in educating their children. I urge an aye vote on House Bill 1390.
Thank you. Seeing no further discussion, the question before us is the adoption of House Bill 1390. All those in favor say aye.
Aye.
All opposed say no. House Bill 1390 is adopted. Mr. Shebo, please read the title to Senate Bill 130.
Senate Bill 130 by Senators Rankin and Hansen, also Representative McCluskey, concerning the authority for state public entities to enter into public-private partnerships for public projects and in connection therewith making an appropriation.
Representative McCluskey.
Thank you, Mr. Chair. I move Senate Bill 130 and the Appropriations Committee report and the Business Affairs and Labor Committee report.
To the Appropriations Committee report.
Thank you, Mr. Chair. Members, in appropriations, we have put aside $15 million for the public-private partnership collaboration unit, a new effort in the state to try and address some of our capital infrastructure needs, and I urge an aye vote.
Thank you. Seeing no further discussion, the question before us is the adoption of Appropriations Committee report to Senate Bill 130. All those in favor say aye.
Aye.
All opposed say no. The Appropriations report is adopted. To the Business Affairs and Labor report, Representative McCluskey.
Thank you, Mr. Chair. Additionally, we incorporated some of the expenses for this startup into that original $15 million appropriation, and we talked about that in Business Affairs and did change that in the appropriation clause for the bill. I urge an aye vote.
Thank you. Seeing no further discussion, the question before us is the adoption of the Business Affairs and Labor report to Senate Bill 130. All those in favor say aye. All opposed say no. The Business Affairs and Labor report is adopted. To the bill, Representative McCluskey.
Thank you, Mr. Chair. Members, over the next year, we are going to be standing up a P3 collaboration unit, a public-private partnership collaboration unit in the Department of Personnel and Administration. And the goal of this unit is to try and bring partners together to help create those P3 partnerships, those public-private partnerships that will help us address some of our fairly significant capital infrastructure needs. It's a creative approach to trying to drive that seed money, invite new partners to the table. We've recognized opportunities for P3 relationships, particularly in the childcare sector, but also in affordable housing and in other arenas. I do have two changes. One which came from our discussion with those in Business Affairs and Labor, and that was to create a reporting structure within this statute so that there would be feedback to committees of reference as well as the Joint Budget Committee. I move L008 to Senate Bill 130.
Thank you. That is a proper motion, and the amendment is before us to Amendment L008. Representative McCluskey.
Thank you, Mr. Chair. Again, members, there is a definition that we have clarified in the first half of this amendment, and then we've created a reporting structure so that this body and our Senate colleagues have an opportunity to see the results of these P3 partnerships and an opportunity to weigh in if there is a need for further revision to statute. I urge an aye vote on L008.
Thank you. Seeing no further discussion, the question before us is the adoption of Amendment L008 to Senate Bill 130. All those in favor say aye.
Aye.
All opposed say no. Amendment L008 is adopted. To the bill, Representative McCluskey.
Thank you, Mr. Chair. I move L011 to Senate Bill 130.
Thank you. And that amendment is before us to Amendment L011. Representative McCluskey.
Thank you, Mr. Chair. Members, we actually have a unique situation. All of our capital projects go through the Capital Development Committee for review and consideration. We have a unique situation in my district where CDLE, Colorado Department of Labor and Employment, has a property that they are ready to sell, the Workforce Center in Frisco, for affordable housing. But they don't have the authority to do that. Normally that authority for underutilized properties is available to them, but this is an unused property, and so we needed to clarify in statute. This particular transaction will still go through the Capital Development Committee, State Controller's Office, and the Office of the State Architect. I encourage an aye vote.
Thank you. Seeing no further discussion, the question before us is the adoption of Amendment L011 to House Bill 130. All those in favor say aye.
Aye.
All opposed say no. Amendment L011 is adopted. To the bill, Representative McCluskey.
Thank you, Mr. Chair. Members, I think this is a great opportunity to help us ignite some new projects that will specifically help us in addressing some of our capital needs, but also provide very relevant and robust programming in communities, whether it's childcare, affordable housing options, or other unique uses of our public buildings. I encourage an aye vote on Senate Bill 130.
Thank you. Seeing no further discussion, the question before is the adoption of Senate Bill 130. All those in favor say aye. All opposed say no. Senate Bill 130 is adopted. Majority Leader Escar.
Thank you, Mr. Chair. I move to lay over Senate Bill 1 until tomorrow, April 27th.
Senate Bill 1 will be laid over as requested by the Majority Leader. Are we on Senate Bill 158? Okay. Mr. Shebel, please read the title to Senate Bill 158.
Senate Bill 158 by Senator Donovan, also Representatives McCormick and Will, concerning support for species conservation trust fund projects and in connection therewith making an appropriation.
Oh, dear.
See, we got the appropriation to report. Right?
Representative McCormick.
No report?
Okay.
Thank you, Mr. Chair. I move Senate Bill, wait, did we already do that? I move Senate Bill 22-158.
To the bill. Representative McClellan.
Thank you, Mr. Chair. This bill is the Species Conservation Trust Fund that allocates severance tax dollars from the fund to fund research. This is a bill that comes every year to study efforts on threatened and endangered species living within Colorado. And this year, we were able to allocate $6 million out of that fund, which is the largest amount that has been able to be allocated in over 5 years. It is one of the Department of Natural Resources' most important bills every year. Some fun facts about what is done with this particular fund is that it has worked to help the recovery of the black-footed ferret. The entire program was based on the discovery of just 8 individual animals in Wyoming after they were thought to be extinct. And currently, there are now about 600 ferrets split between captive breeding facilities and wild relocation sites. So, and this whole program, we need to get up to about 3,000 ferrets to be considered a successfully recovered species. I urge an aye vote.
Thank you. Representative Will.
Thank you, Mr. Chair. So the gist of this whole bill, I can tell you from working in this business for many, many years, the real benefit of this is keeping species from getting listed. Once you get a listed species, it invokes all kinds of things you can't do anymore. So, and this involves, Gunnison sage grouse, greater sage grouse, lots of the native fish species, and sharp-tailed grouse, lesser prairie chickens. My co-prime already mentioned the black-footed ferrets, but boreal toads and lynx and bats. All that, and also it helps with the recovery on the Platte River recovery, the Upper Colorado River, and the Rio Grande down there. So this is in conjunction with CWCB for this money, and it's a great program, and it through severance tax funding. Ask for an aye vote. It's a good bill.
I'm going to say something else.
Thank you. Representative McCormick.
Thank you, Mr. Chair. I just wanted to add some other really interesting fun facts that this money this year will be used to continue the investigation to minimize effects of gill lice parasitism on Colorado cutthroat trout species. I think that's really important, as well as to design a fish passage structure for diversion on Fountain Creek to address barriers to fish movement upstream. Just thought y'all would like to know that. I urge an aye vote.
If you want to know more about gill lice, come talk to me.
Thank you.
Uh-oh.
Representative Catlin.
Thank you, Mr. Chair.
Members, you know, we're getting to the end of the day, but one of the things I wanted to remind you is that one of the most successful programs in the state of Colorado is the recovery of endangered species on the Colorado River. There are dollars in this program specifically for that. You need to understand that Colorado is the only state in the union that has a recovery program that has specific numbers of population in the Colorado River to consider them recovered. That is a major step forward for the state of Colorado. This bill, as it stands, a good bill, vote yes. But I want you to remember that we are doing things in the state of Colorado that other states are not. We've done a very good job with those endangered species on the Colorado River. Some of those that you would not expect are now being in the process of being removed from the endangered species list, and that's a success. That's a success because of this kind of funding. That's a success because the state of Colorado cares about removing animals from that list rather than continue to add them to it. Good bill, vote yes.
Thank you. Representative Pico.
Thank you, Mr. Chair. Something seems fishy about this bill, but I'd cast Sonetta and vote yes.
Thank you. That'll be another $5 fine. Thank you. Representative Hotorf.
Thank you, Mr. Chair, and I don't think $5 is enough, so I think you should up the ante.
I'll consider that. Thank you.
So I want to mention something to my colleagues in the chamber about what farmers and ranchers do and people that live in the country along these river basins and watersheds. And here's what you need to know. The habitat for all this wildlife is in our backyard. You see, on the ranch that I run, along with our cattle, our horses, our dogs, and our cats, and other critters that live on our ranch, we have a lot of wildlife. We have prairie chickens. We have antelope. We have a lot of wildlife, and we provide that habitat. But it has to live with us, and we have to live with it. And this type of legislation helps build some of that harmony. We have wild geese, we have Canadian geese, we have snow geese. We have things that come to our place as they transition through in the spring and then out in the fall again that stop by as a waypoint. And I could have 1,000, 2,000, 3,000 wild geese on our wheat fields grazing free of charge. Now, does that hurt our wheat crop? Maybe it dings it a little bit, but it'll grow back. Doesn't kill it. They don't rip it out by the roots. So that's what rural Colorado does for your wildlife and your native species, and also with respect to endangered species. I'm a big supporter of this bill. I think we have to continue to invest and create this harmony that this type of legislation builds to protect and conserve those species that we're all trying to provide habitat for.
Thank you. Seeing no further discussion, the question before us is the adoption of Senate Bill 158. All those in favor say aye. Aye. All opposed say no. Senate Bill 158 is adopted. Mr. Sheba, please read the title to Senate Bill 174.
Senate Bill 174 by Senator Buckner, also Representative Kennedy, concerning the criteria to be considered in a sunset review hearing.
Thank you. Representative Kennedy, thanks for joining us.
My pleasure. Thank you, Mr. Chair. I move Senate Bill 174.
To the bill.
Thank you, Mr. Chair. Members, this is a fairly straightforward reorganization of the required criteria that DORA looks through when they're doing a sunset review. I ask for an aye vote.
Thank you. Seeing no further discussion, the question before us is the adoption of Senate Bill 174. All those in favor say aye. Aye. All opposed say no. Senate Bill 174 is adopted. Majority Leader Escar.
Mr. Chair, I move the committee rise and report.
Thank you. Seeing no further discussion, the committee will rise and report.
House will come to order. Mr. Shi will please read the report of the Committee of the Whole.
Mr. Speaker, your Committee of the Whole begs leave to report as under consideration the following touch bills being the second read thereof and making the following recommendations thereon. House Bill 1012 as amended, 1077 as amended, 1242 as amended, 1254 as amended, 1260 as amended, 1348 as amended, 1359 as amended, 1361 as amended, 1365 as amended, 1390 as amended. Passed on second reading and order engrossed and placed on the calendar for third reading and final passage. Senate Bill 8 as amended, Senate Bill 11, Senate Bill 172, Senate Bill 130 as amended, Senate Bill 146, Senate Bill 148, Senate Bill 158, Senate Bill 162 as amended, Senate Bill 169, 174, 184, 194 passed on second reading in order to revise and place on the calendar for third reading and final passage. Senate Bills 1 and 2 laid over until April 27, 2022.
Representative Exum. Members, you have heard the motion. There are no amendments at the desk. The question before us is the adoption of the report of the Committee of the Whole. Mr. Shi will please open the machine and members please proceed to vote. For those participating online, Representative Kennedy, how do you vote? Representative Gray, how do you vote?
Yes.
Representative Gray votes yes. Representative Kennedy, how do you vote?
Yes.
Representative Kennedy votes yes. These are the best votes to build up the party kitty. The ones where people didn't really know when we were going to rise and report, you know? I'm not sure. I see Representative Molka. Why not vote? Representative Byrd gets a $3 fine. $3. Okay, all right. That's okay. Maybe just vote. All right, we will mark Madam Speaker Pro Tem and Representative A. Valdez excused with a $12.50 fine for each of them. Please close the machine. With 39 ayes, 22 noes, 4 excused, report of the Committee of the Whole is adopted. Majority Leader Escar.
Thank you, Mr. Speaker. I move to lay over the balance of the calendar until tomorrow, April 27th.
Seeing no objection, the balance of the calendar will be laid over until Wednesday, April 27th. Announcements and introductions. Representative Weissman.
Thank you, Mr. Speaker. Judiciary members, as you can see, we've been at it a while on the floor, so we will start at 2:30 in 107, and we will follow the same calendar, but 2:30 downstairs. Take a few minutes, get some food. If you haven't already done that, we will start promptly. Thank you.
Representative Herod.
Thank you, Mr. Speakers. Members, we will hear Bills and Appropriations Committee tomorrow morning. We will meet at 8:15 tomorrow morning to hear many bills, and we'll see you there. Jokes now are discretionary, but if you have a joke and you would like to bring it, please do. Winner so far has been Representative Catlin, who came prepared. Representative Catlin, would you like to tell your joke? He's always ready to tell a good joke. This one's a quick one, you guys, so everyone listen up.
Representative Catlin.
Thank you, Mr. Speaker. It's an honor to serve with you.
Honor to serve with you too, Representative
You know,
Catlin.
I'm worried about the calendar. Its days are numbered.
Ba-dum-bum-bum.
Representative Roberts.
Thank you, Mr. Speaker. Not sure I want to follow that, but
Business Affairs and Labor Committee, we are not meeting today. We are meeting tomorrow, planned right now for 1:30, but we did have a change in our calendar, so I needed to announce that. We are adding House Bill 1058 to the end of the calendar. We're also going to be hearing the sunset hearing for the Division of Gaming tomorrow afternoon, in addition to what's on the calendar already.
Representative Michelson-Jeanette.
Thank you, Mr. Speaker. Public and Behavioral Health and Human Services, we will be starting at 2:30 sharp. Be there or be square.
Representative Exum.
Thank you, Mr. Speaker. House Transportation and Local Government, we will start at 2:30 over in LSBA. See you there.
Great. One Committee of Reference report. Mr. Schiebel.
Committee on State, Civic, Military, and Veterans Affairs, after consideration on the merits of committee recommends the following: Senate Bill 150 be amended as followed, and also amended be referred to the Committee on Appropriations with favorable recommendation.
Introduction of bills.
House Bill 1403 by Representative Juna concerning a 3-month delay in the implementation of health care billing requirements for indigent patients established in House Bill 211198.
House Bill 1403 will be assigned to the Committee on Health and Insurance. Introduction of resolution.
House Joint Resolution 1024 by Representatives Esgar and Duran, also Senators Gonzalez and Winter, concerning Sexual Assault Awareness Month and in connection therewith, recognizing April as Sexual Assault Awareness Month and designating April 27, 2022 as Colorado Denim Day.
House Joint Resolution 1004 will be laid over one day per the rules. Majority Leader Esgar. I'm not sure I needed a gavel there. Majority Leader Esgar.
Thank you, Mr. Speaker. I move the House stand in recess until later today.
Seeing no objection, the House will stand in recess till later today.